engagement will build a respect for human dignity, a respect for human rights, and an ability to build our societies to be the success that we know it can be if it is managed and done correctly. To our hosts, the Center for Human Rights, the Department of Public Law, Monash University, Future Africa, thank you also for creating the space that we are using to discuss these important issues today and tomorrow. I think just a word about the SACHI chair that we have in the faculty and that is now hosted in the Department of Public Law, but in cooperation with the Center for Human Rights. And the whole thought of the SACHI chair was designed around the thought that there should be some investigation into how international norms reshape domestic constitutional realities and how regional domestic rights bodies, such as the various African bodies, regularly issue groundbreaking rulings, sometimes without even necessarily, in each particular instance, realizing or understanding the impact or the broader impact that their rulings might have. So it is against that backdrop that the possibility of also transforming lives in Africa and transforming societies is investigated. And that is the purpose of this chair, is to actually keep this study and keep the scholarship in that field going. Today and tomorrow, you will deliberate on a number of landmark rulings and decisions. Firstly, you will define which are those landmark rulings and why are they landmark rulings. What makes them stand out from other decisions or indicators that have been given. You will consider the innovation and the contestation that takes place in those fora. The challenge that it holds to long-standing beliefs and practices and customs, and also the enlightenment and the transformative energy that we can gain from these kinds of rulings and judgments. And I challenge you to engage in a very rigorous and analytical critique and debate over the next 2 days when you discuss and consider these landmark rulings. Subject these judgments to deep academic scrutiny to make sure that we enhance the clarity, the consistency, and the persuasive power of these rulings and also of future rulings by these human rights bodies. Rewrite, and I see there are sessions that state rewrite. So rewrite these rulings and the jurisprudence that emanate from that in a way that will make sure that we explore alternative and more progressive legal reasoning, and that we can take the academic debate, but also the human rights debate in Africa forward and take it to the next step and the next level. And then make sure also, you know, at the University of Pretoria, we've recently adopted the Thrive UP 2038 strategy, which sets the strategy for the university towards the year 2038, when the university will be 130 years old. And one of the key pillars of that strategy is research and teaching with impact. And so make sure also today and tomorrow that what you are deliberating or what you are talking about will have impact by taking all of this back to civil society, to break down the barriers that exist and the resistance to change in many ways. And that we take the message out there to our various societies and get the message across that we need to ensure that there is a deep-rooted respect for human dignity, human rights, and the value and quality of human life on the African continent. And then mobilize and work together in a strategic way that we can have that impact, and that 20 years from now, people might look back at this event and say, something happened there that made a difference. Maybe just in one person's life, but if you've made a difference in one person's life, you will make a difference in more lives. So let this conference be more than just an intellectual exercise. Let it be a catalyst for systemic change. The rulings that you will discuss here represent promises that are made to vulnerable people across the African continent. From ranging from children seeking safety from harmful practices to communities defending their socio-economic rights and insisting on the recognition of their rights. The collective task here is to ensure that rights move from paper and from theoretical application to that deep-rooted impact that we look for in our Thrive 2038 strategy. So as you embarked on today and tomorrow's events, I'd like to leave you with the words of Dr. Kwame Nkrumah, the first president of the independent Ghana, where he said, "It is clear that we must find an African solution to our problems, and this can only be found in African unity. Divided, we are weak. United, Africa could become one of the greatest forces for good in this world." And let us strive to follow those profound words and see how we can unite and stand together to get the human rights message across, to analyze these landmark judgments and provide a message, not only to our current generation, but to future generations, that we must expand the spaces of freedom, not only academic freedom, but freedom across the continent, so that we can respect the dignity, the well-being and the status of the people in the African continent. So my best wishes accompany you. I would have liked to attend many of these sessions. Fortunately, my schedule does not allow, but I wish you all the best in your deliberations, and be robust and ask the difficult questions.
Thank you very much, Professor Cornelius, for those inspirational words, and also not only for being here, but for the support, the solid base that the faculty gives to the work that we are doing. So allow me then to just add a few words, and whenever you need to be excused, we understand that you have to go. So thank you very much for spending some time with us. Welcome once again also from my side. I think we have in the room, first of all, I think Gina has been mentioned. As you realize, she's an alumna of the Faculty of Law, but she also worked with the Center for Human Rights in the late 1990s on socioeconomic rights and other projects. So it's really wonderful to reconnect and to do this together with Monash, which is a very reputable institution. So thank you, Gina, for your inspiration and your assistance in getting this process forward. I also think that it's not common to do so, but I have to just pause already at the beginning to just thank two people in particular. That is Tanet. Tanet probably is running around and doing things, but you have all communicated with her, just to mention her name, and also Pumeza, who are the pillars in the chair and has been so important in getting us where we are today. I also want to welcome you perhaps in categories. We would have liked to go around the table and everyone introduce themselves, but that's just not possible in time. We have, in the first place, a number of people who will be chairing sessions. Thank you very much to our chairs and welcome. We have our presenters who've come from far and wide, as far as Canada or the United States. And we really appreciate you taking the trouble and being here, and we look forward to your interventions. We have a category of participants who are students, master's students, doctoral students here at the University of Pretoria. Welcome. And then a broader category of people who are academics and activists and interested individuals, both in person and certainly everyone online as well. You're most welcome. We make an agreement that when speakers come, they will introduce themselves for 30 seconds, just so that we know how the person introduces themselves. And we invite you, members of the audience, to be as participatory as you can, and then to also introduce yourselves when you take the floor. So everyone should be introduced in due course, right? So we will have 7 sessions. Each of the sessions will have a number of speakers. The speakers will have maximum of 15 minutes, and then the floor will be open thereafter for your questions and our discussion. You'll see that there is, after these 7 sessions, there is a session like a round table at the end where we try to pool and see what do we take, as Professor Cornelius said, how do we take this forward? What are the insights that collectively we have drawn from our being together here? So please be alive and participate as much as you can. Now, I think it is a weighty and important moment in the world for many reasons, but one of the reasons is one of maybe more of a positive perspective. We always talk about the three major regional human rights systems, and when we say that Africa is the youngest, it's least developed, but this is a moment where we celebrate a certain level of maturity, I think is fair to say, that the African system has reached. Why can we say that? Because as we know, this year, 1986, and now 40 years ago, is when the African Charter on Human and People's Rights, which is the foundation of the system, has entered into force. So it is 40 years that the system, in essence, has been there in terms of the Charter being enforced. It is then also, well, just 39 years since the Commission has been functional and has been working. It will celebrate its 40 years of existence next year. The court, as we know, this year is celebrating or commemorating 20 years since it has opened its doors, right? Since it has started to function effectively. And that is also a significant moment. If we keep to that, we look at the committee, the African Committee on the Rights and Welfare of the Child, and it was officially established in the year 2001. In other words, that's 25 years since the committee has been around. So I think it is, in one way, a moment of stock taking. What we try to do at this conference is to look at those three bodies and to take stock of what it is that they have produced in terms of one of the major parts of their mandates, which is adjudicating cases and creating a voice for also a discourse, a discursive intervention in the context of global discourses on human rights that we should be identified as African. So these are some of the questions that I think, will pursue. We will try to scrutinize in a way what those judgments are, but we will look at it in a rigorously academic way, we hope, critically, but also constructively. As the Dean mentioned, we are also not doing this in a vacuum. We're doing this against the background of a world in which human rights are under threat. Sexual reproductive rights in particular, multilateralism, the idea that states come together and work out common standards, even that is being pushed back and eroded by kind of insular nationalisms that are manifesting themselves also, sadly in South Africa in some ways. So we will try to interrogate these judgments also from the point of view of how they position themselves. What do these institutions of the African Union have to say to the world in which we find ourselves, where these threats and challenges are ever pervasive in respect of human rights? And we chose the two terms, landmarks and rewriting, to be the prism through which we look at these judgments, these adjudicative functions performed by the African Union bodies. Now, landmark, I was intrigued to just go back to the word and look at how it came about. In 13th century Middle English, the word was first used, as I'm sure many of you have now realized, to denote property. It's when people were settling themselves, they had to show what is the extent of their property, and they had perhaps a landmarks like a stone or a big tree, and therefore it has this very static, kind of almost proclamatory meaning, a landmark. And that is part of what we will do. We'll celebrate, we'll look at the landmarks from the point of view of achievements of the system, of clear articulations of rights and issues. But landmark has another sense, and that is the landmark for the voyager, the one is en route, not the one who is settled. And that is when you are traveling, you are guided by landmarks. You are guided by the big stone or by the tree that tells you how to pursue your journey. And I think we'll also look at the judgments from that point of view, as looking at them as incomplete, as part of a voyage, as part of a process that we will look at critically, and look at how these judgments can further be evolved and are part of an evolving system of further looking at the role of the African Union human rights bodies. I think that each of us who speak to the landmarks will have their own understanding of landmark as a word, as a concept, and we look further to clarifying and elucidating those. So I wish us all a wonderful conference, a conference that hopefully will bring all our minds together, focus them on the African Union human rights bodies, reflect, take stock, but also ask the questions about how can this have been done better and differently, and how do we go forward in our academic critique and in our engagement with these human rights systems. So just one word in conclusion about where this would probably go after the event. We just want to highlight that the landmark decision papers, presentations, we hope many of them will find their way to the African Human Rights Yearbook, which is a publication that is again done in the name of the three bodies, as you know, the African Court, the Commission, and the Committee on the Rights of the Child. There's an annual yearbook that brings together discussions around aspects of these bodies, and we certainly would like to see many of your work going into that publication. And the part on rewriting judgments, very exciting, more critical part of the conference. We hope to see that going into a dedicated, maybe collection of essays, a publication that will be published as a self-standing output in its own right. So once again, most welcome. We really appreciate everyone's presence. We look forward to your contributions. And let me hand over to the co-organizer, Dr. Becker, for her few introductory remarks as well. Thank you so much.
Thank you so much. It's my pleasure to welcome you to this two-day conference on behalf of the Faculty of Law at Monash University in Australia, which is situated on the lands, the unceded lands of the peoples of the Kulin Nation. I pay my respect to their elders, past, present, and future, and acknowledge the deep and enduring connections that First Nations peoples have in Australia to land, to waters, to community and culture, connections that have been sustained for tens of thousands of years. So Prof. Viljoen has already spoken to the landmark judgments aspect of this particular conference. I'm just going to make a few remarks in relation to the rewriting judgments component of this conference. The practice of rewriting judicial decisions is pretty well established globally. Some of you may already be familiar with the feminist judgments or critical judgments projects. These projects share a single insight, and that is that legal outcomes are not inevitable. Judges make choices, and different choices by differently positioned decision makers drawing on different intellectual traditions can and do produce very different results. So we're applying this insight to the jurisprudence of the African Court, the African Commission, and the African Committee on the Rights and Welfare of the Child. These are all African institutions. Yet, if you read their decisions, the interpretive frameworks that underpin these decisions are often deeply Eurocentric. African domestic jurisprudence, African scholarship, and indigenous knowledge systems remain largely peripheral. So the rewriting judgment strand of this conference asks what these decisions might have looked like had the reasoning drawn more consciously on African intellectual traditions, on Ubuntu, on Afrofeminism, post-colonial theory, African communitarianism, and on the lived realities of the communities whose rights are at stake. This is, at its core, a project of decolonization. It's not a dismissal of the original decisions. It's an opening of a space to imagine alternatives, to ask what has been left out, and to consider what a jurisprudence that is genuinely and self-consciously African might look like. So I invite you to engage with what follows over the course of the next 2 days, critically, generously, and imaginatively. Thank you.
Well, thank you very much, Gina. That was, I think, also very clearly articulated, the aspiration, and I think that is also a challenge for us to see to what extent we can collectively meet that challenge. So we are not too far off and behind our program. That's a good thing. We immediately call our first panel to the front. We have the chair, Dr. Professor Tresor Macunia, and the other panelists. We have Dr. Marc Etienne online. I think we've seen you there. So thanks for joining us also online. And then Angela here, I think, and the two Michaels. Yeah, it's Angela and the two Michaels. Michael Adene? Yes, you're coming, right? Okay. So as we indicated, we asked that all presenters try to observe the 15-minute maximum period, just so that we have more time for discussion and engagement. We will also then have some people using PowerPoints and others not. But over to the first chair, Dr. Macunia. Thank you.
Thank you so much, Prof. I think we won't take too much time to introduce the panelists because they will introduce themselves. So the landmark aspect of this conference has been grouped into, I think all the presentations have been grouped into 5 sessions. This first session takes the aspect of landmark as innovation. So all the 4 presentations will, give you the innovations that come out of decisions from the African Commission, from the African Court. So the first presenter is Dr. Michael Adeni. You have 15 minutes, but if you can finish in 15 minutes, that will be still fine.
Good morning, everyone. So my name is Michael Adani, the second Michael. I am a lecturer at the University of Energy and Natural Resources in Sunyani, Ghana. Mostly when we talk about Ghana, we talk about Accra and Kumasi. I'm not from any of them. So this morning, my presentation will focus. Is it being projected? So my presentation focuses on the CERAC versus Nigeria case. So my presentation is on socioeconomic rights and the tripartite obligations emanating from the CERAC case and its implications on climate justice. And I want to argue for why the CERAC versus Nigeria case remains the African Commission's most generative judgment. A lot of us know about the CERAC versus Nigeria case, especially those of us working in the environmental human rights space. So about 25 years ago, a local NGO and an international NGO, that's Nigerian NGO and a US-based NGO, to the government of Nigeria to court over some oil spills in the Ogoni area in Nigeria. And the commission's the commission's most ambitious engagement with socio-economic rights and environmental rights, as well as environmental human rights in Africa. And it has become one of the most consequential decisions that the commission has decided in the area of climate change and environmental human rights. So I want to explain or discuss 3 innovations from this case. But before then, a brief overview of the case. So the Ogonis are indigenous people in Nigeria. It is estimated that there are about 500,000 people. The question of indigeneity is something that is still being debated among practitioners and academics, but we believe that still we have indigenous people in Africa, and these are one of them. And the activities of Shell Nigeria and the Nigerian government in the Ogoni community led to some gas flaring and oil spillage that contributed to environmental destruction or land degradation and polluting of river bodies that directly affected the health, the environmental health, and even economic activities of these indigenous people. Interestingly, gas flaring still happens in Nigeria and even in Ghana in our oil communities. In November 1995, the key activists and the people who were advocating for the government to intervene were killed. They were executed under the sponsorship of the Nigerian government. And these are the facts of the case. The Social and Economic Rights Center, a Nigerian NGO, and the Center for Economic and Social Rights, a US-based NGO, filed a complaint before the African Commission. And they alleged that certain charter rights had been violated by the Nigerian government. And this included Article 2, the right to not be discriminated, and Article 4, right to life and integrity of the person, Article 14, right to property, and Article 16, right to health, Article 18, protection of the family, and Article 21, the free disposal of natural resources, as well as sovereignty over natural resources. And importantly, Article 24, which talks about right to generally satisfactory environment favorable to development. Nigeria failed to respond to the Commission's repeated request for information. In October 2001, the Commission established that these rights had been violated by the Nigerian government. And this decision remains one of the most innovative decisions, not only even in environmental, human rights, and climate justice space, but in relation to other social and economic rights. And in the next few slides, I'm going to take you through the innovations. The first innovation is that the Commission expanded the right to health under Article 16. Usually when we talk about right to health, we focus on provision of healthcare infrastructure, training, health professionals, and the rest. But the Commission creatively connected the right to health also to include the state preventing the private sector entities from causing environmental degradation, polluting river bodies, or causing atmospheric pollution that have direct implications for people's enjoyment of the right to health. And the Commission's interpretation also underscored that the right to health imposed obligation on states not only to provide health services, but to protect people from environmental harms that impair their capacity to maintain their health. And this created a directly applicable legal entitlement rather than an aspirational goal. As most constitutions in Africa, including Ghana, the right to health is seen as an aspirational goal and something that is not justiciable. But this addresses such such issues. And the second innovation is that Commission's decision interpreted the right to satisfactory environment under Article 24 to include both environmental human rights and environmental rights. So when we talk about environmental human rights, it includes what this article purports to guarantee. That is a right to clean, safe, and healthy environment. But when we talk about environmental right, then we are talking about the right to access environmental information, the right to participate in environmental decision-making, and the right to also go to court to seek for justice when your environmental rights or the environmental human rights are violated. So Article 24 talks about the fact that all Africans or all peoples have the right to general satisfactory environment that is favorable to their development. The Commission's interpretation underscored that this include the right to prevent environmental destruction, either from the government or private entities. And also it established access to information about environmental conditions, which makes it a duty for the state to provide sufficient information about impending undertakings or projects that has potential to violate, to undermine or degrade the environment. And it also included community participation in decisions that affect the environment. And lastly, it consolidated the practice of environmental impact assessment. Mostly states go after private entities when they are about to implement certain projects that relate to the environment. But when the state is involved, they bypass it. My government is also culpable. Now we have a project known as Big Push. It's a mega infrastructure project, but there is no environmental impact assessment that has been undertaken or strategic environmental assessment. So when the state is involved, they usually bypass it. But the Commission's decision says that that can lead to violation of human rights. And the third one is that the committee implied that right to housing, which is not directly guaranteed in the African Charter, and the right to food, they have also been violated, because the right to housing, even though the Charter does not recognize it, according to the wisdom of the judges, they argued that these rights can be violated because without housing, right to property and right to even family cannot be enjoyed by people. And the right to food. Food, all of us require food to enjoy our maximum health. So even though the Charter does not directly guarantee the right to food, the committee's decision implied that right to food has bearing on right to health. And therefore, the government's lack of intervention in ensuring that water bodies, farmlands, and even forest resources are not protected led to the violation of the right to food. So this is the third innovation, and these are very important in the time that we are in because of climate change. Because of climate change and the general push for development. All across Africa, governments want to expand infrastructure while they are dealing with multiple crises of climate change, biodiversity loss, and even wars. Wars within countries and among countries. All these undermine economic, social, and cultural rights that I believe that these innovations can be applied in addressing Okay. So in terms of obligations, the decision underscored 3 key obligations that states and private entities are supposed to consider in their various undertakings. And in relation to the state especially, it talks or it establishes the obligation to respect. That is, state must not themselves engage in, authorize or facilitate environmental destruction that infringes the Charter's rights. And the obligation to protect, that is, states are to take measures to prevent private actors including corporations, from violating rights. And this in particular is very important, especially because of the rush for critical minerals. All across Africa, especially in Ghana, DRC, Nigeria, Angola, Mozambique, Chinese corporations are chasing critical energy minerals, including oil itself. And they do this in partnership with the local authorities and government. And as I already established, when government are involved, they bypass statutory obligations, including environmental impact assessment. And the last one is the obligation to fulfill. That is, states are to take positive steps to realize rights over time, even though certain principles are applicable here. But I believe that if we interrogate this, we'll be able to hold our government accountable. Because of time, I'll not be able to go through this. But how is this relevant for climate change? One, I've argued in one of my papers that even this case is also or falls within climate litigation. Why? Because the oil extraction, fossil fuel, is what is causing climate change. And because of the fears of stranded assets, where state and private entities have invested billions of dollars into oil extraction infrastructure, there's the fear that if we transition from fossil fuel, the asset becomes stranded. So now, countries including Ghana, Nigeria, Angola, and others want to drill all their oil before we transition to net zero. Without putting in place necessary safeguard, this is going to lead to similar occurrences because states will want to extract their oil at all costs. And climate displacement and migration is also similar to what happened in Nigeria. Because of oil expansion, because of the fear of stranded assets, countries and government are going to push indigenous people, vulnerable people, marginalized people from oil fields so that they can expand their oil infrastructure. And also issues of adaptation failure and loss and damage claims will require these kind of innovations in order to achieve favorable judgment in domestic and regional courts. Thank you very much.
For a 3-month period, she was sexually exploited and raped by approximately 200 men. She was forced into sexual acts that involved physical bondage and exercise of dominance. She had her hair pulled. She was beaten. She was kicked. She was slapped. She was punched. She was forced to physically fight other women. She was burnt with cigarettes. She was forcibly injected with and drugged with unknown substances. And as a result, she would lose consciousness for hours. This is a quote from the Judgement J versus Namibia from the African Commission, and it's at the heart of what I will discuss today. So good morning, everybody. As introduced, my name is Angela Mulukuti. I'm a Zimbabwean human rights lawyer, and I've been litigating human rights violations domestically, internationally, and regionally for 17 years. And I'm very happy to be with you all today. So thank you very much to the organizers for bringing us together. And in the context of this case, Jay versus Namibia, I'm looking at intersectionality and state accountability for human trafficking. I will discuss 3 factors that make this judgment novel, in my view. The first one is there is a dearth of women's rights cases before the Commission, and there are even fewer cases that deal with human trafficking. This case is special. Secondly, this case displays intersectionality, which is an underutilized and critical tool if we're to dispense meaningful survivor-centered justice. And thirdly, this case builds on the foundation of using substantive equality as opposed to formal equality as a test. So before I get into all of that, let's start with the facts. Who is Jay? Jay is Joan Musenya, a Kenyan woman who was trafficked to Namibia from Kenya for purposes of sexual exploitation in 2017. The relevant parts of the UN definition of trafficking say, and it's up here, the recruitment, transportation, transfer, harboring, receipt of persons by means of threat or use of force or other forms of coercion, abduction, fraud, deception, for the purposes of exploitation. And exploitation shall include, at a minimum, the exploitation of prostitution of others or other forms of sexual exploitation. This is exactly what happened to Joan. So Joan saw an advert for a job online, and she applied, hoping to make use of her Bachelor of Science degree. She was successful and told she'd have to move from Kenya to Namibia to take the role. She was contacted by recruiters in Kenya who organized all her travel, and she traveled by bus from Kenya to Namibia. Upon her arrival in Namibia, her passport was taken from her, and she was taken to a house with other women. It was there that her 3 months of torture and sexual exploitation began. As mentioned, she was raped by over 200 men. Joan managed to escape, but unfortunately, that's not where her troubles ended. She sought assistance from the Namibian police, but instead she was interrogated, she was threatened, she was detained for weeks, and she was accused of being an illegal immigrant. She was also denied access to the Kenyan consulate. In fact, genuine investigations in her matter only began when she filed this case with the Commission several years later. The Namibian police did not properly investigate, and despite naming the perpetrators, nobody was prosecuted. So to cut a much longer and very sad story short, it was only when her case reached the media in Namibia that she was released and allowed to leave the country. And with the assistance of civil society organizations, namely the Initiative for Strategic Litigation in Africa, ISLA, and Kenya Legal and Ethical Issues Network, CLINE, Joan was able to file a complaint at the African Commission in 2019. So her position was that Namibia had violated Articles 2, 4, 5, and 18.3 of the African Charter and Articles 2 and 4 of the Maputo Protocol. Briefly, as you will all know, the African Charter, Article 2, we're talking about the enjoyment of freedoms under the Charter, regardless of your race, your nationality, your gender, etc. Article 4, we're talking about respect for life. Article 5, we're affirming human dignity and prohibition of torture. And Article 18.3, we are looking at the elimination of discrimination against women. And same for the Maputo Protocol, Article 2, elimination of discrimination against women, and Article 4, right to life and security of the person. Joan was also looking for Namibia to be obliged to prevent trafficking, to investigate and prosecute her traffickers, in addition to seeking these violations of the relevant legislation. And of course, she was seeking financial compensation. So that's Joan's side of the argument. Namibia, of course, defended themselves. And in the interest of time, I won't go into the details, but they averred that the necessary legislation was in place, the necessary investigations had been done, and that the case was inadmissible before the Commission. Namibia was unsuccessful. The Commission found that Namibia had indeed violated the African Charter and the Maputo Protocol. They found that Namibia should expeditiously investigate. They said that Namibia's courts should hear the claim for compensation and that the necessary legislation should be adopted, including on trafficking of persons, as well as GBV. And they also, of course, asked that Namibia report on steps taken in light of this judgment. So the order is important, but that's actually not what I think makes this judgment novel. The 3 things I mentioned in the beginning are the ones we're going to focus on. So the three factors. The first one is, as I mentioned, there are very few women's rights cases before the commission and even fewer cases that deal with human trafficking. In fact, in August 2024, the Commission developed a joint analytical study to assess the challenges contributing to the lack of litigation of women's rights cases before the African human rights mechanisms. And as far as I'm aware, and I'd be happy if anyone in the room has more updated information, the study hasn't been released yet, but I hope that it'll shed light on, thank you, somebody's nodding here. I hope that it'll shed light on why we don't have enough women's rights cases before these bodies. As far as trafficking is concerned, this is particularly disturbing because we know that trafficking is rampant in Africa. How are there so few cases that are tried domestically and, of course, at the regional mechanisms we're discussing? According to countering trafficking data, 68% of registered trafficking victims are women, and sexual exploitation constitutes 40% of all these cases. It's a crime that needs additional effort as far as prevention is concerned, protection, and of course, accountability for the victims. And this case, J versus Namibia, will go a long way towards creating a deterrent framework for trafficking. Because we know women are not just trafficked within Africa, but as you can see from this map, outside as well. You can see the flow of traffickers from East Africa to Southern Africa. It's a wide-scale problem. So that's the first thing that makes this novel. We have a case finally that tackles trafficking of women in Africa. The second novel factor is intersectionality. Now, many of you will know that intersectionality is a term that was coined by Kimberly Crenshaw in 1989, and it was designed to provide a multidimensional framework for anti-discrimination law in the US. Specifically, the idea was to acknowledge that the discrimination of Black women in America was multidimensional. It happened on lines of their race, their sex, and of course, their class identities. In short, Kimberly Crenshaw highlighted the need to account for multiple grounds of identity when we consider how the social world is constructed. So take me, for example. I'm Zimbabwean, I'm Black, I'm female, I'm African, I'm from the global majority. And these factors are constantly in conversation with each other. They change how I'm perceived, where I have privilege, where I'm denied privilege, where I'm given access and where I'm not given access. Patty Sellers, who's an international criminal law expert, says that, and I quote, intersectionality is primarily an analysis that concerns vulnerabilities of survivors and victims, but these vulnerabilities manifest as identities. So why is this important? When we use an intersectional analysis, we get to fully understand victimhood in its entirety. We learn how to prevent further harm, we build a progressive body of practice, and also we provide appropriate remedies because we understand the totality of the victim or survivor. So let's look at Joan very quickly and do an intersectional analysis there, using a victim-centered approach. We look at Joan's gender. That's part of the reason why she was trafficked for sexual exploitation. She's a woman. We look at her race. Perhaps that was a factor. We don't have enough on the facts. Look at her age. Women of a specific age are most likely to be trafficked if they're young or below the age of 40. Look at her nationality. She was a foreign national, which meant exploiting her in Namibia was easier because she didn't have a network, she didn't know people, she didn't know the laws. So her nationality was key in her exploitation. Look at her economic status. Joan was seeking employment. That's how she ended up in this situation. She was applying for a job. Disability, we're not sure. We don't have enough facts. Her literacy levels. This was an online advert. So Joan had to be a person who could read and a person who had access to the internet. So all of these factors led to her victimization. And when you do an intersectional analysis, you put yourself in the position of the perpetrator and you see how targets are selected on the basis of these intersecting identities. So that's what makes this judgment novel, because the commission took all of this into consideration. They looked at Joan's age, gender, and nationality. The third thing that makes this judgment novel is the use of the substantive equality test versus the formal equality test. I'll be brief here, but suffice to say that the use of substantive equality versus formal equality builds on this foundation of looking at people's lived realities. So what's the difference between these two things? The formal equality test is characterized by looking at equality in terms of treatment, not outcome. So if everyone is equal, we would all be granted the exact same rights and duties regardless of our age, our sex, our gender, our disability, and so on. And that sounds good in theory, but it does not reflect reality. For example, everyone would have to pay the same amount of taxes regardless of your income. And people with disabilities would receive no additional accommodation unless everybody else was getting it. Formal equality presumes that we are all equal and we started at a level playing field, but it's simply not true. It ignores our lived realities. And in this case, it would ignore that Joan is a woman and women are discriminated against, including being victims of trafficking. Whereas a substantive equality approach involves not focusing on equality of treatment, but on equal outcome. So, as explained by Professor Lowen, and I quote, "A person suffering from a particular illness is not helped by being treated as someone who is fully healthy. They require specific differential treatment to return to health." So what we're saying is a human's specific needs and individual circumstances need to be considered if they are to realize all of their rights. And this, of course, includes factoring privilege and vulnerabilities, which ties into intersectionality, as I mentioned before. I'm sure you've all seen this very famous image, and I think it depicts it well, because in the first picture, we're looking at equal treatment. Everybody has a block of the same size, but the little boy cannot see the game, and his presumably older brother can just see it, and of course, somebody, presumably his father, his uncle, can see it even more. Whereas in the second picture, we're talking about equality in terms of outcome. So depending on your height, you need a higher block, and that's what substantive equality is about. And in this judgment, the Commission meaningfully considers systemic disadvantages of women and the fact that women are more likely to be victims of trafficking for purposes of sexual exploitation. And that's how they were able to find violations of the Maputo Protocol. So in conclusion, this judgment is novel for those three reasons. It's much needed jurisprudence on women's rights. It applies intersectionality, which is critical for victim-centered justice. And it makes use of the substantive equality test, which reflects the lived realities of women. Judgments like this are essential if we are to tackle trafficking, and they go a long way towards vindicating the rights of survivors and victims like Joan. Thank you for your attention. I look forward to your comments.
Good morning, colleagues. My name is Michael Nyakon. I work for the Institute for Human Rights and Development in Africa, and I will be speaking about the Center for Human Rights and others versus Tanzania. I speak as one of the lawyers who litigated the case, so please take my views with a pinch of salt. I am very biased in many respects. But I think this is a case that is quite a monumental case in many respects. I will try to highlight about three or so of some of the important innovations that I think emerged out of this particular case. I think we can look at how the court comprehensively dealt with the vulnerability of persons with albinism, the contribution of the decision to the jurisprudence on state obligations with regards to economic, social, and cultural rights, and how this case bolsters the SERAC decision. But there are many of us who were very disappointed with Community Law Center versus Nigeria. And I think this case really sort of plugs in that gap that the Commission seems to have left open, where states could simply say, we are poor, we don't have money, and get away with the obligations under the Charter. This case completely goes in the opposite direction in certain minimum standards that states must comply with. But I think perhaps the biggest innovation that we derive out of this case really has to do with the impact of amicus interventions in litigating human rights claims before regional human rights mechanisms. For someone who is very intimately familiar with the case, we got far more than we ever requested from the court, because the amicus was the one that literally made the meat of the case. So this case relates to the plight of persons with albinism in Tanzania. According to records that were submitted by the government of Tanzania, when we filed the case, we had estimated, based on reports that existed at the time, that there were about 200,000 persons with albinism in Tanzania. We later learned from the government's own statistics that they estimate from recent census that there are about 71,000 persons with albinism. That is rough data. It's not data that is based on actual counting of persons with albinism, but statisticians estimated that there are about roughly that number of persons with albinism in Tanzania, which across Africa is the highest concentration of persons with albinism per population. So in Tanzania, it's a significant population of individuals who are impacted by the lack of melanin in the skin, which means that even though they are African, their skin tone is much lighter than the average person in society. So it's easy to identify them. And for some reason, across Africa, there are a lot of superstitious beliefs about what albinism is about, what causes albinism, and how people can exploit albinism as a means of enhancing their own fortune. So starting from the early 2000s, ritual attacks became prominent in Tanzania, where especially children with albinism were being abducted, then their body parts being removed with aim that these people who were removing the body parts were going to, through witchcraft charms, either enhance their own fortune. We've been heard of stories of people who thought that if they attached the hair or the nail or a bit of the skin of a person with albinism to their fishing net, that they would have a bigger catch, of fish when they go fishing. So it was a real bizarre set of myths that had developed around albinism, which was putting the lives, the liberty, the ability of persons with albinism to just live and move around in their communities completely at risk. And by the time that we filed this case, there were reports of at least 139 people who had either suffered by murders, 79 people had been killed, resulting of these kind of ritual attacks, many of them mutilated, and several who had been abducted. It got so bad to the extent that even when people died and were buried, that did not save them from attack. Their graves would be desecrated because people were looking for the bones of persons with albinism or whatever, even the clothes that they wore to be buried. Anything that was connected with persons with albinism was considered to be something that was valuable that could be exploited. And that really puts them in significant risk. So we thought that there was a role that we could play in highlighting this violence to the African court and getting the court to make some pronouncements as far as the obligation of the government of Tanzania is to protect persons with albinism from violence, discrimination, and the kind of torture that were being meted out to them. Strategically, we took the view that even though there were broader violations of the rights of persons with albinism in terms of economic, social, and cultural rights, healthcare, education, because we were aware of this idea of progressive realization, and we didn't want to jeopardize, the kind of outcomes that we could obtain, we focused mostly on dignity as the main, claim that we were making. So we made a lot of factual claims about how persons with albinism are being denied healthcare, education, but we never made a direct claim on the right to healthcare being violated or the right to education being violated, because we were very cautious not to allow the government to just simply come and say, well, we don't have resources and we're unable to, vindicate these rights at the moment. But somehow those strategic choices then caught the eye of the amicus, who happened to be the former UN independent experts on albinism, together with the current UN independent expert and the O'Neill Institute at Georgetown Law, decided to intervene as amicus, then setting out extensive pleadings on specifically the right to health and the right to education. And, to our surprise, the court actually did find substantive violations on these rights that we actually did not specifically plead. And that's some of the innovations that I want to highlight. I think when you read the decision, you get the sense that the African court had a very comprehensive appreciation of the vulnerabilities that persons with albinism face in Tanzania. I mean, beside the fact that this is one of the few cases within the African rights system that actually speaks to the rights of persons with disabilities broadly, as far as I'm aware, this is probably the second or the third case that has anything to do with disability. But it is the only case, as far as I know of, that deals directly with the issue of albinism and how persons with albinism are vulnerable to a multiple array of violations. And the court was very comprehensive in how it dealt with the nature and the extent of violations that persons with albinism face. So that even though our case focused really on the violence, what actually emerged out of the case was a court that understood that what needed to be addressed was really the root cause, and not just the enactment of legislation, criminal legislation that holds perpetrators accountable, but really dealing with the issue of awareness raising within communities to erase all of these myths, these kind of superstitious beliefs that underpin the violence, the discrimination that persons with albinism face. I think the court also really understood that there were intersecting identities that were being impacted by this particular case, including the mothers of children with albinism, who, even though they themselves did not have albinism, became somehow, by association, affected by the fact that they had children who had albinism. So the court acknowledges that women who had children with albinism were being affected by this kind of situation, that they were being abandoned by their husbands and spouses or other family, that often women had to choose between abandoning their children and maintaining their familial relations with their spouse or families because of the kind of negative consequences than being associated with a child with albinism brought to these women. But also, the court took a very important view of what the best interest of the child meant in the context of children with albinism. When in the height of these attacks, one of the measures that the government had taken at the time was to essentially just go from house to house, collect all the children with albinism and put them in a boarding school. So there were about 5 boarding schools that were hosting a number of children with albinism. The problem being that for most of them, there were really no documentation on where they came from. So you ended up in a situation where many of the children had no means of tracing back to which village they came from, who were their parents, how to reconnect those children back to their families when the violence subsided, and there was the need to reintegrate. And that the court held was not in the best interest of the child, that even though the initial intention that the state had was to protect them against the violence that was immediate and almost certain going to befall them, if not removed from those environments, that the state needed to take precautions to ensure that they had accurate data, that they were able to trace the children back to their own homes, communities, and families, and could reasonably reintegrate them back into those communities. I think substantively, when it comes to how the court engaged with the state obligations on economic, social, and cultural rights, I was speaking about our disappointment with Community Law Center and others versus Nigeria, and how the African Commission essentially gave a blanket check to states to simply come and say, we don't have the resources, and therefore we don't have, our obligations do not emerge immediately. That the commission even at some point said that socioeconomic rights were programmatic ideals that state could implement if they had resources. And the African court flatly disagreed in substantive terms with the African Commission, not specifically citing the case itself, but indicating that resources definitely are implicated when it comes to economic, social, and cultural rights, but that when an individual or a community or an institution raises the allegations of the violations of economic, social, and cultural rights, the burden of proof shifts to the state, that it is incumbent on the state to lead evidence to show that it has actually applied its maximum available resources to vindicate those rights. So it is no longer up to the state to simply come and say, we don't have the resources, and therefore we don't have the capacity to implement these rights. The state must actually show that in terms of budgetary allocation, in terms of the resources that they have applied the maximum available resources. And that really is an onus obligation that the state needs to lead evidence to show. So you must actually come and say to the court, this is how much budget we have, this is how we are allocating them, and this is how we are prioritizing the socioeconomic rights of these communities that are affected. And that the court, in some reasonable respect, also fell on the back of a minimum core obligation that, especially when it comes to vulnerable communities and groups, that in particular with regards to persons with albinism, that the state had a basic minimum core obligation to provide primary health care in the form of sunscreen and protective attire that protects persons with albinism from skin cancer. Because the research shows that the majority of persons with albinism are susceptible to skin cancer because of a lack of melanin. And sunscreen is the primary preventative palliative that they need to actually prevent skin cancer. And the state was not really doing much to provide this kind of consumable that these persons with albinism need to prevent skin cancer. And the court was very specific that the minimum obligation of the state includes, at the bare minimum, preventative primary health care, that the state must comply with this obligation by ensuring that all persons with albinism have access to sunscreen and protective attire that protects them from the ultraviolet rays of the sun that makes them susceptible to skin cancer. I think finally I'll conclude with how important this case is with regards to the impact that amicus interventions can have. And over the years, we have seen a number of scholarly work that has sought to engage with the potential of amicus interventions. During this research I came across, including Prof. Franz and Dr. Abebe, extensively discussing how the African human rights system could really benefit from amicus interventions, but that the rules were not really, clear and certain, and many of the judgments made references to the submissions of amicus without really engaging with it. But this really sets out how influential the amicus was. That besides the pleadings of the parties, the court went on its own limb to find violations on rights that were specifically pleaded by the amicus curiae. So that by extrapolating from the kind of factual background that we had painted on how persons with albinism were being impacted in terms of education, that because of the challenges with eyesight, they needed assistive devices, large font text, among others, to be able to engage effectively in school, that the discrimination in society prevents them from being able to effectively access healthcare, because even doctors and nurses make fun of them, and makes them feel horrible to just go for basic medical attention. And the latching on that, the court then made independent substantive violations, mostly relying on the further submissions that were made by the amicus in highlighting how the rights of persons with albinism to healthcare is impacted, and how education for children with albinism was also impacted in this case. So it really creates that platform of showing visibly how the amicus interventions can really go to bolster already existing claims that have been made by the litigants in the case, but even forming basis for the adjudicated mechanisms to find substantive rights violations by purposes of the information and legal arguments that have been made by the amicus intervention. So these are some of the ways I think that the decision was impactful and innovative, and I look forward to your comments and questions and engagement further. Thank you.
Thank you, Michael. The last presenter, Etienne Marc, are you there?
Yeah, thank you very much. Good morning. I hope you hear and see me well. So my name is Etienne Marc. I'm a French academic and a former advocate at the Paris Bar. And I'm currently at the University of Tours, and I'm affiliated with the University of Johannesburg. I'm so sorry not to be able to join you in person for this wonderful conference, but last minute circumstances have kept me in France. I will now share my screen and presentation. Okay, I hope you can see what I see in front of me. This is a great honor and an humbling one to find myself once again in the nation of Ubuntu, although virtually. And I'm delighted to be among this remarkable community to celebrate the work of the African Court on Human and People's Rights, and to speak under the panel of the chairmanship of Trésor, who I had the pleasure to meet in Morocco, and very much aware that I speak under the gaze of Professor Wiljoen, who took an active part in the decision I'm about to discuss. I stand before you with,
Etienne, I think we can see your
yeah,
screen. Are you
yeah,
able
you
to?
cannot see my screen.
I don't know if you have to be made co-hosts for you to share. I don't know. You're not co-hosts, so normally I don't. Hmm? You can now share.
All right. Is it better now?
No, but we have it. So can we? Once-
Mm, mm, mm.
Etienne, are you there?
Yeah, I'm there.
Yeah,
Okay,
go
it
ahead.
seems to be working. All
Just
right.
you'll be letting us know when to skip to go to the next
Let's
slide.
do this way. All right. Um, what I have to say is a perspective of a French academic who comes from business law. And over the course of my practice and teaching, I came to realize that if business law is to serve development, one must agree on what these very terms mean, and that those terms mean little unless they reflect the interests, values, and collective representation of the communities the law is meant to serve. Therefore, conceptualizing law on African terms imply therefore deconstruction and decoloniality. And that venture led me naturally toward non-Western legal traditions and toward mechanisms protecting indigenous people. First, those of Latin America, where they are the most advanced, and for which the question of their effectiveness is already being raised. The social situation and the legal treatment of autochthonous people in Africa is a singular one on which I cannot dwell here under our time constraints. But within the still emerging practice of the African Court on Human and People Rights, operational since 20 years, the case opposing the Ojek people to Kenya, which you, I think, know better than I do, occupies a place of quite unique importance. I expect we will have the occasion to return to this case more than once, judging by the program of this conference. And this presentation will rest on 4 points. A, the stakes of the implementation crisis at the time of the decision. B, how the court arrived at this historic landmark decision. C, what this decision contributes. And D, what its limits are. Further detail will appear in the accompanying publication, which will, of course, be updated in light of our exchanges today. Allow me to begin with the date that matter most. On 4 December 2025, the African Court on Human and People Rights delivered its first ever compliance order, and the title I have given to this talk, From Declaration to Enforcement, is meant to capture the distance between an international pronouncement and the lived reality for the community it was meant to protect. Yeah, I think the slide is correct right now. Briefly, by the way of context, the OJEC, some 35,000 hunter-gatherers whose cultural identity is bound to the Mau forest in Kenya's Rift Valley, were reduced to tenant at will on their own land by the 1915 Crown Land Ordinance and became in-law trespassers on their very ancestral territory once the forest was gathered in 1934. The case reached this court in 2009 after a fresh eviction notice. And this pattern is not unique to the Mau. OJEC communities elsewhere in Kenya suffer the same sequence of colonization, alienation, and eviction across the 20th centuries. Can you go on the next slide, please? I would simply recall that the merits judgment of 2017 held that the OJEC are an indigenous people with a collective right to property over the land, and that the reparation judgment of June 2022, that will be on next slides, made the first award of reparation to an indigenous people in this court history. And yet, as recently as November 2023, more than 700 members were evicted by force, and their homes and school were burned. 3 years indeed after the reparation orders, the order's compliance itself draws up a scorecard of 9 distinct obligations, and the picture, I am afraid, is a sobering one. Can you move please to the next slide? On compensation, on land delimitation, and on titling, on publication of the judgments, and on the Community Development Fund, the order records little to no progress. Formal recognition and consultation for only somewhat better, each marked partial. The most troubling line concerns the cessation of evictions. As I mentioned earlier on, in 2023, the order records over 700 people were forcibly expelled and their homes and schools were burned. Consultation in particular fell well short of the standard of the order sets out. An interministerial committee whose existence the community learned of from a Facebook post is not by any measure free, prior, and informed consent. Professor Dana Shelton once observed that international protection of human rights is far more effective at identifying violations than at ending them. The figures bear out. Only 7% of these court judgments have been fully complied with its own 2020 figures, and its own 2024 activity reports pulls overall implementation at under 10%. My slide would further develop on those numbers, but I'll be able to share it with you if necessary. The reasons are structural and worth naming briefly. The court first has no enforcement arm of its own. Compliance depends on the respondent state's political will, on civil society and institutional readiness. Professor Murray called this an implementation crisis that is today reinforced with the direct access itself that is shrinking with the withdrawal of member states. Turning then to my second point, how did the court arrive at this landmark decision? In the OJEC case, every avenue available to the court at that point ran in some senses into a dead end. 3 options realistically were open to it. You will find those options on the next slides normally. Defer entirely to the African Union's political organs, issue a further reminder and order with fresh deadlines but no finding of unlawfulness, or to proceed to a formal judicial supervision under its own new Rule 81. Reporting non-compliance to the African Union's political organ, as Article 29 and 31 of the protocol contemplate, as a merit of textual fidelity, but the empirical defect of producing almost nothing. The Executive Council's role is political, not judicial, and 8 years of Kenyan inaction has already shown where that path led. A bar reminder order risks simply repeating the experience of 2017 and 2022 with no greater prospect of success. And faced with these impasses, the court cites an opportunity that has not existed at the time of earlier judgments: the supervisory mechanism created by its own 2020 reform of the rules of the court. Rule 81 allowed it, and for the first time, the court convened a formal compliance hearing to hear amicus curiae and to issue a reasoned order. So, on what textual basis did it do so? As I explained, first of all, on the new Rule 81, but also on Article 30 of the Ouagadougou Protocol that binds the states to comply, and on the Rule 90 that preserves the court's inherent power to do what justice requires. At paragraph 25 that you will find on my communication, I will share, I think, my PowerPoint presentation. The court holds in its own words that, I quote, "It has an inherent jurisdiction in any case or dispute submitted to it to establish whether a state has complied with its judgment or not, with the time stipulated, and if not, to take the necessary measures to ensure execution." The court went further still, finding at paragraph 140 of the compliance order that Kenya's continued non-implementation itself constitutes a violation of the protocol, a characterization with a real pedigree elsewhere. This brings me to my third point. What does this decision actually contribute? The order of 2025 itemized what compliance now requires, each with his own clock. Immediately, the payment of the full 157 million shilling Kenyan in reparation within an unspecified but stipulated period, a collective delimitation, demarcation, and titling of the Ojek ancestral land, without delay, establishment of the Community Development Fund, cessation of further evictions, and genuine cultural appropriate consultation with the Ojek through their own customary institutions. And within 6 months of the order, that is by 4 June 2026, submission to the court of a detailed progress report on all of the above. I would identify 3 more specific contributions. First, collective land rights become an enforceable obligation, not just a declaratory one. Delimitation, demarcation, and collective titling under the active judicial supervision. Second, consultation becomes a condition of lawful state action, not a procedural formality. Its consent is set by the Ojek's own customary institution, not by the state. And a Facebook notice, as we have seen, is not culturally appropriate consultation. Third, the Ojek on biocultural community protocol becomes a source of a law of its own right, the very measures of Kenya's obligation and not merely the object of the obligation protects. This brings me to my fourth point. What are the limits of this decision? Having heard that this decision merits the description landmark, I owe you, in fairness, an account of its limits. The orders create a real normative pressure, but no instrument of direct enforcement. Nor does it say which. Yeah.
You only have 1 minute. 1 minute remaining.
Sure. Thank you very much. nor does it say which state agency answer for which measures, a gap that leaves the OJEC once again to chase their own remedies. So the enforcement issue remain open. As I add at greater length in the written commentary accompanying this presentation, the order of December 2025 is just the beginning. The distance between declaration and enforcement has narrowed. It has not yet closed. And I will end then by posing questions that Professor Wiljoen is far better placed than I am to answer. Will and when the court will do this again, in this case or in other cases? And my presentation was meant to leave you finally with an image of the OJEC community members on their own letters and placards, a reminder of whom this African court is ultimately for. Thank you very much for your attention.
Thank you. Thank you so much. Now I think we have 16 minutes before the break. We can engage with the presenters. We have 4 presenters, so you raise your hand, you say clearly to which presenter is your question addressed, or if you want all of them to respond, you just say it. And I think if those who are online want as well to ask questions, please let us know. Yes, Michael. Well, you can ask here and then we will know how it works. Use this.
Okay. Thank you. My question is regards to the compliance and implementation. Mike Onyako, for the case, I understand the ruling was made last year, 2025. Probably there's not much Tanzania has done, but in the Ogei case, we see a step further where the commission actually goes to court against Kenya to say Kenya has not implemented. Do we see that as a way forward in terms of pushing these states to implement? And lastly, if the Kenya does not go ahead to implement the orders of court in the implementation case, what then happens? What other avenue is there to push them to again implement what court has asked them to implement, that asked them to implement? I hope you get it.
Okay, we will take a series of 3 questions, two more, and then we'll give the presenters the opportunity to respond to. Wait, the one who. Okay, please go ahead.
Thank you. My question goes to Michael. Michael the second. Yes. Yeah, so on the case of Center for Human Rights versus Tanzania, we understand that the government actually advances some efforts that it has made concerning the whole issue of people with albinism. As you have said, for example, the issues of establishment of protection centers, the schools and whatever. So as much as we understand that the margin of appreciation doctrine is not so much famous in African court jurisprudence, all I want to know, did the court completely outweigh the effort made by Tanzanian government? And if it did so, what is your personal take on that? Because there were some efforts. What were the court thing, and what is your personal take on that, considering the margin of appreciation doctrine, however, not that much famous in our jurisprudence?
Thank you very much. Mine goes to Angela. Well done for the very lovely presentation. I'm called Emma. I'm wondering on the question of intersectionality and the posture that the African Commission has taken, do you envisage the possibility of the African Commission or probably the African Court as well going a step further to looking at intersectionality from an Afrocentric perspective? Because yeah, Crenshaw presents very interesting. That's the conversation in a nice way. But is there a possibility for the courts to engage with intersectionality, given the unique identities in Africa, for example, given the history of colonialism, the continued effect of imperialism, some of the laws that, you know, African women actually find themselves navigating? Do you see space for, you know, the African Commission developing an African-centered approach to intersectionality so that we have some sort of Afro intersectionality perspectives to how we engage with the notion of intersectionality?
Thank you so much. Last question online, Samuel. Samuel, unmute yourself and go ahead, please.
Right. Thank you very much. I just have a question needing clarification. My question is directed to Etienne, whose presentation was based on the OTA case. In his presentation, he mentioned that there was a comment by a professor who said there has been about 7% implementation of the judgment of the African Court has paid the compliance judgment that was issued on the 4th of December 2025. I just very much like for Etienne to indicate this 7% of implementation. What is it in regards to when it comes to the 12 orders of the African Court, which was issued both in the merits and in the reparation judgments? Thank you.
Thank you. Thank you, Samuel. So we'll start with Etienne briefly. Can you address all the questions? You know, that's why.
Yes, thank you very much. I will maybe start with the last question that have been addressed to me. So I've been doing my on research, and I didn't find any specific numbers regarding the rate of implementation on the merits or on the reparation judgment. But I believe Professor Wiljoen published a contribution explaining that less than 10% in general of the decision are actually implemented, which leads me to the first question that have been addressed to me. That number really is today is to me one of the main challenges to make this system of human rights protection work and to take this system seriously. And we have to acknowledge that the system, the court exists and is in function since 20 years, which is relatively recent. And to the precise question that have been addressed to me, there is no magic solution. There is a separation of power, but we have seen that since 2020, the court reform is on procedures, it's on rules, and it offers to the court a new mechanism that we shall welcome. But still, if the member states keep not enforcing its judgments, we have to rely on the multi-layers and stakeholders, I don't know to say, features of that situation. That means that we shall put more, we should rely on other stakeholders, such as national jurisdictions, such as NGOs, such as activism, to try to convince the state to change first its policies before going in front of jurisdiction, and then if the state is condemned, makes more pressure to play also on the reputation of the state, so that the state, if the state still want to appear attractive toward the international community, that the state should understand that it should comply with international human rights instruments. Thank you very much.
Thank you, Etienne. Angela?
Thank you, Emma, for that very good question. I absolutely think it's imperative that the African Commission develop an Afrocentric view or an Afrocentric interpretation of intersectionality, because that reflects our lived realities, and that is the reality in Africa, and that's what needs to be reflected. But I think it's imperative that the litigants also do their best to put that information before the commission, because anybody who's worked in a court with any judge, you'll know that if you give them most of the information, you'll probably get a better outcome than if you don't. So I think it's on those who are bringing cases before the commission and these various bodies, and also on the commissioners or the judges themselves to read up about intersectionality, Afrofeminism, and as you mentioned, the legacies of colonialism, imperialism, patriarchy. I think all of that needs to be integrated into how we do an intersectional analysis before the African Commission.
Yes, so two questions were addressed to me, both of which relates to implementation, and the other one on the margin of appreciation. I think in terms of the implementation of the decision of the court, we know that one of the main orders of the court, which was for Tanzania to adopt a national action plan to put in place what exactly is their proposal to promote and protect the rights of persons with albinism. They have enacted that national action plan. I think actually they did, whether a few days before the judgment was delivered or after it was delivered. One of their own arguments during the hearing was that they were in the process of adopting this national action plan, and therefore they didn't want the court to make any decision regarding that particular what you call it, relief that we had requested from the court. But so they have complied with that initial plan, but having the plan means that you must also put in place the budget that needs to be utilized to implement the plan. So we have a 2-year implementation timeline. That is what the court ordered, that the state must put a compensation fund in place to ensure that persons with albinism who were impacted by these violations actually can access that compensation fund, and that some of that money that will go into the compensation fund will also be used for advocacy to raise awareness about albinism in communities, to ensure that people appreciate the scientific genetic underpinnings of albinism. There's nothing spiritual or superstitious about it. It's just a genetic mutation that results in the lack of melanin. So we will continue to pursue the government as litigants towards having those budgets in place to implement the decision. In terms of the margin of appreciation and whether or not the court took into account some of the measures that the state had adopted, indeed, the court actually acknowledged that there were a number of measures that the state had put in place. What the court was not convinced by was whether these met their minimum obligation. So, for instance, the court acknowledged that the state had indicated, and we had not controversied it, that they had supplied sunscreen to about 44,000 out of the 71,000 individuals that the state acknowledges are persons with albinism within the state of Tanzania. What the court disagreed with was that because it considers sunscreen to be preventative health care, which is a minimum core obligation, you cannot say that you have provided for some of the community members and not all of them, and that you had not met the basic needs of all the community members, because that is something that is fundamental for their right to life. That most of the persons with albinism were going to develop skin cancer and die before they turn 40 years if the state was not actively providing them with this kind of sunscreen. So it's not that the state did not consider what the government was, the court did not consider what the government was doing. Even with regards to the children who were placed in the boarding schools, the court commended the government for taking the initial step, but that initial step then resulted in overcrowded schools with limited, healthcare and other kinds of facilities. So acknowledging that the state has done something does not really, mean that the court agrees that what the state had done was, sufficient. And the real, crux of the issue was that the court had said the minimum, that if you had not met that minimum call, then even though we acknowledge the efforts that you have made, that would not be deemed to have been, absolving the state of its obligation to take those targeted steps that it needs to take to ensure that, that those minimum core obligations are complied with. So those will be some reflections from my side.
Yeah, just a quick one. Based on the question that was asked to Angela, as a litigator, do you foresee any use of Afrocentric based argument in the next pleadings or other cases you are involved in, or you litigator, you remain positivist in how you frame things?
No, certainly. I mean, I think there's room for Afrocentric ideas. We are often these days, threatened by this scarecrow of African values, and I think that is a narrative that we need to claim. We need to, as litigants, start defining what those African values are, so that we don't have this, politicians wavering these African values as something that is supposed to, make us fearful and undermine us. And whenever it comes to any issue that they disagree with, they whip up this idea of African values. So I think it is important for us who are litigating, who are trying to set the norms, who are trying to shape the, the jurisprudence, to also weave into our pleadings what exactly is our own interpretation of what these values are. What does Ubuntu mean in the, in the context of healthcare or education, or, all of these rights that we are concerned about, so that we don't leave this debate of what, the African conception of these rights are to just politicians who wants to, bully us and want to, deny us of having basic reasonable debates about issues sometimes. That, these days, whenever they don't like anything, they say African values and the conversation must just end. So I definitely think that there is a role for litigants to, try to inform the debate and to weave, as much as reasonably possible, the Afrocentric side of some of the issues that we are concerned about, and to reclaim that, narrative of African values and what it means for human rights on the continent.
Thank you. Michael?
Yes. Quick one on the implementation of the African Commissions and African Courts decisions. I think the African Union should strengthen its political oversight, on some of these things. For instance, Kenya is failing to implement the court decision, but a Kenyan was also contesting to be the president of the African Union Commission, for instance. So it is time that we begin to also push for the African Union to sanction some of these states or national government. But then I must also underline that it depends on the political systems in such countries. For instance, if a decision goes against Ghana, I think it would be difficult for Ghana to say, I will not implement it because of the political system. But to conclude, even in the CERAC case, we realized that at that time, it was a dictator who, at that time it was Obasanjo. But during the time of Abacha, they quickly established the Ministry of Environment and an Environmental Protection Agency. And you see that it was in direct response to the case, even though they were not responding to requests for information, they were doing some groundwork. And so we have to also look at what we mean by implementation. And we should also engage national human rights commissions in various countries, and continue to mobilize civil society, the academy, the ordinary people, to mobilize pressure on their national government when it comes to implementation of some of these decisions, so that these landmark cases will not remain landmark, but lead to tangible outcomes that we will all be proud of. Thank you.
Thank you, Michael. This leads us to the end of the first session. Thanks to all the presenters, and thanks to all of you for your active participation.
And thank you for everyone's participation, also online. I think it was a very efficiently run session to keep us nicely on time. So for those in the room, let us take the tea break. It is just outside the room, and try our best to be promptly back at 15:15. So there is 15 minutes for tea break, and then we'll be in the hands of Dr. Sabelo Kumetse, who will be the chair of the next session, and the panelists can take their positions here as you return. Thank you very much. How do we make this more efficient? How do we make this more efficient? Do you have a plan? How do we, I mean, let's see the next one. It's really.
Yeah,
No,
well,
but I mean,
it should have worked.
yeah, why did it not work? I don't know. Do we know? Do we know why it did not work? Because you could see his screen was
Yeah.
was doing it, and then why did it just restart? So maybe we'll just try again.
Let's
Yeah, maybe we
we can
try.
test it.
Is there someone online now? Yes, the first one. Does she have a PowerPoint? Okay, shall we try to see if she's online? Yeah, we can just lift it up, right? Yeah, let's put it to the next round, right? For hers, I will. I suppose we don't have we should try to get that, right? We don't have the, here we have the, we should have like the WhatsApp or something for them. There's no way. But that's the only thing that we can, yeah, that's, you'll save a little bit of time. If she were online, but, let me see the participants. We can write it out.
Hello.
How do we get back into that mode, right? Let's go out of there. So if she saw our message, it was it sent, right?
Testing one, testing one. Morning, Cindy. So how are you, ma'am? Colleagues online, please confirm that we are audible.
I can confirm.
Thank you. Testing one.
So is the audio good online?
Yeah, it's good.
So you must find out this
It's
online.
just, I think, the presentation, why it's shown online is not.
We have one both here.
Hello.
Marisa is here. Let's call this person, another one boy. See, I didn't. What's him say?
I just need to find out if
So this person has already shared as a screen, and she's good. So
Must
we can
be
start with them. Yeah?
okay, all right.
And then let's just call this person Wamboze. Uma.
Uma Wamboze.
Yeah.
All right.
Let's just say Umar Wamboze, you can join us.
You know. Can we have Uma Wamboze?
Umar is here. And then we can start. Yeah, let's
All right. All right. I think we can start. Ladies and gentlemen, let's settle down. Thank you very much for coming back. We hope you had good coffee. I think in the absence of others, I think they will join us as we proceed. At this point in time, we would like to call upon the first speaker, who will just introduce herself briefly, Nosipiwo Nzimande, and thereafter I'm going to ask the other colleagues to make their presentations. We have made an agreement that the presentation will not go beyond 15 minutes, so that we can have a good discussion thereafter. So over to you, Nosipiwo. Nosipiwo is online.
Yes. Okay. Am I audible?
Yes, you are, Nosipiwo.
Okay. So I just introduce myself and then present and then.
Yes, please.
Okay.
Go ahead.
Thank you. So thank you very much, Chair. Hi, everyone. My name is Nosipiwo Nzimande, and today I'll be presenting on my paper titled A Step Closer to Abolition, which is based on the dissent in John Lazaro versus the United Republic of Tanzania, which I dub as Landmark. So this paper actually extends my analysis that I developed in a previous paper that I wrote that was titled The Abolition of the Death Penalty, based on the same judgment. But in that paper, I argue that the abolition of the death penalty is customary international law, and that the interpretive methodology that is used by the dissenting opinions illustrates how courts can advance abolition by adopting a human rights perspective. just to give a background of the matter, on the 7th of November 2023, the African Court on Human and People's Rights handed down a judgment in a matter concerning the compatibility of the death penalty with the African Charter on Human and People's Rights. So the court was split into three, essentially two, but three. The majority judgment adopted a restrictive approach by looking at the plain meaning of the provisions of the Charter and found that the method of punishment was not prohibited by the Charter, but rather it was the method of execution, which is supposed to be by hanging, that contravened Article 5 of the Charter. And on the other hand, we had two dissents, the dissenting opinion of South African Judge Dumisa Buhlentsebeza and Congolese Judge, Judge Blaise Chikaya. They adopted a more purposive approach in line with contemporary developments in international and regional human rights law by finding that the death penalty is incompatible with Articles 4 and 5 of the Charter. Next slide. Sorry, I'm just moving on to the next slide. Okay, here we go. So for the purposes of this paper, landmark is defined as advancing legal understanding and setting an important legal precedence. So the Vienna Convention on the Law of Treaties becomes instrumental for my analysis because it sets out a foundational principles that are used in the process of treaty interpretation. So the paper focuses on two kinds of interpretive methodologies. The first is the literal rule, and the second is the purposive approach to interpretation. And just to give a background, so the literal rule basically is known as the plain rule of interpretation, and it's a method of statutory interpretation that requires the court to apply the ordinary and natural meaning of words used in the statute. So when courts are using this approach, they focus on the wording of the legislation without taking into cognizance the legislature's intent or the broader purpose of law. It's based on the assumption that the lawmaker's intention are most accurately reflected in the language that they've chosen to use in that statute or instrument. The purposive approach adopts a broader perspective when interpreting legislation or treaties because it focuses on the purpose and the objects that the legislature sought to achieve when they were enacting the law. And this approach examines the statute within its wider context, including historical background, the social and legislative circumstances that led to its enactment, and also the specific problem or mischief that was intended to address. So it seeks to ensure that the interpretation of the statute aligns with the underlying purpose and the spirit of the legislation. The Vienna Convention aligns with the purposive interpretation as Article 31 provides general rules of interpretation and has 4 subsections, the 3 of which are relevant to this analysis. So I'll go with the first provision. It says, a treaty shall be interpreted in good faith in accordance with its ordinary meaning to be given to the terms of the treaty in their context and in light of its object and purpose. Subsection 2 provides the context for the purpose of interpretation by providing that the context for the purpose of interpretation of a treaty shall comprise, in addition to the text, including its preamble and annexes, any agreement relating to the treaty which was made between the parties in connection with the conclusion of the treaty, any instrument which was made by one or more of the parties in connection with the conclusion of the treaty and accepted by other parties as an instrument related to the treaty. And subsection 3 provides that additional material to be considered in treaty interpretation by the court includes any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions, and also any subsequent practice in application of the treaty which establishes the agreement of the parties regarding its interpretation and any other relevant rules of international law that are applicable in relation to the party. So the Vienna Convention provides a framework that courts can use in interpretation. And in my discussion of the interpretive divide in John Lazaro, I will illustrate how the opinions placed greater emphasis on the object of the Charter, the evolving international human rights standards, and developments in regional and international practice. So the majority adopted an ordinary meaning of the Charter's provisions. So it interpreted the Charter within the confines of existing state obligations and legal framework rather than through the lens of evolving human rights standards. The majority did recognize international trends towards abolition, but it declined to treat such developments as determinative of the meaning in Article 4. They rather placed significant weight on the absence of universal treaty ratification prohibiting the death penalty, and it focused on how many states still retain it as a method of punishment. The dissenting opinion of Ntebeza J adopted a more purposive approach to interpretation that centered human dignity as the foundational value underlying the Charter. In his analysis, he did not only confine to the legality of the method of execution, but he examined whether the death penalty itself could be reconciled with the Charter's broader commitment to the protection of human dignity and the right to life. He also drew on comparative constitutional jurisprudence like US versus Makwanyane in South Africa and international human rights developments and the practical operations of the death penalty in contemporary legal systems. His analysis basically illustrated how dignity functions not only as a protected right in the Charter, but as an interpretive principle through which the content of Article 5 can be determined. The dissenting opinion of Chikaya J also adopted a purposive approach to interpretation, but it's slightly different from Ntebeza's J, but it reached the same conclusion. For Chikaya J, the absence of an express provision prohibiting the death penalty does not preclude the court from interpreting the provision in light of subsequent developments in international and regional human rights law. He sees the ambiguity of the Charter as creating space for judicial interpretation informed by contemporary realities. He relies on regional practice, international abolitionist trends, and regional instruments and sees them as reflecting an understanding that human rights must be interpreted in the broader international legal order. So in reconciling the reasoning of the majority and the two dissents with the Vienna Convention, we see that the majority adopts or applies Article 31 in a very conservative manner by privileging the ordinary meaning of the Charter's provisions and the current state of international legal obligations over broader considerations, while the two dissents align with subsections 1, 2, and 3 of the Vienna Convention, which recognizes the relevance of subsequent practice and other applicable rules of international law in treaty interpretation. So the significance of the two dissents extends beyond the conclusion that the death penalty should be abolished, but also in its assertion that the Charter is a living instrument whose meaning evolves alongside the development of human rights norms. Next slide. So the question is, what makes the dissents landmark? They situate the Charter within a broader international human rights framework by viewing it as part of an interconnected international human rights system than as a self-contained legal instrument. The dissents further emphasize that the Charter must be interpreted in light of contemporary African legal developments, which consist of an emerging regional consensus concerning the protection of the rights to life and human dignity. And what do the dissents mean for the future? They have a very significant influence on future litigation as they provide future litigants with a coherent legal framework through which challenges to the death penalty may be advanced under the Charter and also under domestic legislation. The dissenting opinions also influence on the abolition discourse as they contribute to reframing the debate. It moved from one that was concerning penal policy to one that was concerning the interpretation of fundamental rights. The reasoning of the dissents thus situate the abolition of the death penalty within a broader framework of human dignity, the right to life, and evolving standards of international human rights law. The dissenting opinions also contribute to African human rights jurisprudence as they advance an interpretive methodology that allows the Charter to evolve alongside developments in international human rights law. They also illustrate how regional human rights law should be interpreted, and they are reliant on the objects and purpose of the Charter and subsequent developments in international law and regional practice illustrate how Articles 31, subsection 1 to subsection 3 of the Vienna Convention may be utilized in the interpretation of human rights treaties. And most importantly, the dissenting opinions treat the Charter as a living instrument. They affirm that the Charter is not a static instrument that is confined to the intentions of the drafter, but it's a living instrument that's capable of responding to contemporary challenges. And just to conclude my presentation, I believe in the abolition of the death penalty, and just to cement on its advocacy, we can live without the death penalty. Human rights demands it. Thank you.
Thank you very much for that presentation, Nospio. So we see a dissenting opinion being a landmark in its own right. And I think the jurisprudence is really improving. We're not only seeing the majority being the landmark, but we are seeing the dissenting opinions. So on that note, let me call upon the next speaker, Uma Wamboze. We had agreed in your absence that it will be 15 minutes, and I'm not going to be standing to flag you down. Thank you.
Hello, everyone. My name is Umar Trai from Boise. I'm from Uganda. I'm also a researcher, and my niche is Sogi ascrites, specifically in Uganda. So, for most of us, what we know as landmarks or even leading judgments is actually the shorthand from overall from judgment. So, for example, when you look at the case of Rex versus Sussex Justices, which presents the principle of fair trial, that justice must not only be done, but must also see to be done. That is all we know. We do not know the facts. We don't know who the parties were. So that is what should I call it? It's an overarching characteristic in most of the landmark judgments that we have today. And you can see the same in Salmon versus Salmon in terms of corporate personality. So that is like sort of an overarching pattern. What I'm going to do today is something similar, but I'm going to do it in respect of Zimbabwe NGO Forum. So for most of the previous periods, scholars have normally focused on the classical investigation of landmark judgments. So for example, a scholar would refer a judgment as a landmark because it presented a certain principle that they were biased to, or maybe it overturned a particular form of injustice in society, and they would praise it for that. For example, Brown versus Board in the United States, and several other. And the problem with this approach, as you will see, is that it is subjective, and being subjective is biased, because what is a landmark to one may not be landmark to the other. Hence that Theo Stefan statement that landmark is is to the beholder. And so what do we do in the information age? Okay. Sorry. So now with the age of information, now that because when you realize that one of the factors as to why most of the theorists and the scholars preferred particular judgments was also because of the issue of absence. It was the only judgment you knew. It was the only judgment that was available. Judgments are only available in print, in libraries. And if you had no access to all of these things, then it is very, very, very obvious or very okay. So it's going to be very easy that what you know is influenced by the kind of access you have. So if it's the only judgment you know, then definitely it's going to be landmark in that particular field. But now with the age of information, all these judgments can be accessed online. We have websites dedicated to providing precedent and judgments of these courts. And as you have seen, previous scholars, for example, recent scholars, Thale has used the data contextual method of proving that the Lopez-Ostra case in the European Union is not actually as landmark as people thought, because there are other judgments that have done the same, but just because certain scholars have preferred it. Same has been done by Bruin and others in respect of where they have patterned, they have done a citation network analysis and connecting particular judgments to others and see who has referred to this, where they have referred to it. Have there many people referring to this judgment? And is that and proving that this is what makes it a principal kind of judgment, hence landmark. However, we have a limitation of doing that within the African human rights system. Because one, when I was doing my research, when you look at Africanly, we only have merit decisions from the commission. The soft law outputs are not really available. So you have to go to the African Commission's website if you want that. However, on top of that, there's also lack of meta citation data. And so you cannot really, because when you look at the other websites, for example, the HUDOC for the ECHR, there is meta citation data. And so the system already is showing you which case is preferred in this particular field and why is it preferred, which has many citations. So there's really not so much work to do in that instance. Of course, the same applies Africanly, ULI, SAFLI, and all the other websites in that regard. So Zimbabwe Human Rights NGO Forum versus Zimbabwe. In 2000, following a referendum in Zimbabwe, most of the majority of the people voted against the drafted constitution. What followed was political violence, which included rape, battery, torture of opposition politicians who are against the draft constitution. So a coalition of 12 human rights NGOs in Zimbabwe filed a communication before the commission, and the decision was delivered in 2006. Of course, whereas the decision is mostly known for its ruling in terms of state responsibility for violations occasioned by private actors, non-government actors, what I'm going to talk about today would be what most of you would call obiter dicta. Of course, in much as the ruling even did not even find the state in violation of Article 2. Yet that is what makes the case of my presentation today. So the essence of my presentation is in paragraph 169, where the commission said in respect of Article 2 of the Charter, which is about non-discrimination, the aim of this principle is to ensure equality of treatment for individuals irrespective of nationality, sex, racial or ethnic origin, political opinion, religion or belief, disability, age, or sexual orientation. Emphasis added mine. If you look at the provision in the Charter, it does not go that far. It ends on any status. And when you look at, and even when you look at most of the times, and so that is also that paragraph alone didn't really have anything to do with the ruling it gave, with the commission's ruling at the end of the day. However, it is the first time that the commission has made an explicit reference in terms of regarding sexual orientation. And why is this important? It's because, as I'll mention when I'm talking about the legal merit procedure that I want to emphasize. So in respect of the obiter problem, I would like to just make a case of a few things as why it does not apply here. So the first part is that one, the obiter the obiter problem. So we have that thing in domestic courts where we have ratio decidendi and obiter dicta. So ratio decidendi are like the essential grounds for the ruling of the court, and the obiter dicta are the non-essential, really, just the judge's business. But yeah, so that is mostly, it's very common within the domestic courts because it's important in that hierarchy that ratio decidendi is, it's binding. You cannot go aside it, especially for the court lower than the court that has made the decision. In international law, however, this view has been disagreed with, and as you can look at, especially when you look at like the case of Lotus, or when you look at the case of Barcelona Traction, which is the one that made the first decision in regard of Ega Omnes, it was obiter dicta. So really, in international law, everything counts. Whatever is said in the judgment counts. So that classification does not really apply here. In respect of the second ground is that passing remarks, as we have seen throughout history, have a tendency of acquiring a life of their own. Actually, in many instances, what landmarks are known for and what landmarks are decided for is an entirely different story. As you can see, in the United States in 1938, there was a trade case, United States versus Carolyn Products, and what happened to be a footnote in that judgment, several years later has become the threshold for the strict scrutiny test in the United States Supreme Court. My case is that that same standard applies for Zimbabwe NGO Forum, and here is why. All right. So I'll be advancing a test that I've put forward for a landmark status, and that is the dual validation test. So it combines one, legal merit, and then the other part is empirical data analysis. The empirical data analysis is on the basis of what Thale and Bruin have done in respect of the European Union law. The legal merit element in terms of Zimbabwe NGO human rights, as most people have been talking about, landmarks, there's that part of legal innovation, being the first, and changing something fundamental around that area. I have two claims to make. One, when you look at most of the legislation that has been made against sexual minorities, when you look at most of the arguments that have been made by states, for their restriction of the rights of sexual minorities, it comes down to two things. The first one is the absence of an explicit reference of their rights in their constitutions. And then the second one is about the limitation test, that whereas your rights are there, fine, we can limit them because of, cultural sovereignty, because we want to protect our children and those kinds of things. And I want to show you how Zimbabwe Human Rights does this. So, of course, in respect of the absence one, you also note that neither the Charter and nor do the 9 core instruments of the United Nations mention sexual orientation explicitly in all their non-discrimination clauses. And you'll find that reading into these charters and these instruments, sexual orientation rights has been coming as with the evolution of law and also the contemporary realities we are having as us. So Zimbabwe NGO Human Rights Forum was actually not the first. Constant versus Zimbabwe would have been, but then the communication was later withdrawn in respect of sexual orientation. And when you look at, so that is what makes Zimbabwe human rights take that, because it is the first in that instance. But also when you look at the background, the regional background against which this decision was made, you can look at some of those statements. For example, President Mugabe in Zimbabwe in 1994, while closing the girls and banning them, the Gay and Lesbians Association of Zimbabwe, and banning them from attending the book fair, he said, if we accept homosexuality as a right, what moral fiber shall our society ever have to deny organized drug addicts or even those given to bestiality, the rights they might claim and allege they possess under the rubric of individual freedom and human rights. Similarly, when you look at President Sam Nujoma's remarks in Namibia 2001, the Constitution, he says, the Constitution is being misinterpreted by colonialists who are confused. They are using the Constitution to protect homosexuals and lesbians in an irresponsible way. And to crown it all, from Uganda, MP Bahati, when presenting the 2009 anti-homosexuality bill, he had this to say: "Our Bill of Rights does not recognize homosexuality as a human right. Don't tell me that anal sex is a human right. No one has a right to lure our children into homosexuality." When you look at even the domestic litigation that has been done in respect of sexual minority rights, you'll find that the government has consistently brought up this. Actually, in Uganda, in 2005, the state went ahead to propose an amendment to the constitution in respect of the right to marriage, because it was not very clear on the kind of persons that can engage in a marriage, that can, form a union in marriage. And it went further that marriage in this constitution shall only mean between a man and a woman. So effectively ruling that out. And so this is very important because the commission has a mandate under Article 45(3). And so a mandate to interpret the charter. And so it is like the ruling body in terms, it is like the arbiter of what the words in the charter means. So for the commission to say, even if it's in obiter dicta, for you to say that, you know what, this right to non-discrimination includes sexual orientation, that is enough. And of course, you will see that in Uganda, it has been used in the recent constitutional petition, which is now on appeal, to defend the rights of sexual minorities in that case. And also, similarly, you will see that if you look at Nigeria, same thing happened. Ghana, a similar thing has also happened. So there is that context in non-discrimination, that absence, that where your rights are supposed to be, if your rights are not explicitly, stated in the document, you actually do not exist. On the second claim of limitation, so the pattern has been that, okay, we'll accept that you have rights. And so normally they will say that that right is only for those jurisdiction right has been accepted. For us here, we have our cultural values. We want to protect our children, something similar to what MP Bahati did when he compared, the rights of sexual minorities to recruitment, something I've dealt with in some previous works of mine. So why is this important in this respect? When you look at the Inter-American Constitution in Atala Rifo and Daughters versus Child, it says that differential treatment on the grounds within a non-discrimination clause must meet strict scrutiny. The distinction must not rest on prejudice or stereotype. The distinction must not rest on prejudice or stereotype. As you realize, for most of the restrictions that are being suggested in most of these cases are rested on stereotype and prejudice against sexual minorities. And so the fact that Zimbabwe NGO Forum puts it within that suspect category, it ineffectively means that we do not need to answer any question in respect of that, of the restriction claim. Yeah. So now moving on to the next part of the test, which is the data and the methodology. So what we did is that we organized, we reviewed all decisions. I reviewed all decisions from the African Commission after Zimbabwe NGO Forum. So that is from 2006 up to now. But as you realize, there is limited or no case law in respect of sexual minorities from the African Commission. And as such, we had to expand our premise to collect data even from the soft law outputs of the charter. That is including concluding observations, periodic reports, general comments, resolutions, etc., which, as you realize, they have made more compelling and more comprehensive submissions in respect of sexual minority rights. So we looked at 49 outputs, and then we have 9 output types, that is the concluding observations, activity commission reports, etc. And then of those 49, only 46 of them were relevant to sexual minorities. Of course, you realize that there are 3 decisions. The first decision, there are 3 decisions from the commission. The first decision came in 2009, 3 years after the Zimbabwe Human Rights NGO Forum, and it said verbatim what the paragraph 169 declaration, that is the Zimbabwe Lawyers for Human Rights and Journalists. Of course, there's also been the argument that this could have been made by mistake. It is somewhat surprising, and etc. etc. Yeah. Okay. So you realize that out of these 49 outputs, most of them which are really soft law outputs, I just want to talk about this. So there are three peaks in 2015, 2017, and 2023. Realize that most of these ones were really reactive. For example, in 2014, when Resolution 275 comes out, it was responding to the law that had been passed in Uganda, the AHA, and the violence that was going on in that period. When you look at 2023, the same thing, because there had been a law that had been passed, and there were really very many cases of violence going on at that time. We categorize these references along those categories because we also need to get against that, not every citation is necessarily important. Some of them are just passing, some of them are really bare mention. So we focused on categories 3 and 4. And we did all the analysis manually because of the unavailability of citation data. And as you can see, out of of course, there's also a difference between the outputs and then the citation instances. You may be cited in an output 2 times, and it's very peculiar when those 2 times are different. For example, in one output, there was an instance of supporting sexual minority rights, and there was an instance that was against sexual minority rights, especially that communique around where the commission refused to grant observer status to the 3 NGOs. And then in the same one, it was also considering an urgent letter to the government regarding discrimination of persons from, for their sexual orientation in respect of access to health facilities. So as you realize, of all of these, the 47 instances, we have 63.8% of them, which is a large majority of them being relevant and genuine doctrinal instances of citation of Zimbabwe Human Rights NGO Forum, which means that it holds an important position in terms of human rights, rights within the African human rights system. When you look at the table here, which is this one, yeah, I'm concluding. So the green, those are all the outputs. The red are the ones in 3 and 4, which shows that it still has a large share. The outputs where the decision has been engaged with, positively. And then the yellow is where the decision, where the African Commission has gone against sexual minority rights, like in the instance where they observed. So as you realize, that it has not been a straight line. We have had milestones and also a lot of pushback. The limitations, I talked about them earlier on, so I don't need to go back. And that then in conclusion, sometimes precedent can be made by accident. Thank you very much.
Thank you very much. Ladies and gentlemen, there were 5 gadgets here that he was using, and that's the reason why he went overboard. But thank you so much. Basically, what we have learned today is that sometimes a landmark status can come unintentionally. So for those of you who are still studying law, when you become judges, please also allow the Holy Spirit to lead you in making decisions. On that note, let's call upon Titi Mowos to come and make his presentation. Over to you, Titi.
Good morning, everybody. My name is Taklap Turkamos. I am a PhD student at York University in Toronto, Canada, but originally from Eritrea. Today I'll speak about Belgium v. Tunisia as a landmark judgment that redefined constitutional democracy in Africa. So as an outline, this paper is organized into 5 parts. First part speaks about background. Yeah, here basically I'll speak about Tunisia's constitutional trajectory. And the second part is the theoretical framework within which I try to deal with this case, and that's modern constitutionalism. And the third part speaks about the African court's reasoning, and there are some 4 subparts here. And yeah, the fourth part is the main part of the paper, which speaks about what makes this judgment landmark. And then I will speak about the broader implication of this judgment for other African member countries, and then the conclusion. So as a background, there are some important timelines in Tunisia's constitutional history. First one is 1861. This is the first written constitution in their world. That constitution established the Supreme Council, which was meant to check constitutionality of laws. And the next constitution is the one of 1959. And this constitution followed the French Fifth Republic, the example of the French Fifth Republic Constitution, which intentionally intended to establish the dominance of the executive. And then we have this long period of President Ben Ali's rule, which continued the same constitutional model, but reintroduced the National Constitutional Commission, but with only advisory and non-binding opinions. It didn't have the real power to check the constitutionality or to block unconstitutional laws. And then we have the 2011 revolution, which significantly shaped the country's political, legal, and institutional trajectories. And as a result of this revolution, the 1959 constitution was suspended, and the parliament was dissolved. And then we have the latest constitution, which is a 2014 constitution, which was the result of the 2014 revolution. This constitution is widely regarded as democratic and progressive. It's enshrined a new model of constitutional control, and it expanded the rights protections. And it provided for the establishment of constitutional court, which was intended to check constitutionality of laws. Then follows the 2011 crisis, which is the source of the case under consideration. In 2021, the president dismissed the prime minister and suspended the parliament and lifted all parliamentary immunities of parliament members. And Yeah, and concentrated almost all government power to the executive, effectively the president, to himself. That is this is the trigger point for the case. And the alleged violation was that the Tunisian lawyer who brought the case to the African court alleged violation of the right to self-determination, that's Article 20 of the African Charter, and the right to participate in public affairs, that's Article 13 of the African Charter, and the right to access to justice, Article 7 of the African Charter, and also the violation of states' general obligation to protect human rights that is contained under Article 1 of the African Charter. And to better understand this general situation, better analyze the case, I chose to look into it under the theoretical framework of the theory of constitutionalism. Yeah, so I'll not talk much about the theory of constitutionalism for the sake of time. I'll proceed into the court's reasoning. So there are four parts that I want to discuss here. One, jurisdiction, and two, admissibility, and three, the merits, and four, the remedies. Yeah, sorry. Under jurisdiction, Tunisia argued that the court does not have jurisdiction, and the objection was based on two grounds. First ground was that the application does not relate to any violation of human rights, and the court's response was that no, it does relate to human rights because any claim that concerns the interpretation and application of the rights and of the Charter and other relevant human rights instruments that are duly ratified by the respondent state, by the state concerned, are can be subject of jurisdiction by the court. And the proof of alleged violation is irrelevant in determining whether the court has competence to hear the case or not. And the second objection was based on infringement of national sovereignty. And here, Tunisia argued that the application infringed its national sovereignty, and specifically says it violates non-intervention principle under Article 2, Sub 7 of the United Nations Charter. The courts again rejected this objection, and the reason was that the reason the court gave was if a state ratifies international treaty and other instrument that establishes international tribunal, it is an expression of will or consent to voluntarily cede parts of its sovereignty to that tribunal. So Tunisia, by ratifying the court protocol, has ceded part of its sovereignty and submits itself to the jurisdiction of the African court, so that Tunisia cannot effectively claim that this is a violation of national sovereignty. And the court also noted that this is in line with Article 2 Sub B of the Vienna Convention on the Law of Treaties, and it also aligns with the court's previous position on similar matters. Another point here is admissibility. And again, Tunisia object that admissibility based on two grounds. First is public interest or lack of standing. And again, here the court rejected this, and the reasoning was that individuals can bring a public interest case without without being required to prove personal victim status. They're not required to show that they're affected by that specific violation. Public interest or actio popularis can be a ground. The second objection was based on non-exhaustion of local remedies, and this was again rejected by the court because as the court reasoned, the institution that was supposed to check the constitutionality was not established or was not present in the country's judicial system, and applicant is not required to exhaust a remedy that does not effectively exist. On merits, the court found three violations. The court found that the right to participate in public affairs was violated, and the right to be heard was violated, and states' obligation to protect human rights. That is, Tunisia failed to provide the legislative ground that would enable the protection of human rights. And on remedies, the court ordered the repeal of the presidential decrees and operationalization of independent constitutional court and the return of constitutional democracy within 2 years. With this background, I proceed to the theme of this paper, which is what makes Belgique or this judgment a landmark judgment. But before that, I would like to say a few words on what constitutes a landmark judgment entails. And as discussed by previous presenters, it's that the definition of landmark judgment and the criteria for identifying a judgment as landmark are subject to a lot of contextual factors, and here I will outline four points that make this judgment as landmark. The first is expansion of jurisprudence. This case was the first case that addressed comprehensive constitutional breakdown that was brought before the court. Of course, the court had dealt with other constitutional crises in previous judgments, like in Mitikala versus Tanzania, where the court decided on constitutional issues that limited the participation. And there was also another case, XYZ versus Benin, and this was on electoral procedures. But this case, the current case, that's Belgique versus Tunisia, deals with an overall constitutional breakdown. So this makes it this is one point that makes it landmark. And the other point that makes it landmark is assertion of authority. The court asserted its authority to check executive powers. So historically, the court prefers to limit itself, not to go deep into domestic political matters of the states involved. But in this case, the court went deep into the subject matter and Yeah, and reviewed the legality of the exceptional part, the legality of the decrees that were decreed by the president, and assessed the constitutionality of these decrees and ordered their repeal. So this was significant. This was significant move from its previous position, like which can be described as judicial restraint. And the remedy is also different. Previous remedies were somehow limited, but this remedy, the remedies that were ordered in this judgment, moved beyond adjudicating isolated violations of constitutional provisions into addressing structural conditions that necessary for restoration of constitutional order and human rights protection. So this was not limited to specific violations. It rather went further and addressed the overall crisis. And the next part will cover the broader implications of this judgment for other African members. And here, the first implication is deterrence. I think this can send a message that exceptional measures or emergency powers cannot dismantle constitutional governance. Of course, this is a little too optimistic given the reality in Africa, but it still can, at least theoretically, it can send a message that executive overreach is not beyond judicial oversight by the court. Does that have risk? Yes, it does. There are the immediate risk can be political backlash, including withdrawal of Article 34, sub 6 of the declaration. As we know, this declaration allows individuals and NGOs to directly access the African court. Without this declaration, individuals and NGOs do not have access to the court. Cases have to come through the commission to the court. Otherwise, individuals cannot directly take governments to the court. So if this declaration is withdrawn, then that means individuals cannot directly access the court. And there is some statistics here to show the importance of declaration of Article 34 sub 6. Out of the 366 total contentious cases brought before the court, 338 were filed by individuals and 24 were filed by NGOs. And this is 98.8 of the total cases that were brought before the court. So if these declarations are withdrawn, that means the jurisdiction of or the relevance of the court can be significantly crippled. So this is a major risk. And what influence can this judgment have on domestic courts? Well, as I said, domestic courts are supposed, at least theoretically again, to cite or to refer the jurisprudence of regional courts. So in this case, if at all, if a domestic constitutional court is to refer the jurisprudence of the African court, this can be a strong reference to check executive overreach. So overall, this judgment was a pivotal moment in African regional jurisprudence, which expanded the court's role in safeguarding constitutional democracy and human rights in Africa. And it sets a benchmark for assessing system governance failures and affirms the indispensability of constitutional order for the protection of human rights. With that, I thank you.
Thank you very much, Titi, for that very interesting presentation. Here we see the landmark status of a judgment coming with serious risks, especially in the African Human Rights Commission. So let's hear the last but one speaker who will be speaking to us on the litigation for the record, the African Commission, Abubakar Ahmed decision as a landmark for strategic litigation and grassroots mobilization in Ethiopia. Halifat Aye, please take the floor.
This, this. Okay. Good morning, everyone. Okay. Very short. Thank you. Hello, everyone. Good morning. My name is Halifat Mohammed Yusuf. I am a law lecturer at Wolo University in Ethiopia. I used to work as a former human rights officer for the Ethiopian Human Rights Commission and currently doing my third master's in Global African Studies at the African Institute. I'm very grateful to be back here at the University of Pretoria. I think the first time where I came here was exactly 10 years ago when I was competing at the 25th African Human Rights Moot Court Competition. I was a third-year law student, but it's really great to be back here, and thank you for the invitation. My presentation for today will be on litigating the record on Abubakar Ahmed case, and what I will be presenting for today is how can we see Abubakar Ahmed case as a landmark, as a positive as well as negative landmark for the African human rights jurisprudence. So my presentation is situated within the panel theme of landmark as contestation. And I think this theme is particularly important because it allows us to think beyond the traditional view of what a landmark case is. And in addition to this, it also allows us to understand landmark judgments as not simply cases that establish new legal rules or provide or create doctrinal innovation for that matter. And instead, in my presentation, what I'm trying to do is to ask what makes a judgment landmark in a human rights context, and to be very specific in the African human rights context. So that's one. Is it all these legal principles it creates, or can a judgment also become landmark because of its political, social, and most importantly, historical meaning it carries, which takes us to this case. So as you can see, when we talk about landmark judgment, so the first session talked about landmark judgment as bringing doctrinal contributions. But then when we talk about landmark judgment, I think it's very important to consider that this status can also come from contestation. And why I say contestation is because it can come from struggle over whose voices are marginalized and recognized, how state power is challenged, and most importantly, how law can become an instrument or a space where marginalized communities seek accountability, which takes us to Dimzatini Sama. So Dimzatini Sama in English, which means let our voice be heard. It is one of the strongest I would say, first ever peaceful protest that happened in Ethiopia that was organized by Ethiopian Muslims. And the reason why it was organized by the Ethiopian Muslims which was basically to challenge and stand against government interference in religious affairs. So the case emerged from the activities of the Ethiopian Muslims movement, Sama, who raised concerns about concerns relating to religious autonomy, states' interference in religious affairs, and most importantly, constitutional rights. So what they did is they pursued peaceful advocacy, dialogue, as well as negotiation before the dispute eventually turned to or entered the criminal justice system. Here, the applicants are members of the Muslim Arbitration Committee who were arrested and prosecuted under Ethiopia's anti-terrorism proclamation. They eventually challenged their case or their treatment basically before the African Commission and the alleged violations of several rights protected under the African Charter, including freedom of religion, freedom of expression, association, and assembly, and most importantly, fair trial rights. And then the African Commission ultimately decided or found violation on almost all the major claims that was presented by the applicants, which makes the case basically significant within the African human rights jurisprudence, especially for cases related to freedom of religion and states' non-interference in religious affairs. But having said that, what makes a judgment landmark, especially in this circumstance? So landmark status is usually measured by either doctrinal innovation, such as creating a new precedent, clarifying rights, and advancing doctrine. However, having said that, I think the criteria are very much contested. Tiklab has also presented his perspective because when we talk about landmark status, it's very complicated. But most importantly, you do see doctrinal innovation, remedial effectiveness, and the ruling's broader social or political impact. But the problem is when we talk about landmark judgment, the traditional view is very much limited to change in the interpretation of existing laws, establishing important legal principles, influencing future jurisprudence, as well as shaping social and political understanding. In my presentation, what I will try to do is to show the significance of Abu Bakr Ahmed case, because the significance lies in the tension that it reveals. When I say tension, I mean the difference between recognizing a violation and providing effective remedy. So having said that, my presentation broader view or objective is to, one, validate marginalized group, because again, the case began with a social movement. It came from a group or a community that was previously framed through security lens, but then eventually got recognized, legal recognition as rights holder by the African Commission. So my key argument is, it's not that Abu Bakr Ahmed case is landmark because it introduces the most transformative legal doctrine, but because it demonstrates how grassroots movements contest state power through law, the African Charter, and convert a political struggle into a recognized African human rights claim. So having said that, you can see the contested significance of this case, because this landmark cuts both ways. It's a positive landmark as well as it's a negative landmark. And the reason why I say that it's a positive and negative, which I will be talking about in the coming slides, but in case I don't have time, I think it's very important to talk about the positive aspect of this case as well as the negative aspect of this case. So the positive aspect, yes, it provided legal recognition for the victims, one. Second, it validated grassroots grievances that has lasted for a long period of time against Ethiopian Muslims in Ethiopia, and contributed to African human rights jurisprudence. In particular, it affirms that counterterrorism measures that is usually taken by the government cannot serve as a pretext for suppressing legitimate civic or religious engagements, which is a good thing. But then you see the negative aspect, and the negative aspect or the negative landmark demonstrates that recognition of violation does not necessarily translate into a timely and effective remedy, especially when there are unresolved torture claims. So when I was talking about the case, I said that the applicants won on almost all counts, on all claims, except for torture, which is interesting because Ethiopia has obviously admitted in the 2019 UPR report that it has committed torturing activities against the Ethiopian Muslim Arbitration Committee. Not only that, even in the 2024, the periodic report that was submitted to the African Commission, it was clearly documented that torture has been committed by the government, and not even that only. The Prime Minister of Ethiopia, Dr. Abiy Ahmed, publicly admitted expressly in the parliament that torture was committed. But guess what? The African Commission stated that there is no compelling evidence that has been produced to support the allegation of torture. Now, the problem with this is the African Commission was highly dependent on the local proceeding. So the local remedies that was taken in Ethiopia, which of course they wouldn't say that that the government has committed torture-related activities to the victims. So that's one thing. The second thing is when it comes to the delayed justice, and the reason why I say delayed justice because the African Commission received the case on October 2013. The African Commission decided on this case between February and March of 2023. So almost after 10 years. And then, of course, the decision was published in 2025, so last year. So you see the 10 years gap. And the other is effective remedies. There was no effective remedies that was provided for the victims, so that's one problem. But the other problem is the African Commission ordered the Ethiopian government to amend the anti-terrorism proclamation. The thing is, Ethiopia has already amended the anti-terrorism proclamation. Ethiopia amended the anti-terrorism proclamation in 2020. This case was decided in 2023. 3 years before this case was decided. So you do see why it is considered as a negative landmark decision. Because it's positive since it demonstrates the power of strategic litigation and also social movement and the regional human rights mechanism to validate marginalized claims. But then it's also a negative landmark because it reveals the continuing gaps that we see, especially in regional human rights education, the gap between rights recognition and providing meaningful justice. But then what makes the Mtsachini Sama, Let Our Voice Be Heard, or DY, I would say, different? Why can it be considered as a landmark decision? Because one, it has a jurisprudential contribution because it clarifies or expands the application of the African Charter on cases related to counterterrorism legislation, religious freedom, as well as freedom of expression, association, and assembly. And it also reinforces that national security measures remain subject to regional human rights scrutiny. On the other hand, which is very much important for us, especially in Ethiopia, is the socio-political significance, where you see how it transforms the grievance of social movement or grassroots movement into an authoritative regional human rights claim. The second is it obviously provided an institutional recognition of marginalized voice, but most importantly, created a historical record of state action and state accountability. And most importantly, it has also demonstrated the role of strategic litigation in challenging the state's narrative. So if I say that for the introduction, I think it's important to kind of define or discuss about what makes a judgment a landmark judgment. How can we understand landmark judgment? But then when we're talking about landmark judgment, I think it's very important to try to connect it with strategic litigation, because when we're doing strategic litigation, the primary goal or the ultimate goal is not just limited to receiving remedy, because strategic litigation is about a process through which social resistance enters the legal system. In addition to this, if it enters the legal system, the resulting consequences or the judgment will become a landmark because it records, documents, and most importantly, institutionalizes a struggle that has originated outside the formal legal institution. So we can see it from a three perspective. You have the legal perspective, the institutional perspective, and the social political perspective. Sama, which is the Ethiopian movement who moved from protest. It started as a protest, and because of Sama, by the way, the former Ethiopian government, I would say, was overthrown because it started with Sama, then it moved to the Kero movement of Oromo youth, and then the movement that happened all over the Amhara region. So we have, so basically, let our voices be heard is a grassroots movement, as I said, who were organized for religious autonomy, constitutional rights, claiming the right of freedom of religion and the right as Ethiopian citizens, and most importantly, non-interference in religious affairs, because what the Ethiopian government was doing at the time was introducing a new sect of religion. No, I wouldn't say religion, maybe doctrine, a new sect of Islam religion, which came all the way from Lebanon, and the government tried to impose a modern kind of Islam on Ethiopians, which of course they didn't accept. And they started to peacefully mobilize and protest rather than offering a political opposition. But then you see how the African Commission provided an institutional acknowledgement to a struggle that originated through social mobilization. And this is where exactly the landmark aspect lies, because it started from being a grassroots mobilization to a structured movement, domestic legal failure, because the Council of Constitutional Inquiry was ineffective. One of the key arguments that happened for the African Commission was, is a case admissible like before the African Commission? Has the applicants exhausted all the local remedies that was in Ethiopia? Then what happened is the African Commission stated that yes, the local remedies is available, it's effective, it's sufficient. But then what happened is, because the question was also a constitutional law question, whether the anti-terrorism proclamation is in line with the Constitution of Ethiopia as well as the African Charter. So the Council of Constitutional Inquiry and the House of Federation, both who are a political organ, are the one who has the power to provide constitutional interpretation. And they are both not a judicial body, but a political body, which means that they are biased, they're not independent, they are easily pressured to make political decisions, which is why it took them almost, I think, 6 months, and they didn't provide any interpretation when it comes to the Constitution, which is why the African Commission deemed it unduly prolonged, because it was delayed. And because of that, the case was deemed admissible to be presented before the African Commission. But before doing that, there was also a criminal trial that was proceeding in Ethiopia, where the applicants were sentenced to 22 years in prison, which takes us to the regional litigation or the claim before the African Commission, which was taken on 4th of October 2013. Okay. So moving to the case before the African Commission, facts, admissibility, and merits. So the facts is, there was arrest of committee members, the Muslim Arbitration Committee. They were charged with terrorism. There was allegation of violation, and they were prosecuted under the Anti-Terrorism Proclamation number 652/2009, but which was amended in 2020 later on. The key question when it comes to admissibility was regarding the domestic remedies, which the African Commission deemed ineffective. And eventually the Commission reaffirmed that remedies must be effective, but not merely formally available. The merits stated that applicants succeeded on almost all substantive claims: liberty, fair trial, religion, expression, association, and assembly. But unfortunately, the torture claim that was clearly documented, expressly admitted by the Prime Minister, was not established. Yeah. So I think I'm gonna pass this or try to explain it in 1 minute. So what the judgment achieved is, again, validation of grassroots grievance, creation of historical record, and contribution to jurisprudence. in terms of advancing debates on religious freedom, counterterrorism, civic participation, and the limits of state power, what the judgment has uncovered is the recognition of rights without remedies. That's one. Second, delay and changing context. One of the key informants I interviewed told me that it was easier to overthrow a government instead of waiting for the African Commission to decide on this case, which was really interesting and somehow true. And then you have the torture claim that was left unresolved. Conclusion, rethinking landmark judgment. And again, I will go back to why I argue that the Abu Bakr Ahmed case is a landmark case, because I believe that it should be evaluated from both a legal and social political dimension. Because when we talk about a landmark judgment may be landmark because it's changed a certain law or even a doctrine, but it should also be considered as a landmark because it changed whose experience become legally recognized. And with that, I will conclude with a picture from the Salat man, who is a symbol of resistance for from the Zachnisa mass movement. Thank you.
Thank you very much. So here we see the documentation of truth being a landmark in and of itself by an African court. So that is very interesting. Ladies and gentlemen, we do not have time. It's because of the tea time that we spend more time during coffee. But that is not my problem. I will give the last speaker 15 minutes to make his presentation, and then we are going to entertain maybe one or two comments, and then we'll have a discussion. Thank you. Over to you, sir.
Thank you. Thank you, Chair. And thanks to those who made this possible. We don't take it for granted. So ensure that we have a platform to share our ideas. I am Tarisai Mutangi from the University of Zimbabwe. And I am going to begin with the conclusion for two reasons. Number one is that I don't want to get into trouble with the chair. And secondly, if you check your program, you'd see that the Ogik decision appears 3 times. There are 3 speakers who speak on this decision. So on that basis alone, I think if the organizers agree that this is a landmark decision, so the job is already done by that acknowledgement. And the conclusion is as follows. The landmark status of the Ogik compliance judgment is contested. Now, that's our theme. When I first reviewed this particular decision or judgment, I thought it was an outright landmark. But when I went through it and pondered more and more on it, I realized that perhaps there are a few opportunities that are not clear or that were missed. And therefore, perhaps as my sister said, negative landmark. I mean, that's what we want to hear in these conversations too. Let's have those new ideas about landmark. Landmark, can it remain traditional or understood in the traditional sense? Because I also have a question to say, from whose perspective is a judgment landmark? Is it from you and I, the scholars, who want some jurisprudence to keep writing and express their views as we're doing here? Or is it the litigant or the lawyer, the representative? Or from the perspective of the victim, is it a landmark? in what sense is it a landmark? So perhaps, some of these things will be teased out. The aspect of the OGIC compliance judgment I am going to deal with is simply the compliance hearing that took place on the 4th of June, 2025. And I draw pressure from that because even Franz, who is here, is also part of that process. And I'll disagree with him on certain issues in spite of him being my supervisor. It means that I've come of age, isn't it? So my colleagues, other colleagues, and I have avoided to, to look at their papers so that I don't influence my presentation. I'm sure that they'll talk about the landmark status of the OGIC decision on substantive issues, the recognition of the rights of indigenous people, and so forth and so on. I think it's a landmark in that sense. But my focus is on that final lap, if you like, in the litigation process, the logical conclusion of litigation, which is implementation of decision or judgments of our human rights bodies. It is because of that implementation that the principle in the Joseph factory case, which is that reparations must, as far as possible, reverse all the negative consequences of a violation. And that is a lap where we'll be talking about implementation of those reparations. The giving of reparations in a substantive judgment may be a landmark conversation. How about the last bit, which is the implementation itself? So perhaps the landmark nature of this comes from the fact that, of course, this is the first time that the African court, not African bodies, but African court convened a compliance hearing. That was a momentous occasion for that reason. But the procedural elements that came out of it, which were then addressed in the judgment itself, is the focus of my contribution. Why are we fussy about implementation? It's obvious. It might amuse you to know that only 2 of 104 decisions, or probably 110 now, of the African court have been fully implemented. Only 2. Fully, and by probably one country, one state. Only 2. Is it Burkina Faso? Yes, it's Burkina Faso. The Konate decision, the Zongo, only 2. The rest of them have not been implemented. And there are even some states making public declarations that we are not going to implement publicly. I'll leave it to you to research. You think I'm targeting your country. But there are states that have made public declarations that we are not going to implement your decisions or decisions of the court. In spite of that resistance and pushback, you have the African court being courageous to say, we are going to draw out one of them publicly to have a conversation about what is delaying implementation, what challenges is that state facing in terms of implementation, and that is Kenya. And of course, Kenya did not resist that invitation. It participated throughout, and I think it will continue to participate, and that is a good sign. So implementation is a big problem across the continent, not only the African court, but African Commission decisions, the Committee of Experts, and so on. So this is the dark background, if you like. Is the context in which this compliance hearing came. What else can anyone else who has courage do to show progress in terms of implementation? what kind of challenges are states facing. So all along, a court will render a decision and expect a state to file reports reporting on the extent of implementation. Some have never done that. Some do it twice, once, and then they forget about it, just like they do with state reporting. So here is a court or human rights body in the dark in terms of what is exactly happening in that particular country in terms of implementation. So the compliance hearing was one opportunity to publicly converse with the state and get to understand, hopefully they did through that conversation, what are the challenges Kenya is facing. And the hearing is on YouTube. If you have time, you can look and listen to it. And it's an opportunity for a state to be able to look at the challenges that states are facing, which is a rare opportunity for a court to do that. Like I'm saying, in many cases, our bodies are paper-based in the sense that they receive complaints, they rely on information on the papers without any first-hand information or conversing with state actors. But what makes a compliance judgment a landmark? So I'm limiting it to a compliance judgment, not just a judgment in general. But in that specific area of compliance, what makes it a landmark? And then we can test whether this one qualifies. Number one, it must leave readers with no doubt as to how to initiate a public hearing. Under what circumstances would a court convene a public hearing? Who has the right to ask for it? In this particular case, did the applicant ask for it? Or was it at the discretion of the court? Or can a victim themselves ask for it? Or even any other interested person ask for it? Number two, perhaps the most important, is jurisdiction to convene one. Does the court have jurisdiction to convene a public hearing? How about participation of amicus? There's an amicus who could have been part of the legal proceedings from the beginning. But are other amici allowed to join at the stage of implementation or compliance hearing? Or there's limitation to that? Thirdly, state delegations and their composition. There's a group of lawyers representing the state, comply with the requirements of the state delegation for purposes of a compliance hearing. And then the role of victims, the most important. What is the role of victims in that particular hearing? And of course, at the end of it, what sort of new orders will come out of that hearing? So, if you want to call this a landmark judgment, it is because the court was very clear in terms of its jurisdiction to deal with compliance hearings. At national level, once a court has rendered a decision, it has rendered its obligations. It's left upon another arm of state to take it over for execution. But the uniqueness of national litigation is that a body like a court, a committee or commission still remains interested, actively interested in ensuring that there's execution of its decisions. And in this case, the court was very explicit, but I should just put a footnote to say it was because the amicus had to say, can you say something about your jurisdiction as far as these issues are concerned? Why? Because where this procedure was formed for the first time in the Indo-American system, one country called Panama contested the competence of a court post-judgment jurisdiction. And that court was very clear, and it's exactly how our own court also followed in terms of that jurisprudence to say, we have jurisdiction, not only jurisdiction to convene, but also jurisdiction even to render provisional measures in the course of implementation. You can see that the court is still actively involved, can even order provisional measures to deal with issues that arise during implementation. Probably that's all that we can actually glean from the court itself, from the decision itself as far as this issue is concerned. But like I said, we owe it to the court to be brave enough to convene this hearing for the first time, in spite of the circumstances of the environment or the context in which it is operating. So, but the rest of what I'm going to tell you now, as I already come to the conclusion, are what I call missed opportunities that I would have wanted to read in a landmark judgment that is on a compliance hearing. You will see that the issue of timelines for filing of information by the parties before the hearing, it is an issue that is left unaddressed. Why am I concerned with it or about it? It's because some of the information was filed a day before the hearing. So the question is, how was the court able to verify, the content of that information to ensure that there's a meaningful engagement with the parties during the hearing? So I expected that probably the court would then address this issue in the judgment to say, in future, this is how the filing of information should be dealt with, ensure that there is ample time for the court to deal with that information, verify it, and have meaningful engagement with the parties. Number two, the composition of delegations. So the critique comes from the experience that has come from elsewhere. I ask the question to say, is lawyers or legal representatives that represent the state good enough or sufficient in terms of who should be in the delegation to speak to the question of implementation? When you look at the decision, it talks about national actors that were key to its implementation, the Minister of Lands, and the task force established to oversee its implementation, and so on and so on, and the Land Commission itself. So what has happened elsewhere is that delegations from state parties would come with lawyers and other national actors, so that the conversation with the court is based on what is exactly happening on the ground and those actors that are on the ground. We are not saying the court will not do this in future, but the expectation was that this issue could have been canvassed in the decision itself so that it provide guidance going forward. The question of victim participation. If you look at the YouTube, victims were actually introduced, some of them were introduced by the lawyers to the court. This so and so from the Ogig community, this so and so, but that's all what has happened. So they continue to address the court through the lawyers, as they have always been doing during the litigation process itself. Again, I'm not saying in future the court would not want to hear directly from witnesses. I said it's a paper-based court. Of course, witnesses may also be called, during litigation to give evidence, but it's a paper-based court. Who is better to articulate the impact of a violation than a victim, herself or himself, rather than doing so through their lawyers? So in the American system, they have perfected, if you like, this procedure to ensure that victims are able to directly address the court on the impact of that violation. Not only that, but also on the extent of measures adopted to implement those reparations. Finally, I was looking at what kind of new orders did the court render after conversing with the parties. Are these new orders acknowledging clearly what has been done to implement and what is still outstanding in terms of implementation in a measurable way? Or simply an acknowledgement to say this has not been done and still needs to be done? So I ask myself, is this a new list of old orders that you find in the compliance in itself? Repetition of reparations as they are, in the judgment on the merits and also on the reparation judgment. So again, I'm not saying that the court will not, in the next phase of these hearings, sit down and agree on specific time frame, not the global time frame to say after 6 months you should do this, but specific time frame for specific measures that need to be adopted in respect of each reparation, so that the implementation itself is measurable and can be traced. The rest of the issues are there in the paper, but again, I come back to the same conclusion to say that for being the first judgment dealing with compliance hearings and dealing with some critical issues that pertain to this procedure, the judgment could grudgingly qualify as a landmark. But what I say is that we are going to probably have to read a few more judgments on compliance hearings until we really get what we call a landmark judgment that establishes this procedure for the court and guides parties in future similar proceedings. I end here and thank you for your attention.
Thank you very much, Tarisai, for that very interesting presentation. In view of the time, colleagues, I would like to invite comments from the floor and also comments online. So I do have a discretion of how many people I'll be pointing at. I see the gentleman wearing a nice gray suit on the floor, and then online, do I see any hand up? Not as yet. So I will give the two gentlemen that I've just seen, the gentleman in gray and the gentleman in a shirt. Thank you. Just make it briefly. We'll start with the gentleman wearing gray. In that order, please.
I'm Chofo Che from Cameroon. My question goes to Teke. He presented on an issue which I'm very passionate about, constitutional democracy in Africa. I wanted to know, concerning this case, if it establishes a vital legal baseline for democratic governance, especially with respect to the broader wave of unconstitutional changes of government and democratic backsliding happening across other regions of Africa, or is its impact just felt in North Africa or Tunisia? Thank you very much.
Thank you very much. Gentlemen.
Good afternoon. My name is Anthony. I didn't want to specifically speak right now because I'll be talking to you in the afternoon on the OGEC matter. But however, just to engage with what Tarisai has said, because I'll not be dealing with procedural aspects in the afternoon, the issue of the lateness in submission of the report at the hearing, at the compliance hearing, perhaps would not be such a worry that it was submitted late, because then the court had time between July and when it rendered its decision to interact with the material before it and then make a decision as to compliance. And to me, actually, it also gives more ground that this might be an afterthought of the Kenyan government, and therefore a stronger case for this is why you've not complied. And then when it comes to victims, I think that issue was addressed at the reparation stage, where there were witnesses as to the nature of the OGEC people, their lifestyle, and therefore had an impact in as far as reparations were concerned, the monetary reparations. Just a small comment. I think I'll give the other ideas in the afternoon.
Thank you very much. He did mention that he was not intending to speak. So the third speaker, briefly, I don't see any ladies raising their hands. All right, I've seen one, and please, gentlemen, bear with me. Let's try and be as inclusive as possible. Yes, sir.
Thank you. My name is Trésor. My question, I think, goes to TT on the Belgid case. I didn't really see the uniqueness of that case compared to other cases that came before it, like against Benin, Sébastien Javon in December 2020, Nudewenu, XYZ, which also spoke about the very same issues, the African court speaking, entering into dialogue with the Benin Constitutional Court, the African court clearly clarifies standards on elections and all the things. So Belgid mainly drew its inspiration from those previous cases. So I didn't see why you focus on that case while we have previous cases which developed those principles. The second question linked to it is, you will realize that Belgid is one of those cases that made Tunisia to withdraw its 34-6 declaration. And the same thing, XYZ, Ajavon, Nudewenu, pushed Benin to actually withdraw its declaration. So what do you note from that pushback when the African courts get involved in domestic constitutional matters? Most countries are really reluctant. What can we learn from that trend and tendency? Thank you.
Thank you, Trezo. The lady over there from Egypt.
Hello, thank you so much. My name is Aya. I am part of the HRDA program. At the risk of being a little bit repetitive, what are the recommendations that the panel can suggest for the implementation of those specific reparations that you are requesting? Like, there are some scholarly writings that did recommend a dedicated implementation unit or a working group within the framework of the court or the commission. Like, one, how feasible do you think this is? Two, are there any like recommendations within the general atmosphere of the lack of political will as well and the sovereignty of the state? Thank you.
Thank you very much. I would like to hand over to the presenters to just address the questions that have been posed. And then let's see how far we can go. If there is more time, then I will give the gentleman front. Briefly. We need to be out at past. We have just less than 10 minutes.
Thank you, Chair. The question raised by my colleague Anthony there. So the late submission of information was not fatal. So the point that I was making is that the nature of a hearing, a compliance hearing, is for the court to internalize the issues that the state is going through in terms of that small progress or that big progress in specific areas. How is it finding that process at the national level? And the court will be hearing that for the first time in that report. So my point is, if it receives the information today, does it have enough time to ponder on it, to deliberate on it, so that it can engage constructively with the parties the following day? They had time to then ponder on it on their own, with no one to ask after the hearing. That's the point that I was making. There's a rule in adjudication to say, if you're a judge and you have a question, ask the question when the parties are still before you. Otherwise, you will struggle that question on your own, because you have no reference, you have no one to ask to clarify it for you. So that's basically the point that I was trying to make there, to say that the second one, the issue of victims, addressing the court during reparations. I have no problem with that. And it was important at that stage what sort of reparations were appropriate for the violations. But here we are now at that implementation period. What has been done? What is outstanding? Victims are better placed to address the court on that as opposed to their representative. That's the point that I was making. Thank you.
Thank you.
Sure. Thank you. I think I would like to go with Aya's question. Thank you so much, Aya. I think, first of all, it's very important to also note that the African Commission was actually the only educating body that has conducted a comprehensive examination of the merit of the case of Abu Bakr Ahmed. But then I think for the way forward, and I might be very bold in stating this, I think the way forward is for the commission to revisit and correct its decision in light of especially the unresolved torture claim. And the reason why I say that is if we want to convert it from a maybe flawed outcome into a positive precedent, I think it is that would be the way how we can advance justice for the complainant through a reasoned and evidence-based argument, because it was wrong to depend on the local proceedings for the allegation when it comes to the torture claims. And this also shows how I think unresolved torture allegations indicates that even a largely successful human rights cases may leave important dimension of the victim's experience without any, comprehensive legal acknowledgement. So yeah, I hope I answered your question. Thank you.
Thank you.
Yeah, I will start with the question regarding the uniqueness of the judgment. Yeah, I think this is unique. I also touched it in my presentation briefly. That is an extension of the two cases that dealt with constitutional issues. One, Tikala versus Tanzania, and the other XYZ versus Benin. This case also touched on constitutional matters, but the context is different. In these cases in Tanzania and Benin, there was functional constitutional system. There was functional system. And the issue was regarding isolated violations of constitutional principles, constitutional provisions rather. In the case of Tunisia, however, it is regarding a complete constitutional breakdown. And in the context of non-existent, I would say, non-existent system. The system was completely broken down. So this makes it unique. And yeah, the context, the country, the system, the context that brought about the cases is also different. This was brought following a revolution, and the other cases, the context in the other cases are different. So there are many distinctions that we can go through, but for time reasons, I was very brief. And regarding the withdrawal of Article 34 sub 6, yeah, states are withdrawing, but withdrawal of states, I guess, does not have anything to do with the landmark nature of the case. It's different. Although it's unfortunate, it signifies the relevance of the judgment, I guess. The judgment is relevant. It is addressing very critical issues and I would say being hard on the governments, and that's why they're withdrawing. And they don't even give like convincing reasoning in their withdrawal. The justification for withdrawals are mostly sovereignty matters and other unrelated with the subject matter of the judgment. So I guess it still remains the judgment still remains landmark. But as I said, the backlash is there, and it's very dangerous backlash. It can cripple the court, but still, the court has to make a choice whether to be bold and assertive and be effective, or try to appease member states and risk irrelevance. In the case of Belgium, I guess the court goes for the court went for the first choice, and I think that was the right choice.
Thank you very much. Can I forego you, Uma, and ask Nosi?
I guess there was one question from that gentleman. Was it its impact? I think so far I can say there's no visible impact. Even the country itself, Tunisia itself, withdrew its judgment following withdrew its Article 34 declaration following the judgment.
All right, thank you very much. Nosipio, do you have a parting shot as we conclude? Nosipio online?
Yes, I'm still here.
Yes, please give us your parting shot just before our nicely cooked lunch.
Okay. Just to answer the lady who spoke about the lack of political will, it is an issue. But what I can say specifically with the abolition of the death penalty is, if our courts also force the issue, like adopt a human rights perspective, then I think abolition will follow course. Because in South Africa, the very same thing happened. We had S versus Makwanyana, that was in 95, 96, and then the death penalty was abolished. So maybe the courts do play an instrumental role when it comes to these human rights issues, and their interpretation has a greater weight.
Thank you very much, Nosipio. Ladies and gentlemen, my professor, Franz Viljoen, used to say that there is no glory in length. So which basically means that there is no glory in keeping you here for longer than what is expected. Let me thank all the presenters. They are wonderful presentations. Let me thank you, all the participants. And let me also thank those who are. At this point in time, I would like us to just come back at 2:30. Thank you very much for your attention.
Thank you very much to the panel. Just one moment. As we leave for the lunch, which will be just upstairs here, where I think other people, Olivia had their breakfast, we just ask that where the registration tables are, that we just assemble there. David, our photographer here, will take a position and take a family photo. So please, if the family can just, as you leave, assemble there, and we'll do the photo quickly before we take lunch. Thanks so much.
All right, let's make a move so that we can come back earlier. Yes, outside.
Are you doing this morning? They're on their lunch break. Or these were the case. Yeah, it's 1:30 there. Yeah. So 8, 9, 10, 11, 12, 1. Oh, no. Yeah. Oh, you're wearing your shirt. Are they playing tonight? Yeah. Is Poppy wearing his? He's wearing it on top down. Yes, is he mom donning it?
He said he has a development lunch if you want to play it safe, which I think means he's wearing the top for sure.
Which means he's probably not wearing. Is that correct? You decided to not wear the jersey today?
No, I am. Just wanna have the option of taking it off during the day.
You really just want to look like a New York communist.
New York communist.
Not.
I can look afraid of you.
And I'm missing that. Yeah, yeah, no, it's-
You have a good meet healthy?
This person. I read an abstract about the graduate of the college. 2 years ago, first years say, hey, I wanna give money to, where do I give money? And they say, you know, this got public health, okay, go give money to the proposal.
I made coffee right
No. Thank you. So but and then he's actually found.
Like people might use.
He actually finds the scope of the papers.
What was he doing? Study.
What?
Study.
Stuff business. Undergraduate.
American blueberries. I suppose that they were moldy. Really?
You said they don't have to eat them.
Very warmly. Yeah.
So you know how
Fine.
it's being reported that the university wants to fundraise for open, like, intellectual diversity, whatever viewpoint diversity faculty.
We did it, when that was the.
Well, people are appalled about that, I think. How, oh, so apparently they are, right? So this guy apparently met with the president of Provost to talk about their idea of a of fundraising for endowing chairs with the goal of bringing to the university people who attend the university diversity.
Okay, maybe we don't let them get chairs.
No, but endowed chairs meaning.
Oh, endowed chairs.
Endowed professorships. And he was very interested.
So you have something.
And so he's very interested. He wants to donate to 2 such chairs.
So
But,
you're meeting with them today.
but he wants to make sure that if that at least one in scope of among, because he's decided that actually.
But isn't that kind of discriminatory to say that you're hiring somebody because they're have a conservative ideology?
I get what, like,
Like,
so
you're getting
anyway.
into you, I mean, I feel like it's.
I think it's gonna be.
I think there are ways to at least see more neutral by creating chairs for people who are researching specific areas.
Fine.
But you cannot go around looking for.
I assume.
We're only going to put Republicans.
No, I don't think that's gonna get, I think, and I think there's gonna be areas where some, it's here too. Like, bills, like governance.
Yeah.
Right, now. So anyway, so there, all of that, so I had been, that's where I was gonna be with this question, and I had been, we had met with the person. So I'm meeting for meeting with Andrea yesterday, and I got a phone, call, and I'm so glad I answered the phone, because I'm an unknown number, but it's probably the CPAC people,
Yeah.
whatever.
So you answered.
So I answered, it was,
This guy?
no, it was John Manning,
Oh,
like, oh, I'm glad I answered. Yes, John.
did you save the phone number?
Yeah,
Your
I saved the phone number.
Okay.
Take the phone number. Okay, now,
I don't know what the phone number this is, but
But
if this person calls you, I don't know who it is.
yeah, so it was not a university number. But
Probably his cell phone.
it is probably his personal cell phone. So, he called me, like, you have a minute? I was like, yeah, I do. Like, okay, I kind of write that.
You got John
And
Hicks'
he's like-
number?
Yeah.
He does.
And he says, so I wanted to talk to you, like, Alan Garber is gonna give them a phone call later today to talk about your lunch tomorrow. This person. And I wanted to talk to you about what Alan's message to Andrea should be. Like, okay. So it was about.
Alan doesn't
I-
know what his own message should be.
I don't know, but
Or
for
is it
some
just he
reason,
wanted you to also get the message?
I think they also
In
wanted.
case Andrea didn't quite get it.
Yeah, I think so. I think that was it. And then
She
he
had
made sure to
Or
remind-
3 different people tell you this, the same thing?
No. One person called Andrea and the other person
Yes.
with the same message.
Oh, Alan called Andrea.
They-
You need to be eating breakfast.
So he made sure to like, look, he's interested in doing this. So how would you think that would look at this? You know, it's very difficult to think about what intellectual diversity from the point of view means in the biostatistics department. I think it would be hard for them. But I can imagine that happening, for example, in health policy. I can imagine that happening. Let me think about it. But health policy. I was like, you can, but it's gonna be.
Very, very controversial.
It's gonna be difficult, like health policy, I said that, yeah. That would be it, that's an easy sell.
Environmental,
Like,
but that's controversial.
I was gonna, tough.
You can do it in other departments.
You can do it in
though.
a department,
Be more controversial.
and you do not wanna bring one person, spend all this money to bring one person. Only to have this fail.
Yeah. When people be hire internally?
No, they wanna bring people up. They wanna bring, for this thing, they wanna bring people up, let's say. But they decided that. As a body. Harvard University has too many families. They need to bring some serious people with the children from. To counter balance.
I think that's just a university issue.
I think that's just how university.
Yeah.
And so it's self-selection, it's several things, it's to some extent, it's self-selection. Very few people. Go into a career where they know they're gonna be. putting themselves in a situation where they're going to be earning less money than they would otherwise, in the same set of skills. Not all, but in general, that applies. Only because of the advantages that being an industry has, such as being able to have more time, spendings.
A lot of which you can do in like farming
Hmm?
and pharmaceutical,
Right,
which is equivalent training.
exactly, so. More, I mean, it's more clear in some of this, it's not gonna apply to lasts.
Yeah.
But it's gonna apply for things like economics. Even law. Oh, not exactly, but,
¿Qué me cuentas, Sanchich? Engineering. ¿Qué cuentas? Getting up to eat.
so people who,
Science.
yeah.
Life science.
Yeah.
Basically all sciences. All sciences and social sciences. And then not all social science.
But in general, like for a broad range of disciplines. If you want to optimize income financial gain, you would not choose them.
If you don't remember what the last time you brushed Sally's teeth. Yeah. Were you gonna brush them?
Well, the vet already told me that she's gonna have to be sedated and put under anesthesia and have her teeth.
I would just said that if we didn't get our act together, she was gonna have to do that.
No, the last time I saw him, he didn't say it when I went with you, but the last time I saw him, he said that he was definitely gonna have to do it. That it wasn't urgent, but that in the next year, sure. Because the problem is that she's got buildup underneath her gums, so no matter how much we brush it, we're not gonna be able to get like that.
You need a deep cleaning, Sally. Welcome to our people problems. And not more, not pressure, respect, you need some respect, please. Anyway, so.
We're still talking about this. Always be. Take you time to get out.
Yeah. It always takes some time to get anything out.
So anyway, so. Yeah, so I guess you wanted me to be prepared for. And support for that conversation, and then in the process, he managed to remind us that he found. The work that this is kind of like a answer and consequences of an inquiry.
Yeah.
A group that you were part of. I did mention this donor that you were part of that. It's like, okay, I know, okay, I know, yeah, like, I got it, now I know what role I'm supposed to play. So like, maybe I wanna have the option of taking yours, right? Okay. So appreciate it.
You don't want a talking point?
Hmm?
You don't want a conversation started?
Conversation.
Cessation. Ew. I thought you needed to go to
Yeah, I
work.
couldn't feel good.
You had to go and eat. Like Tanny? You didn't really let me get your teeth cleaned because you ran away. Sandy, come here. Actually, I spilled a bunch of food sugar. Hey.
Pick up.
I got her for, I got the really big one. Would be best friend again.
Eight. Yeah, I think you need to dig out there.
You know, you and Sophia have been home.
Was not that bad yesterday.
Scared of food.
Sophia. If we tell her to go to sugar. But it is Sophia.
Sophie, let's get off the toilet.
He's on her phone.
I know. I'm aware. That sounds like a fair.
Are you in a break? Oh.
They're in South Africa. Why is the soccer being? What?
This is not for me. It is
You can't aren't the breathing goal. I've gone up my.
No, the USA has like horrible chants, I will say. Like the chants are just, they sound so bad.
Oh, chance.
I thought
C-H-A-N-T, not C-H-A-N-C.
Like the chants are essentially, go USA, we're gonna win. Like it's bad.
No, it's not because it's not political, it's that I was concerned that it would make me look less serious. That's it. This the third of which we
¿A qué hora se hace el partido?
At 10.
Okay, so you're going to be ready to leave at 3. So if I were to leave the house at noon before you get home, I don't have to worry.
Very nice jersey.
Bella, Poppy, the jersey has embroidery on it. Bella, the jersey has embroidery on it. Yeah, it's quite fancy. Colombian one doesn't have embroidery. Yeah.
No, but it's the same.
It is, this is embroidered? Well, mine doesn't have embroidery. Or her look, around the patch.
It's a logo of the Federation of the
It is?
Yeah. Impact summer seniors, so. I gave it in 3 sheets. What I did.
It's been super hot in the rooms.
There's an article, I think in the Washington Post about why Europe, title is Why Europe is the most quickly overheating country.
Seems like every year there's something.
We are too, we're just not acknowledging it. Well, we're having horrible fires every year.
Yeah.
They're just trying to pretend that it's caused by something else.
No, so the way we're feeling wasn't for that last time.
Hey. And the government is trying to tell us that it's not.
So Harry, we're talking about here. So she takes a
Yeah, I think you should take it.
You're studying us all these things that are forbidden to do in Los Angeles. Yeah. Like, yeah, so that there's all these regulations for outdoor breathing.
I know, I really love it. I probably should have done this, like the keynote says.
What's that doing? So I haven't.
¿Qué pasó?
Yeah, después me pensé que había, that there was a finding that says that some sort of.
Oh.
Like,
It's
here's
just
a
Sophia's bait breakfast. Not a fire, right? So.
for a fraction of a second, but there was a fire. There is a fire, it's just a controlled fire, right? Fatigas. And you like a patica chandosita? That's. Ya check me your watch.
Yeah, why don't I go?
Okay.
If you decide to stay. You were gonna stay, right?
That's what I was thinking.
So how's your?
Because I'm gonna be at Northeastern, no, 5:30. So I could go.
Wait, why are you going in?
Well, I'm interviewing somebody at 4:30.
So then Bobby can pick us up both.
We can be in contact.
Yeah, that's.
We can be in contact and see where.
I'm not sure when
He doesn't want to pick us
So
up.
I'm gonna be done at 5. Have two polls. One at 4:30 and one at 5. So exactly. So
Oh, you
that's what-
have a call at 5?
No, one at 4, I'm sorry, one at 4 and one at 4:30. One ending at 4:30. And that's phone call ends at 5.
If you leave, I mean, to.
So we'll be leaving our 5.
Then I can go to social to just.
Yes.
Oh, Sophia, that's breakfast. It's simple.
So are you done with your courses?
Oh, I
No, for some reason, she doesn't have class.
had a house class. Is it test?
It's a safety issue.
Yeah.
She has a quiz today.
No, I took one quiz. I still have to take one quiz on the test.
No.
That's the only package, that's to do that. I think so. And what the thing. Oh, we want that. Okay.
You paid for premium? Mommy never pays for premium.
Well, she got it.
No.
When she signed up for the basic package, we finished this.
I asked. Hey.
Those things that happens when you get married, you don't know what you're signing up.
Right.
Don't know what it's me.
No.
I'm gonna check to see if you have that. Maybe. It's not in your whatever jacket it's on, right?
In his sweatshirt. Oh, it's in the side pocket.
Okay, good. But now you know where it is.
I just put it back in.
The advantage. Can I throw that away?
Yeah, you do.
Perfect.
Bye, girl.
Good date.
He stressed me out first.
Ciao, Chinese.
Oh, that's what you got.
Ciao, Sopita. Nos vemos.
Ciao. And I will get right through. Yeah. I think that's the thing.
My friends. Want orange juice or something? Okay, at what point are you gonna start characters? I forgot.
Sim, no business que escondemos, gratulamos e devemos ônibus. Eu business success. Segundo, nós abrimos novos por relativamente dragam diríamos. Separatori nos amo películas sacras protegidos. Piragamos, Vesquio, Stelifratres, Mario Gordo. Senador, pero non solo nos, os padres romani, sedetiam omnes peccatores et scipuli quam, padres et sorones, separata te pegetis solis, server amore nostro, iuti la Jesus. Ben, ac proximum fratres, avant What does England pronounce New England towns and cities? Boston. 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 Hey, right. Okay. What's that? What's up? Wow. Great job. This is a day in the life of a Puerto Rican that didn't grow up in Puerto Rico. I wake up at 7 a.m. to the sound of a cookie on my phone because, of course, I only visit Puerto Rico in the summers. And for breakfast, I start my day with a healthy mofongo. Then I put on my Puerto Rican socks just in case somebody wants to question my Puerto Ricanness. At 10 a.m., I do some flag lifts while I listen to traditional Puerto Rican music. Once I'm done with my workout, I eat some protein, which consists of an alcapurria. Then I write down my affirmations for the day and I recite them out loud. I am Puerto Rican. I am Puerto Rican. 9 a.m. Puerto Rican. By 12 p.m., I eat a healthy lunch, which consists of alfalfa. After that, I take a picture with a Puerto Rican flag and I post it on social media to remind everyone that I'm a real Puerto Rican. I agree. Several evolutionary currents. Several evolutionary crimes have been committed by whales. First of all, names, rules like. I think this is a day since evolution made them further and further down their souls. They're further down to evolution. They came from land. They only went water. As much as possible because the asteroid that killed the dinosaurs came from toxic wasteland and means died. So they also took this opportunity to colonize the ocean. First came the ridiculous vaccines. They were the size of full salmon that's Europeans because they loved to eat fish. That was 15 million years ago. And a few million years later, those hairy crocodile right here. They still walk on land. They fight in the water. Like running to see a spear with their nostrils halfway up their faces, followed by massive swords. Water, but still have active legs that are size of Rugon, but figures, L-shaped, 15 feet long, and Flaccidus. The pine lives 30 feet long. Eventually, their nostrils move so far back that they're basically on their backside because they're mammals and they still need air spring. So basically, it's a terrible thing and turned it into a big several evolutionary crime. Last time was there, I did big sightings. So, you know what signing is? They have to take it both sightings and assessing on it. I will see you. This is really big. Yeah. I'm curious how it. Yeah, it's easy. At the end of the time, it's almost extremely. So I believe in a one-family voting system. I think it would bring back the nuclear family. That's going to be so interesting. Because they started with Steve Irwin's first. She said, it's a spirit. I know it's this money law, but when you marry your money belongs to your husband, your husband money belongs to you. This conference where she said, just based on Texas, has a long history of proving young girls to child bride and teen. There are a lot of successful during final researches that attacks interference. It's telling them that you have married as early as possible and have children. If you're a have 100 kids, and you have one year to dream. I think we should be kids. So much that this place is so most where one of the best things is I think short and the short class and the best places where it's sometimes this we don't we had another help in the second it has to be what it has to well basically possible because of us because that's actually that's the only thing is the days when I'm not to ever get for them as well as the cast out so they comes to the basically there is such a compared to harm some is not this choice because never so I exam as well as the voice of sensation as well as the show fire is it is far too much to be baking today, so I'm going to bake a no bake snack to take that. I was afraid of the ice bucket challenge. Yeah, that's not here. Getting buckets on top of ice, just hands. Ice bucket challenge at home. All you gotta do with an ace part with your bucket specialization. They all kinds of buckets on so short, tall, and even bonding. This one, the Canadian side, it's a little guy. I'd say it usually takes around 2 days for it to take the bucket on. But that's one of those big bucket. Yeah, we put a bucket on every single ice each head. There's about 22,000 of them. So these cost like $5 a piece. One bucket every does it's like $120,000, $108. That's something that costs about $2 million. I think it's
this panel quite interesting. Landmark as illumination. I want to see you guys brighten the hall. Is that Anthony's presentation? Timothy, sorry. The CRR people, they are too fancy. He's the first. But last 3 minutes of poll. So we try to reduce it to 12 minutes each. 12 minutes. You're working on doing some hours that are straight with the good afternoon, colleagues. The interest of time, we're going to start this panel, which, as you can see from the program, is written Landmark as Illuminations, right? That's the right word. Good. My name is Elvis Okala, and I'm going to chair this panel, which includes the colleagues as you see here on my left. Each colleague will have at least reduced to 12 minutes because we've lost some few minutes already. At least 12 minutes to make their presentations. We'll be very strict on time. And then we have enough time for questions and comments on their presentations. So we'll start with the Timothy. Am I supposed to read your bio or something? There's nothing here. I think most of us know you. Come, Timothy. Yeah, thank you. Timothy. Okay. Fair enough.
Good afternoon, everyone.
If you're interested at all in fire.
Good after lunch. You know, the panels that come after lunch are usually a very tall order. I don't know why that's why they chose the word illumination. For this afternoon panel, we hope that the next few minutes or hours that will be here will be at least worth your while. As introduced, my name is Timothy Thondu. I work for an organization called the Center for Reproductive Rights, legal advocacy organization working in Africa. My subject, or the subject of our conversation in the next 11 minutes and 53 seconds, as Prof. Elvis has shared, would be what has then been referred to commonly as the Tanzania girls decision case, which is decision number 2 of 2022 from the African Committee of Experts on the Rights and Welfare of the Child. And in our paper, and maybe perhaps I would want to mention at this point that I am representing 2 of my other colleagues who we wrote this paper together, Martin Onyango and Wanjiro Kamanda. And in our paper, we argue that decision number 2 of 2022 is a landmark decision, primarily because of a couple of things which we shall see in our presentation. But one, the African Committee of Experts on the Rights and Welfare of the Child had an opportunity to illuminate, an interesting word, I'll keep referring to it, on the question of the right to education for adolescent girls, but how that intersects with the right to reproductive rights for these adolescent girls. And that is why we make that argument that it indeed is a landmark decision. Perhaps maybe just to kick us off with a brief background on what that case was about. I think one of the presenters also mentioned early in the morning that it's a very biased presentation because we were also litigators in this case. And I would want to adopt that because I was also part of that. Before 2017, child marriage in Tanzania, and for those of you who are Tanzanians, would know it was widely encouraged, and married girls were not allowed to continue with education. Over and above child marriage, sexual abuse and sexual violence was also a very common occurrence, especially among young adolescent girls. And learners in school ended up being subjected to forced mandatory pregnancy testing. I was doing a training for judicial officers about a week ago, and one of the judicial officers said it was such a common occurrence that when they went back to school, especially in their late primary school and early secondary school years, they would be subjected to forced pregnancy testing. You would assume that they would be taken to a clinic somewhere. You sit down, there's a nurse who is seated there. They speak to you about 1 or 2, 3 things in a closed room. You're given a comfortable place to sit. After that, they tell you we're going to do 1, 2, 3 things, and then you have an opportunity to say whether or not you would want those things to be done to you. Unfortunately, that was not the situation because most people used to be paraded at the school gate and you're stopped just before you enter school. And the form of pregnancy testing was through pressing your stomach to confirm that there is no living human being inside it. So they would consistently press your stomach. And if they felt, I wonder, anyway, if they felt there was anything, then you would be taken to the side and you're told you're probably pregnant and therefore you need to be examined further. But that is a story for another day. So that was a very common occurrence, including in Tanzania. And during this period, unfortunately, Tanzania did not have any law on re-entry. So what it coupled in, so that I cut the long story short, as a background for this case, is that over and above the mandatory pregnancy testing, what happened is you would also, if you were found to be pregnant, you would not be allowed to go back to school. So you would be mandatorily expelled from school because of being pregnant. In very severe cases, some of those girls would be requested to actually tell the school who had impregnated them. And if not, then they would be detained arbitrarily for quite a while. Over and above that, as I've mentioned, in the likely event that you carry your pregnancy to term and you complete it, you are not allowed back to school because of 1, 2, 3 things. I hope we'll have some time to play a very short video that then forms the subject for our conversation this afternoon. But that was exactly it. How it became serious is in 2017. The then president of the United Republic of Tanzania, John Pombe Magufuli, the late, made a declaration on TV, and that's a video that I hope we can play, that any pregnant learner who had found themselves pregnant, either out of their own volition, meaning you are enjoying sex as he puts it, or you had done it, he puts it in Kiswahili, kwa bahati mbaya, meaning it had happened not out of your own volition, it had happened by mistake. That mistake could either be sexual violence or anything else. He said that under his rule, you would never be allowed to go back to school. The import of this is, this was coming from the highest office in the land, where the president was making a declaration that in a country like Tanzania then, a declaration, including a declaration in the podium or in a pulpit in church, became law because he was and is and was to be the law that was to be implemented in Tanzania, carried a lot of weight. That meant any person who required, or any person who found themselves pregnant would not be allowed to go back to school. When the Center for Reproductive Rights, together with our partners, the Legal Human Rights Center, brought this communication before the committee, what had happened is it had followed a series of litigation in country that had ended at nowhere. Yeah, in simple words. The situation at the High Court and the Court of Appeal had ended up not yielding any results that would be useful in addressing the scourge that was the forced pregnancy testing and the mandatory expulsion of adolescent girls in Tanzania. And this prompted us to then file the communication before the committee of experts seeking to enforce several rights within the African Human Rights Charter, but also the Children's Charter. And among the things that we sought, of course, to enforce was one, the right to education, among other rights, including the right to reproductive health care. What happened in between, or when that communication had been filed, in November 2021, the Ministry of Education issued a circular allowing pregnant girls to be readmitted to formal schools. And as you would imagine, this then became the subject of the defense, if I could put it that way, by the government of Tanzania when they were defending their cause before the African Committee of Experts. And they also had an opportunity to be able to interrogate whether this served as either reprieve or a means to cover up or to try and compensate for the policies that had been there. And when the committee made its decision, it found in no uncertain terms that that circular would not hold water because the Republic of Tanzania had violated many rights of adolescent girls in Tanzania, including that of the right to education, but also the right to reproductive health rights. I will not go into the conversation because perhaps you might have an opportunity to read this paper. Many rights had been implicated, and that formed the basis for the conversation before the African Committee of Experts. Allow me then to briefly just look at, in the next 4 minutes, why we believe this decision is a landmark decision. I think many speakers who have spoken before me set out the criteria to which you would then analyze a decision and make a determination whether that decision falls within the category of landmark. Many of those criteria would ideally, if you subjected this decision to that criteria, would find that indeed it actually meets that criteria. The first and most important thing that you would find when you read through this decision is that one, and in the spirit of this panel, it first begins by illuminating the dimensions in which girls' rights had previously been obscured within the legal and policy discourse. So when you read through the African Charter, when you read through the Children's Charter, when you read through some of the laws and policies in Tanzania, the right to education is embedded in it. However, the discussion that was before the committee became more nuanced because it was not just about the right to enter school, the right to get that education. It moved beyond that. When you begin by mandatorily forcing young girls to be subjected to mandatory pregnancy testing, that is very humiliating one, and those who are found pregnant being expelled and then being forced to give out names of whoever had impregnated them or being subjected to detention arbitrarily and for an unknown period of time, then those conversations were what the committee was faced with in making a determination, does this affect the right to education? And the committee went to lengths to explain what it means under Article 11 of the Children's Charter to determine what the right to education entails. What would be interesting for this conversation is it then went beyond just the formal education that you would miss in school, but as you will see in the recommendations that were made by the committee, they speak about the right to comprehensive sexuality education as a right or a subset of the right to education within the Children's Charter. And they speak to it at length and say, the reason perhaps some of the issues that had befallen many adolescent girls in Tanzania regarding the question of either child marriage or sexual violence stemmed from the fact that comprehensive sexuality education was not something that had been embedded within the education system in Tanzania. Secondly, the decision also significantly expands, as I've mentioned, this right to education. Third, we also find that the decision demonstrates the inseparable relationship between education, gender equality, and reproductive justice. As I've mentioned, the court had an opportunity to just go beyond what Article 11 provides and speak to the question on reproductive justice. What does it mean? So the question on forced pregnancy testing, obstetric violence, the question on whether that, of course, amounts to the violation of the right to reproductive rights for these adolescent girls, and they had an opportunity to do so. But also, when you look through this decision, and through the litigation, because I didn't have an opportunity to take you through the litigation history, the best interest of the child as well as child participation came out very clearly from this decision. You would find that what was central to the conversation, including at the litigation stage, was that child participation was so central. One, not just in the conversation, because the research, the body of research that had been used, of course, to create a body of evidence that would be taken before the committee had also been developed in conjunction, but also involving the children themselves or the adolescent girls. Whoever filed the case before the committee was not just CRR and the Legal Human Rights Center, but on behalf of 5 adolescent girls who, during that time, the committee had an opportunity to hear from them directly. So this case also centered the conversation around child participation. And because I see Elvis has stood up, allow me to conclude, because he's a bully and he will finish me if I don't. When you have an opportunity to read through this decision, you will also interrogate some of the questions that then form the basis for why this conversation needed to go before the committee. Post the decision, Dr. Tarisai, when he spoke before here, also spoke about the implementation of that decision, but also the implementation hearing. This case has also had an opportunity to go for an implementation hearing before the committee of experts. And the committee of experts ended up giving further recommendations to the respondent state for it to follow up to ensure that they are implementing this decision in its entirety. Lastly, this decision has also been implemented in conjunction with the respondent state. So in a very unusual, perhaps might not be in the cases in which you have litigated, the government of Tanzania was willing to work alongside the respondents in implementing the decision from the committee of experts. And that's an ongoing conversation. And we're hoping that by the time we are concluding, we will also have that statistic that was mentioned, that out of the many cases that the committee of experts has issued, at least this decision on the Tanzania girls would have been implemented. Thank you very much.
Is it? I'm always ready. Okay, if I press start. Yes, that's me. Present the time starts. All right. Good afternoon again, everyone. My name is Usang Maria Asin. I'm from the Faculty of Law at the University of the Western Cape. And this paper is presented together with Professor Ebenezer Jurojaye, who is at the Center for Human Rights here at the University of Pretoria. The actual title of the paper is An Analysis of the African Commission's Approach to Substantive Equality in the J and Namibia Decision. I won't restate the facts of the case because if you were here in the morning, Angela did a brilliant job of that in a manner that is extremely eloquent. I can only admire and applaud how she did that. So if you were not here, too bad. Now, in this paper, we focused mainly on three things. First, the implications of the Commission's departure from formal equality to substantive equality. Two, the Commission's attempt to draw lessons or inspirations from other treaties or human rights bodies in arriving at its own decision. And finally, we threw up a query as to whether the Commission is able to continue and improve on the trajectory of this progressive manner in which it addressed this communication. And I would explain why we put that query as I proceed. In terms of the implications of the substantive equality approach, if you go through many of the communications that are similar or have anything to do usually with discrimination or equality, the traditional approach of the Commission is to just simply stick with formal equality. In the vast majority, that's what you would find. And you know that this is inadequate in terms of satisfactory outcomes from a human rights perspective. Examples include communications brought by Equality Now and the Ethiopian Women Lawyers Association against Ethiopia. There is also the Community Law Center and Nigeria case that Michael referred to earlier today. Not to mention the fact that it took more than 10 years to get that outcome. Now, basically, Commission will just focus on, let's say, three things. Whether the similarity or there was a similarly situated men, whether the women received differential treatment from the similarly situated men, or whether the differential treatment was objectively and reasonably justified. Now, this is inherently flawed when you take into account all the issues of intersectionality and all of those things that were mentioned earlier in the morning. And so lots of critics, there's lots of writings out there by different feminists and other scholars about how illogical it is and how it's weak and blind to deep-rooted sociocultural factors that fuel gender inequality in Africa. So they jettison all of those other elements that would help to prepare and put forward outcomes that actually advance the cause of human rights, not just in Africa, but also in terms of the mandate of the Commission. So in the Namibia case, it was a U-turn, pleasantly surprising, because the Commission itself admitted to previous errors in strictly focusing on the formal equality approach and indicated that these Joan and Namibia case presented an opportunity for it to adopt the substantive equality approach. So that's the summary of the first part. Now, when it comes to the attempt to draw inspiration, you know that that is required in terms of Article 60 and 61 of the Charter. So I won't go into all of that. In arriving at that decision, some of the inspiration came from the CEDAW Committee and the European Court of Human Rights. Of course, it's a welcome development. First, I'll tell you why, but first, from the CEDAW Committee, the Commission drew inspiration from General Recommendation 25 on Article 4 of CEDAW, which calls for a shift itself from the formal equality approach to substantive equality approach in order to address historical disadvantages of women, amongst others. But more importantly, the need to adopt corrective remedial measures to ensure a more level playing field. It must be noted, however, that the Commission fell short of this by not actually awarding those damages, but rather just directed Namibia to hear arguments on financial compensation. From the European Court of Human Rights, the Commission drew from the Juvic and Croatia case, where the court basically found discrimination on the basis of sex and pregnancy. However, beyond presenting a summary of this case, the Commission did not engage in any in-depth analysis to justify its reference. We consider this a missed opportunity, mainly because it would have been a chance for the Commission itself to develop its own jurisprudence and approach on discrimination, among others, in terms of the Charter and the protocol. Now, at this point, I want to mention that from the morning's presentation, I recognize that this is also a space for delving into Afrocentric views on intersectionality and other elements of substantive equality, as earlier mentioned, and the role that litigants also play in bringing this before the Commission. So I want to put it out there. Finally, we queried whether the Commission will maintain and improve on this progressive approach. Why did we do this? It's basically due to the inconsistencies in the Commission's own approach to its communications in terms of deviations from its own previous progressive provisions and then falling back to retrogressive stances. Those of you who have been working in this space, you would know how that has been a point of frustration for many of us who litigate before the Commission. Again, a disappointing example is the case of Community Law Center and Nigeria. There is also the fact that the committee hardly relies on or refers to its own jurisprudence on norms and standards when considering communications. There's even an LLD thesis by Jafet Begon, who many of you know, that highlighted this issue, tracing many of the communications. This was a strong issue in that thesis amongst many others. Now, this inconsistency and lack of certainty appear to be the default modus operandi of the Commission, and it's unfortunate. Why? It's not helpful for legal development and for certainty of the law. So, the Commission's role in our human rights landscape is very, very pivotal. I mean, it's the oldest human rights body compared to the others on the continent. So it's important to call it out and to see how to encourage and strengthen the approach that it takes towards communications, particularly when it comes to ensuring certainty and growing its own jurisprudence and avoiding confusion, even in the minds of those who litigate before the Commission or people on the continent who have hopes that the Commission itself would help to address some of the human rights issues that we face. So we conclude by just restating this important nature of the decision while also showing the areas of weakness and calling for the need to go deeper and to go further in future Commission communications. And more importantly, to maintain, we call for the need to maintain this progressive stance and improve on it. I thank you.
But I just, but simple. Yeah. See.
Good afternoon. Yeah. My name is Anthony Monene. I am going to revisit the OGIEC decision on you this afternoon because we have had quite a bit of discussion about it in the morning, but from some different perspectives. I'm actually happy to be here today because today for me is homecoming to the center where I did my master's in about 28 years ago when Franz was a young professor who loved his rugby and his cricket. Gina was a young girl who had just started working. She looks as young as she was then. I'm sorry I've disclosed you. Anyhow, the OGIEC decision today has been discussed from dimensions of particular aspects of it. And therefore, for me, I look at it as a case so that I think about the 2017 merits decision, the 2022 reparations decision, and finally the 2025 compliance order. Now that trilogy of the three is what then I reflect on as the case, because it's a continuum that you cannot separate from the others. The initial case, the merit case of itself is a landmark in a way I'll demonstrate to you because it for the first time defines who are indigenous people in as far as the African rights system is concerned. We may not as such say that the reparations decision is a landmark because it's not the first reparations case of the African court. However, it supports the landmark nature of the compliance decision of 2025. So in a sense, I will agree with Tarisai that the 2025 decision is a landmark, but somehow for different reasons, but we arrive at the same conclusion. So I begin by asking a preliminary question as to whether the OGIEC case, the continuum of the three, is a landmark case. And I ask as a preliminary point, is it landmark? So we ask ourselves, what is a landmark decision? And I take the definition that it's a high-profile case that either establishes a new legal principle or it alters how we think about existing legal principles, or it gives lasting precedent for future rulings on the same issues. And for me, that is threefold. So that number one, it establishes precedent. Number two, that it alters existing law. And thirdly, that it has a widespread social impact. So does a case that has widespread social impact go beyond the litigants themselves and impacts on greater society? And I'll be showing you that in a minute about this case. So let's look at the contextual background of the case. Who are the OGIEC? The OGIEC are a small, distinct community in Kenya. You'd want to call them indigenous because of their way of life. They are forest dwellers. They are hunters and gatherers. So in a sense, they live on gathering fruits in the forest, hunting wild game, and honey harvesting. And that honey harvesting, when we come to cultural distinctiveness, is critical because it impacts on how they carry out the rituals, their ceremonies, it is of medicinal value, and so forth. What's the location of the whole case? Now, this is the Mau complex, forest complex, which spans over 7 administrative geographical areas of Kenya. And in a sense, it is the spiritual home, it is the ancestral home, and the economic home of the OGIEC, because even predating the colonial state, they lived around that geographical area. Now, the importance of that area again, and which the government may use as an excuse for it, is because it is the actually the largest closed canopy forest in East Africa. And so therefore it is a lifeline for the Kenyan economy in terms of water, and of course, agriculture, which is big time in terms of economic life of Kenyans. But then again, it feeds water into about 12 big rivers, so to speak. It also has, those rivers feed into about 7 lakes. 3 of them which are shared water resources in East Africa: Lake Victoria, Lake Turkana, and Lake Natron at the border with Tanzania. Now, the conflict comes from a colonial past of dispossession of those lands by the colonial state, then perpetuated by the independent state. Now, during colonialism, what the British did was, for purposes of settling their settler community that ran agriculture in Kenya at that time, whatever appeared to be unused land or unoccupied land was then declared public land or crown land, and which then became available for alienation and allocation to the white settlers. And that area is largely the Rift Valley, what is called the White Highlands. And so part of the Ogiek land became a target of that as part of crown lands, which then could be alienated and allocated to settlers. And that in the colonial state then escalates into a fight about state development, that the state wants to develop it for the benefit of Kenyan people, and then in other instances for environmental conservation. And that's what really the dispute is all about, right from the merits case to the compliance hearing. Now, we want to ask ourselves, because we're looking at a continuum, we ask ourselves, what are the judicial milestones? So number 1 is the 2017 merits decision, then the 22 reparations decision, and finally the 2025 compliance order. However, the dispute predates that 2017. Actually, it started at the African Commission in 2009, when the Center for Minority Rights Development, call it SEMIRIDE, and the Minority Rights Group International filed a communication with the Commission on behalf of the Ogiek community. What had happened at that time in 2009, the Kenyan Forest Service had issued a notice for the Ogiek and other settlers to move out of the Mau forest for purposes of forest conservation. In the same year, the Commission issued an order of, what do you call it? OPM, provisional measures to stop those evictions. And so when the government did not respond, what the Commission did is to seize the African court under Article 5.1 of the protocol. Why? Because Kenya has not deposited instruments recognizing the competence of individuals or NGOs to approach the court. And so therefore, in the first instance, which resulted in the merits decision, the African Commission on behalf of the Ogiek filed a case alleging the violation of about 8 articles of the African Charter. Now, out of the 8, it found that there were violations of the Charter, substantially 6, and then a violation of state obligations and under Article 1. So, on the basis of that, it made certain decisions relating to those orders, violations of substantial rights that it established. Then come 2022, because then you're asking yourselves, what is the value of saying or establishing that rights have been violated, there must be a way to fashion remedies. And that is what the 2022 process was all about. What do we do about the infringement of collective rights? What do we do about the infringement of the right to development? What do we do about the infringement of the right to culture and cultural identity? And finally, having made orders as to certain remedies for each of those breaches, then there was necessity. Actually, at the point of the reparations hearing, at the conclusion, then it says, we shall meet later in time to audit whether you have complied with our orders as to reparations. And that's what gave ground to that compliance decision. Now, that takes me to my thesis of this paper. When I reflect about the whole case, based on the three judgments, if you like, is that we are talking. Oh, I had a lot to. Could I? Oh, okay. So, so my argument is that this gives a legal soul to indigenous resistance, and that we can then use that as a reference point for looking for state action against that sovereignty. And so I do a doctrinal analysis of the substance and the judgments of the case, and then a socio-legal critique examination of what happens to those decisions. So the uniqueness or the landmark nature of the merits decision is fourfold. And I will use the analogy of Professor Fiuliun, of landmark as being where are we, and then two, where are we going? So that is eliminative. So we have four pillars in the merits decision that are landmark. Number one is where it identifies collective land rights, and that collective groups can have title to land different from the torrent system in England that knows individual title. And then number two is about cultural preservation. And that is to say that when you preserve the cultural identity of the Ogiek who depend on the forest, and they do beekeeping, and beehives are kept on trees. So they don't need to log and destroy the forest. So who better takes care of a forest than such people? So that there's a symbiotic relationship between how you preserve the ecosystem and how you preserve the cultural identity of that community. And the third pillar is about the right to development, the issue about free, prior, and informed consent, and how you stop state paternalism about development, so that you are the drivers as the beneficiaries of the right to development. You're the drivers of your development and decision making. Then relating to non-discrimination, violation of Article 2, which had been claimed, the court then innovatively says we cannot decide this alone, then we have to look at it also in the context of Article 3, so as to bring in the issue of substantive equality, so that you look at the uniqueness of a cultural community and how do you protect that cultural identity. That's right. Okay, I will do that very quickly. So, as I said, the reparations issues about fashioning remedies, there is nothing landmark about it, but it then supports the hearing relating to compliance. Now, that hearing about compliance is the first of its own of the court. And that is why it spent a lot of time establishing whether it had jurisdiction to hold such a hearing and make orders on it. And on the basis of the submissions of the amicus, they were able to reach a decision that they indeed had jurisdiction to hear, to hold a compliance hearing and then make orders as to it. Now, that to me then also gives some landmark nature to the reparations hearing. Now, at the end of it, again, it said there was no compliance and ordered another hearing 6 months later. So 6 months actually end today. So we look forward to what will happen thereafter. And because of lack of time, I will skip the 5th bit and just reach my conclusion. So at the end of it, I reached the conclusion that there is a real implementation gap between what the courts have said and what government has done as decided in the compliance hearing. But for me, what it does, even if government does not comply, although we know there are internal mechanisms of making it comply, for example, through grassroots mobilization, lobbying, and so forth, it actually gives a soul to indigenous resistance to marginalization, both at the African level and also at local level, if we look at local mechanisms. And I think that will come out clearly in the paper, although I've skipped the section about the illusion of the Constitution, because the Constitution at Article 2.6 makes international law part of our law, especially ratified treaties. And that means something in as far as local enforcement is concerned. I thank you and look forward to your ideas on it.
Thank you.
Okay, my best.
Yes, fine. Because you want to see me several times.
Of course, I don't want to see you several times.
The time starts now.
Okay.
Are you ready? You have the presentation?
No.
No,
Yes, I've done also.
the time starts now.
Okay. So bear with me, I'm the last one and the time pressure is on me, so I'll try to focus on my notes as much as possible. Not explaining, so you can ask me questions if I'm not clear, if I rush it, please. So my name is Fakat Brana. I'm from Ethiopia. I'm an assistant professor at the law school at Hawassa University, and currently I am based at UWC in Cape Town with Professor Maraya in the Children's Rights Project as a postdoc. So I did my doctorate here at UP. So it's good to be back home. So my analysis is on the Hansungule decision. So I'm delighted to present this to you and get your feedback. Of course, I've presented it to the faculty at UWC before I sent the final one here, and I got my comments there. But I'm also hopeful to get more from you, and I had the opportunity to get actual reflection from the person who was part of the judgment writers. That is Professor Vinam Mazmur, who actually wrote, I didn't know about it, but he gave me many insights, and so I just want to recognize that here. So in this one, so to give you the context first, so the reality in relation to these cases is very stark. So from the Lord's Resistance Army, that's a non-state armed group that operate in northern Uganda. And the case is about what happened to children in relation to, or due to their association with this non-state armed group, the Lord's Resistance Army. And the case covered 1986 to 2006. That's 20 years. So it got its final decision in 2006. But between 1986 and 2006, children have really suffered due to that conflict. And these children that were associated with the Lord's Resistance Army, they were known as night commuters because they were forced to travel from their IDP camps to urban centers each evening to seek safety, only to return in the morning. And this was actually the backdrop against which the African Committee of Experts on the Rights and Welfare of the Child rendered the decision on Michel Sungule and others versus Uganda. That is communication number 1, 2005. So that's the first communication of the committee to reach out. The question. So first conceptualize the landmark nature also. For me, the Nsungule decision is a landmark because of at least 4 cumulative criteria. The first one is its doctrinal innovation. So here a decision breaks a new legal ground, interpreting provisions in ways that reshape the normative landscape. That is one. The second one is the decision's operational significance. Here, if the decision transforms abstract rights into justiciable obligations, making them actionable before judicial or quasi-judicial bodies, that's also would make the decision landmark. The third one is its catalytic effect, meaning the influence it has on subsequent jurisprudence and development of the law, normative development as well as practice. And the fourth one is the visibility and voice. When the decision renders visible what was previously just invisible, the specific plight of a vulnerable group, if it brings up to the forefront, then that I would consider as a landmark. So if this, at least these 4 cumulative criteria are there, then that would be a landmark decision. And of course, the Nsungule decision satisfies for me all these 4 criteria. So the first one, let me begin with the most foundational landmark element of the Nsungule decision. That is, the decision was the first communication decided on the merits concerning children in armed conflict by the African Child Rights Committee. So the children and armed conflict issue, it's a serious issue, especially in the context of Africa, where we have like continuous conflicts, where many United States armed groups have been proliferating actually in recent years, and they have been abducting, they have been forcibly and willfully recruiting children, and all the violations that have been happening, they have been happening, but no much action has been taken, at least from a treaty body side or other judicial body, especially with children and armed conflict related issues. Obviously, I recognize, because I did my doctoral study on this one, there are issues, human rights issues that are addressed, but specifically IHR related issues that could be relevant for the situation of these children have been ignored, and the Nsungule decision has taken up this one, and that makes it a landmark for me. The second one is the state 18 standard, that the state 18 age standard that the Nsungule decision maintained in that decision. So in this regard, Article 22 of the African Children's Charter, it differs fundamentally from its counterpart at the UN Children's Charter. So the UN CRC, that is the Child Rights Convention, that is actually the basis for the drafting of the African Children's Charter. And under the Child Rights Convention, the minimum age set was 15 years, but the African Children's Charter put the benchmark at 18 years of age standard. And for this purpose, in fact, the African Children's Charter, it refers back to the UN IHL and human rights instruments to serve as interpretation for this one. But the committee said this one is clear. 18 is a standard for Africans. Now all children that were associated with the Lord's Resistance Army and whose violations, whose rights have been allegedly violated, were considered to be those that's the case. The third, the third one is with regard to due diligence framework. Perhaps that is the most significant doctrinal contribution, I would say, the Nsungule decision has articulated in that decision. So the committee stated that effective implementation of laws with due diligence is part of state parts obligation under the charter. So the government tried to brush it off as if these violations have happened from third parties, so it does not concern itself. But the committee asserted that even if the violation directly comes from an in-state armed group, the state is still duty bound, at least to show due diligence to protect the rights of these children from violation by said actors. And so it considered Uganda responsible for at least some of the violations that have happened to this Jordan. The fourth one, which is actually that interests me much as someone who has an IHL background, is the role that Sungule decision played in bridging IHL and IHR, that's international humanitarian law. That's for those of you who are not keen in that area. So that's a body of law that applies in situations of armed conflict, and obviously the human rights law that applies at all times. So that specific part of law which is supposed to be applicable in times of armed conflict, how it needs to be read together with human rights law, the Child Rights Committee in Hansungule decision has at least attempted to deal with that issue. And as someone who had researched a lot on IHL and human rights issues, I would say that from treaty bodies, most of the time the focus is not just the mandate is on human rights. So most of the time is just the focus is only on human rights. But there are areas actually that could really affect the protection of child rights unless clear standard is set between those laws or how they could be applied in harmonious way to particular cases. So the Sungule decision highlighted all these four cumulative criteria that I found out to suggest certain cases landmark. And on top of that, of course, I need to add that the Hansungule decision had also some remedial innovations, because the decision concluded with 6 concrete recommendations to the government of Uganda. And these recommendations, if we see them clearly, I'm not going through them because of time. So they are very structural, and this structural approach, I believe, is very important to deal with such issues. Another thing to raise about this decision is its contribution for the general comment on this area. So the landmark character of the Sungule decision, it is evidenced by the influence on the Committee's 2020 general comment on Article 22. That is the article that deals with children and armed conflict situation. So when this general comment was adopted, and when you read it, you could see that there is an influence from that decision, which went into that one. So, for example, it calls on states to exercise due diligence in relation to violations by any actor in conflict on their territory. So this purely tells me what is there. So in the last, I would like to say a few critical points. While the Sungule decision is really landmark for me, it has taken up an issue which has not been given due attention. But for it to be better, it would have been better first. The committee, I kind of find that it told the state responsible for this obligation to prevent violations by United States, particularly the Rose Registered Army. But you see, there is some problems there, because despite citing certain roles, the committee did not fully apply the principle to the low resistance army issues, but it's only focused on the government one. The second one is the inconsistent application of due diligence standard, because when I briefly looked at subsequent decisions, the standard is not the same. Perhaps it's because the decision came first. I'll give the committee that. Third, from an NHL perspective, the committee's analysis also reveals certain limitations. And that is because the committee has not started by classifying the situation for IHL. That is the starting point, classifying situations, because depending on the classification that we make, the body of laws or the specific provisions that will be applicable to a given case may differ, and that limitation has been observed. Yeah, so well, these are my presentation. So if you have any question, please.
Thank you. That was a good session, wasn't it? I think we can give the panel again a little round of applause to first for accepting the pressure and for keeping to time. I think that is very important. I had very strict instructions from the organizers to make sure that we catch up. So I have one question. I will open up for questions now. We have about 20 minutes or so to ask questions or to make comments. And my question is for all of you, and that is based on the theme of this particular panel. Is there one particular aspect of all the cases that you've all spoken to, that could be regarded as the epicenter of what makes these cases, unique, or that makes them landmark? And when I look at landmark cases, I want to see a case that will not miss an analysis on the thematic issues on which that case is based on. An example could be the Tanzanian girls case that Timothy spoke to, and he was part of that litigation team. Do you think the aspect of pregnant girls and access to education, that case and the decision that was arrived at would not miss a critical legal analysis? And I'm saying this on the basis that if you look at the core principles that guided that decision, because based on common things that we all know that guides all decision committee, best interest, participation, survival and development, and non-discrimination. So what makes it different from the other cases? And this is just an example of what the question I'm asking all of you. Because it should be a case that, including in Europe, that if such issues are also brought up by the EU or in the American system, that they will not miss this African case to mention, because it really opened up and at a landmark as an illumination. That's the word I'm trying to remember this in English. Great. That's my one question to all of you. And I will now open up for questions. Yeah, I see a hand right up at the back. No, I think, where's the roving microphone? I can help.
Thank you. My name is Nobukosi. My question is around the Tanzania schoolgirls. I'm presenting on it tomorrow, so I hope you're there. But my question is, one of the things that I always wondered, just reading from it in an outside perspective, is there was this desire to stop the state from forcibly asking the girls who had impregnated them, and justifiably so, because the methods that they were using were just not okay. But how was that balanced between actually needing to know who did impregnate the girls? Because a lot of them, all of them actually, are underage, or forced marriages or potential sexual assault. How was that balanced out?
Do we have any takers? So.
Thank you so much. I must first declare I'm from Tanzania. My name is Zulu. I would just want to concur with the presenter on the Tanzanian girls case. I really agree 100% of all presentation, but I just want to add one thing, which makes it even more landmark decision. That just apart from the circular that was issued by the government at that time during the case, but then that case also had a very, very symbolic impact to Tanzanian policies. Because in 2023, I think the later year after the case was published, Tanzania enacted their education and training policy 2023, and in that policy, a policy statement was included, which is policy statement 4.5, which was talking about inclusive education, and it addresses the specific action to address gender disparities. However, it is not that much specifically touching what was on the case, but at least it was the very first thing, a very first statement to have, because the previous policy did not have anything that of that nature. So that case had such kind of symbolic impact. Now the thinking changed, and there was something in that policy. So maybe as part of a strategic advocacy, apart from policy, maybe let's hope for the best. Maybe now we are going to have probably, I have to say probably there can be a law sometimes in the future, or there can be a regulation sometimes in the future, but at least that as a landmark decision symbolically
leave that policy statement in the later education policy. Thank you.
Thank you very much. Maria, very interesting discussion on the J case, which sent me thinking, because there's been literature and arguments, especially, for example, when you read the Feminist Judging Project, where there's been arguments that when we have women on the bench, when we have more women judges, that ultimately influences, the later in December 2025, which meant there was precedent for the African court to build on and advance. And too many things are really going through my mind. Do you think, because you've also engaged with litigation at that level, do you think women are making a difference on the bench? Because for me to see 5 women sign off this judgment and fail to engage with the issue of substantive equality when there was ground that had started to be laid already by the African Commission is a bit problematic. Begging the question, does that debunk arguments that when we have women on the bench, then that impacts on how the woman question is also dealt with? Does that mean that the argument should probably shift to, as having a random discussion, I think, with Trezor earlier, where we were basically chatting about the beauty of having, litigants that have all these postgraduate qualifications gone through the center. Both Michaels were speaking there. Michael Nyako was speaking about how he's been taking a lead, and you see how knowledgeable people are really influencing decisions. And my question then became, is it really an issue of women being part of the bench, or an issue of education and sensitization rather than just representation? Should what is happening actually debunk the argument of women will automatically force the change in terms of how decisions are arrived at?
It's me. Thank you for the opportunity. Anthony, trust me, I'm not retaliating at all, but just to keep the conversation going. This continuum of landmarkness of the OGIC decision, merits, reparations, and compliance. Do you see another leg of that continuum, or what does the future look like for you in terms of it retaining its landmarkness going forward? And quickly for Fikri, the last presenter on the Nzungule communication, I think that just as a comment that I think it is a result of a professor and his students drafting that particular communication. So it can encourage some young scholars here to say, even before you qualify with the masters, you can actually draft a powerful communication that can result in this. But probably you might know that it could have also led to the first fact-finding mission by the committee itself as a result of that decision, as another first, and probably also led to the adoption of guidelines on communications as another first, as far as the decision is concerned. So that's more of a perspective from the other side of those, from the drafting side of the communication, as you also shared a few nuggets on the writing side of those who drafted the communication itself. Thank you.
Yeah, I think we have one more.
Good afternoon. I'm Joshua Kipiego. So my comment goes to Mr. Fikiri's presentation. And I think I'll build upon what Mr. Tarisai said. I think another element that you can add on the judgment making it landmark is that the African Union Council provided a report on the implementation of that decision in 2012. And in its report, it actually made a recommendation to the Peace and Security Council to consider that decision. And out of that, Uganda actually invited the members of the committee so that they can come and see how they can implement that decision. So I think maybe to address the earlier concerns that were raised about the linking between implementing decisions by African human rights bodies and the lack of political will. Here we can see how that link was brought in, that the African Union Executive Council provided the report on the implementation of the committee's decisions, and afterwards it also went ahead on the Peace and Security Council to consider implementing that decision. And after Uganda actually went ahead to implement it. So that can also be a solution to the question that was posed in the earlier council, kind of trying to implement that decision by recommending to the states. Thank you.
So we take this last question. Thank you.
Okay. Good.
So maybe perhaps the answer to start with the question that was asked on the committee found or found we not only just stop sexual violence but investigate proactively cases of sexual violence. That investigation does not involve or should not involve the detention of those committed who sexual violence. For 5 days. Information. There are other methods for those conversations, but not necessarily infringing on the rights of those girls. The person in the pursuit of the an obligation to investigate and ensure that you end sexual violence. So that was pretty clear. It was clear that the detention was not part of what we're required to do, even as we pursue the conversation around the investigation for sexual violence. Then I think
strategic advocacy conversations that we're pursuing now is also an amendment to the Education Act, so that it's not just policy that speaks to these issues, but also statutes that ideally governs how education is provided in Tanzania. So that is part of the strategic advocacy that we are doing. So that is it. Now, in terms of the question that you asked for what is the one thing that makes it landmark? Allow me to say 1.5 things. One is that the question on SRHR as a conversation that it relates to adolescent rights is in itself a very novel conversation. There is not a lot of jurisprudence, especially in the child rights space around sexual and reproductive health rights, of course, and as it also relates to children's rights, the right to education, the right to dignity, all those things. I think in a couple of forums where I have had you speak, we always say that the Children's Charter does not provide an outright right to sexual and reproductive health rights for children. But when you have a decision that then speaks to the conversation beyond just what is within the Charter or the wordings of the Charter, then in itself gives an opportunity for any adjudicating body, national at regional level, to interrogate the question as to whether the right to education expands beyond the wordings of Article 11. That will be the first thing. Number two, the opportunity that we have seen come out from this decision, including implementation, as I've mentioned, is also very massive. Not just Tanzania, because this decision was against the Republic of Tanzania, but the decision that came out from the committee post that, we have seen implementation not just in Tanzania, but across the region. So for example, there is now a re-entry policy in Kenya, there is now a re-entry policy that is being developed in Uganda, and this has started from the conversation that came out from the committee of experts. So if I was to sum it up in those 1.5 things, I would speak about the novelty of the question on SRHR as it relates to the rights of adolescents, but also the conversation that shifts beyond just the courtroom to an implementation framework that is not just implemented in the state country that was respondent, but beyond that, because policy is being affected across the region. Thank you.
Thank you very much. On Elvis's question, I think the fact of the shift to substantive equality linked with the social cultural impact is where I would land on in terms of the so-called landmark nature of it. Because if in the morning, we also delved into it a bit, and looking at the systemic, structural and contextual disadvantages of women in Africa. We need to be able to give life itself to the standards we have agreed to, not just in the Charter, but particularly in the Maputo Protocol. So for me, in that regard, that's the big thing on it, because I mentioned the fact that historically, that's not been the approach, right? So that's where I land on that. In relation to Emma's question, that's an interesting one. The Community Law Center is what was renamed the Dalaoma Institute, where I'm also a senior research fellow. So that case was brought by us together with another organization in Nigeria at that time. And I mentioned this because after the decision came out, we had a number of engagements, and specifically some of the female commissioners were involved and also sharing light on their perspectives on the disappointments, let's say, we had with the decision, and talking about some other political elements and things like that we cannot go into here. And that's why when I talk about the disappointing nature of it, it goes beyond just what the decision says when you think about the things and some of the issues behind the scenes. And we did try to touch a bit on those, including the woman question in the paper. But I think for me, it will do us a disservice if we just focus on representation, because you and I know it has never always resulted in that kind of result. Sometimes it actually has the opposite effect. So if we go to say, oh, it has to be about women, what if they are not there, or they are there and it doesn't help our cause? Do we then say women should stop being there? So for me, representation is a different subject from the effect on what kind of decisions we get. So it should be about competence, it should be about knowledge, it should be about living up to your mandate. Anthony was presenting here. He doesn't need to be a woman to know that it's stupid to determine pregnancy by pressing my stomach, right? So it's not about representation. And lastly, I'm going to say, even in one of the cases that they relied upon, it wasn't because in Croatia, there were more women on the bench, right? The discrimination was determined based on sex and pregnancy, but it was all clear to everyone based on the available legal standards. And that's why, for me, my issue is more of why the flip-flopping and the uncertainty, like you mentioned again in the case that came up subsequently. So those are some of the structural issues we need to deal with within the context of the commission itself and its approach to communications. Thank you.
I'll start with Elvis's question about what is it about landmark decision making that can span across all cases, even like what we've discussed. And I think what strikes me most about the Ogiek decision and the landmark nature that it has and that can span almost any other case is that where a decision-making body is confronted for the first time with determining an issue that has not been dealt with by that body before, is about the issue of drawing inspiration from other bodies decision-making bodies that deal with similar instruments. And you will see how the court went around it in determining who an indigenous people is under the African Charter by drawing from the workings of the working group of the Commission and the work of the UN Special Rapporteur on Minorities. Coming to Tarisai, it is not the end. Even as we wait for the next steps after the 6 months period that the compliance order gave to the state to comply, and I'm sorry because of time, I didn't come through my other argument about the implementation gaps and what I call the illusion, the constitutional illusion, because our constitution makes international law part of our law. And that is why I say that at the African level, then it gives a platform for indigenous resistance to marginalization. So there may be other cases of other groups from other countries that want to be recognized as indigenous people who can draw from that. Again, the legal school in Kenya is this: how do we implement decisions of the African court, given that Article 2.6 makes international law part of our law? That would give human rights bodies. For example, the Constitutional Commission created under the Constitution to implement human rights standards. Perhaps it's part of its mandate then to take up and action such a decision. How do you deal with administrative bureaucracy? For example, when you say that the Community Land Act identify or recognizes collective title, but then it says we have to form a committee to identify who are the community members. Then after that, there will be the normal registration through the lands ministry and so forth. That gives avenues for other people to push the agenda. For example, already the Pan-African Lawyers Union is pushing the agenda of implementation. Perhaps our National Commission can take it up. And finally, the issue about environmental conservation. Now, how the court draws a link between the cultural lifestyle of the Ogiek that is so connected to the forest that they have to preserve it because of their rituals, because of their honey activities, and so that way they have to preserve the forest. Then that beats the logic of forest conservation of getting people out of the forest, because the people in the forest, the biggest culprits are people who got allocated land 40 years ago for political patronage, logging, which the timber industry is big, some tea estates associated with political figures. Those then cut those trees. And when the Ogiek are there, the opposite is true. They preserve the forest because of sustaining their own lifestyle. So that symbiotic relationship between a cultural lifestyle and preserving of the forest, to me, can impact in a sense to environmental conservation, and especially where the new buzz about climate action is, and considering that then the forest is a carbon sink.
Okay, thank you. Thank you for that one. I'll look it up. It will definitely help me. So if I have to pick one landmark that could go across from the Hansungule decision, I would say it relates to what I praised in my title, that is making the invisible visible. So Article 22 of the African Children's Charter, it deals with children and armed conflict issue. And its counterpart is there at Article 38 at UNCRC. But these provisions, they have always been there, but no one has been dealing with them. They have not been operationalized so far. But the Hansungule decision opened that way. And in fact, it has also demonstrated the potential for complementary application of humanitarian law and human rights norms, so that it integrating the 6 grave violations framework in the UN Children and Armed Conflicts mandate into the African human rights system, into a regional human rights system. That's what I would say. Thank you.
Thank you. And I hope that some of these good points that you've just made now, all of you will feature in those book chapters or articles. Thank you. Cassius, you had a question. So we'll do this. We take 3 more questions. one on my right and the second one to my right to left. Sorry, I didn't do sign. And one burning question. So I will start with Cassius. I see only two hands on this side, so you forfeited your own chance.
All right. Thank
yeah.
you very much, Prof. My question goes to the presenter who presented on the Hansungule decision. I wanted to understand, it appears across all the presenters since morning, there is some bit of consensus. Yes.
Cassius, the microphone went off a bit.
Yes, it appears that one of the factors that they look at is the doctrinal innovation. So I just wanted to understand what is really in this doctrinal innovation. To say that the case has developed the law and the doctrine, what is really about? Do they sort of like develop some sort of a typology to measure this this innovation? For example, if you say that the case has developed the law, do you mean that that case has contested the law and came up with something entirely new? Are you saying that it is aligning to what has existed, or it's avoiding what already has been put in place? Simply, is there any measurement to say it has it developed the doctrine, this is what we mean, and this is what we can prove? Thank you.
Then we have, I should have gone there, sorry.
Thank you. My name is Tali Tali. I am from Kenya. I have two quick questions. First, the J versus Namibia decision. I've always wondered, would it not have been a better approach to have that case heard in the domestic courts, particularly in the Kenyan courts, considering that the victim was Kenyan and that there were violations, or rather, the Kenyan government failed to undertake some obligations there in terms of remedies, considering some of the remedies that were given in the case might present challenges in implementation. For example, the remedies of compensation. And then secondly, to my former lecturer, Dr. Munene, who taught me many years ago, the question of indigenous people has been talked about by the court and also by the commission in Royce and the Batwa people case. I'm finding that the systems are taking a reactionary approach where they are waiting for violations to occur, and then they set down matters respect to that. Would it have been better if the court and the commission would have set down what should be the obligations of governments in treatment of indigenous people? Because we have indigenous people in many parts of the world. For example, the Ogek were living in a forest. Look at the Ndorois who are living near the lake. Right now, the lake, their land is completely swallowed up. Look at the El Chamus, their land is swallowed up. So should governments have positive obligations to develop measures to protect these indigenous people so that we are not coming to court as a reactionary approach, but rather we take proactive steps to protect these people? Thank you.
I think we have just two questions. Both of you. So we'll start with you.
Thank you for that question. So, doctrinal innovation. So, for me, the Hansungule decision is doctrinally, it has doctrinal innovation as a contribution because it breaks down new legal ground. So, by interpreting provision in ways that were that reshape the normative landscape, as like I was rushing it. I wish I explained it well. So if you go and see the general comment on that provision, on that article 22, which was adopted in lately in 2020. So you could see the influence, the doctrinal influence that Sungule decision has in that general comment. And so by explaining ways in which that article should be understood or operationalized, I would say that's a doctrinal contribution with regard to that contribution.
Talitali, I think in relation to how government deals with enforcement of human rights obligations, in a sense, there always has to be a starting point, because for a case to be a case, there has to be a complainant. But then what happens? And that is where I'm saying, for example, that the Ogiek case then is what gives avenue for resistance, or what you call the legal soul. And that would then be a wake-up action, for example, for the Kenyan National Commission on Human Rights. It is supposed constitutionally to report to Parliament on what it does, including the compliance with human rights standards. So now, since 2017, it has been aware that there is certain obligations that the Kenyan state has and already had before the decision, but were verified by that decision. And therefore that would then take care of other indigenous communities. And as you correctly say, the Ndorois, the GEMS, and of course that Ndorois case still remains just recommendatory at the commission level. But now again, they have a greater voice now that they have the decision of. And so they can use it as a way of mobilization. But I think since the commission is part of government, then that's where we should have new conversations about it.
I'll try to be quick. So, I mean, interesting question, but I mean, the answers to those are in the legal, what's it called, legal and technical basis. The violations took place in Namibia, so she freely traveled. So I don't know on what basis she would have brought a case in Kenya. And even if she did, would she be calling for the government of Namibia in Kenya? So it's all of those internal legal factors that will determine. But overall, when you think about the boundary nature of trafficking across the continent, it actually makes sense, even just from that point of view. It makes logical sense for the African Commission to be the one to hear the matter, so that this decision is widespread, just like we mentioned before.
Great. We've come to the end of this panel, but one last thing I want to leave with the panelists is that as you interact or engage with your submissions, is that you look at whether these decisions, taken at these regional bodies, if they've impacted domestic policy. Right. We heard about the re-entry policies in Namibia, Kenya, Tanzania, or Uganda, trying to have that. Have those decisions impacted domestic policy? Have countries or state parties to these institutions, adhere to some of the decisions of this case, even if the decision does not involve the state? Right. I think that could also speak to that has probably been a landmark decision in that space. Thank you. Thank you so much for being a lovely audience. We are done. Good.
Thank you very much for a wonderful panel and helping us to maintain the regression into lateness. But we have a tea break scheduled. It's now just about 4 o'clock, if I'm correct. So shall we try to be, as was suggested, have a 15-minute break and be back in 15 minutes or 15:15? So the tea is just outside the room here, as before. So take a small break and we'll be back at 15:15 with the next panel with Dr. Yasmin Luanjula and the panelists. Thank you very much.
The last session.
All right. Welcome to the last session and the last panel for today's event. The name of the panel is Landmark and Transformation. Since this is the last session, we're going to go straight into it. And by the way, for those of you who are still here, you guys are legends. So well done. Round of applause for that. So let's get straight into it. Let me call upon or introduce our first speaker, Felix Dube, who will be speaking about the Batwa decision. Felix?
Okay. Thank you so much. Good afternoon, everybody. I wish to stand on the protocol that has already been observed and to thank you for still being here at the conference. It's always a pleasure to present in the late afternoon because everybody is either slumbering or already tired, so less questions. I hope that's not the case here. I'm trying to move the slide a bit and it's not moving. Oh, okay. Thanks so much. So my presentation is based on the case that you see on your screen, the Batwa decision. I've always been interested in the jurisprudential legacies of judges and courts across the world, particularly the South African courts, South African Constitutional Court, and other constitutional courts that have been established in various parts of the world. And recently, I've published on the legacies of South African judges like Froneman, Albie and Mahomet. I'm not saying go read the papers, but from those publications, I've observed that there is very little, if any, engagement by the South African judiciary, particularly the Constitutional Court, on the jurisprudence of African human rights bodies like the African Commission and the African Court on Human and People's Rights. But that's a question for another day. I guess something that we will discuss at an appropriate platform. But today I want us to discuss the Batwa decision that you see on your screen, which was rendered by the African Commission on Human and People's Rights. I've specifically chosen this decision because of my interest in environmental law and also because it touches not just environmental law, but because it also touches on indigenous peoples and their values and principles. Those who might have seen a few papers that I have written, you'll see a golden thread running through on Ubuntu as ecological rule of law. So that's why I specifically chose that decision. But before we got to it, I want to highlight that as a student, I was always fascinated with the idea of a landmark judgment. A seminal judgment, a watershed judgment. Scholars love to use those big words. But what exactly do they mean that it's a landmark judgment? It's a watershed judgment or it's a seminal judgment? So we will see that today. So this decision is based on the peoples who I will say is contested, but I will say they own this area. The Kahuzi-Biga National Park, the Batwa peoples of the DRC. This is the case on which I want to speak about. And back to the question that I was saying, what exactly do we mean by a landmark judgment? And on what basis do I argue that the Batwa decision is a landmark judgment? Or is a landmark decision? I have specifically chosen it because it comes from an area that is ravaged by conflict, and often we pay very little attention to the environmental considerations going on in there. Everybody's concerned about the mineral. So I want to argue that the Batwa decision is a landmark decision because it achieves 5 issues. First, it displaces the premise that indigenous presence is presumptively harmful. So it basically demolishes the doctrine of fortress conservation. And secondly, this is a landmark decision because it integrates property, resources, development, and the environment. And thirdly, it is a landmark because it reorients epistemic authority towards indigenous ecological knowledge. To my papers, I said I've been writing on Ubuntu as ecological rule of law. So this is where we converge. And fourth, this is a landmark decision because it redesigns remedies as structural governance change. And we'll see as we proceed with this presentation. And lastly, it travels principles for future protected areas. I think future cases are going to go along this route. All right, so I now want to take you to my third slide. And the premise here is that the law has converted a central possession of a particular area into illegality. So this is the history that you see on your screen there. So we know that most of African countries were colonized either by the British, the French, the Belgians, and the Germans and others, although the Germans left a bit early. But what we see with the DRC is that it was mainly occupied by the Belgians. So in 1937, the Belgians decided to create the Mount Kahuzi Reserve. 20 years later, they added the bigger forest to it. It became a bigger reserve. The 1970, the post-colonial, I don't want to say democratic, but the post-colonial government was now in power. What did it do? It established the Kahuzi Biga National Park, and it specifically prohibited human presence there. 1975, it expanded the park more than tenfold. This is where the issue started. But when we read the decision of the African Commission, we see that the Batwa recognized themselves as the original inhabitants of the Kahuzi Biga forest. Their neighbors recognized them as such. So if the government engages in forest conservation and say they must move, what does that say about the connection to their ancestral land? What does it say to their connection to nature in that particular area? This is what I want us to interrogate a little bit. So what we see with this judgment is actually instead of the DRC government actually ensuring that the people of the DRC live in harmony with nature, it actually separated them. Because the idea of forest conservation says the people and nature are separate. You cannot have them in the same environment. This is where the problem begins. So that area no longer becomes a central land. Instead, it becomes an empty wilderness for conservation reasons. And of course, we know there is a protected gorilla in that area, which is fine. But what the African Commission rejected was the idea that you can conserve a particular area by displacing the original inhabitants of that particular area. I have written before when I was writing on climate change, and I argued that when it comes to climate change mitigation and adaptation, you cannot exclude indigenous knowledge. What is the reason? Because indigenous peoples across the world have not been known to actually cause climate change or engage in activities that accelerate climate change. Instead, they've always been known for good conservation. Therefore, you cannot say you are conserving an environment or you are mitigating climate change by displacing the indigenous peoples in a particular area. It is a self-defeating exercise, I want to argue. So, before I move on to the last slide, I just want to emphasize, because this is important for the part when I discuss the remedies. What did the African Commission say? It says that when the government came after the post-colonial era, it passed legislation that actually say if any indigenous person there, basically the Batwa people, if ever they were seen in the park, they would be trespassing. So it actually displaced the indigenous peoples in the name of conservation. It framed them as an enemy of conservation. I think that was a wrong way to proceed. And they were never given the opportunity to give their free, prior, and informed consent. They were just driven out through legislation. So what we see is legislation being used as a barrel through which you can actually drive people out of their indigenous land. All right, so let's move on to the next argument. And here I want to show that the African Commission actually made the right decision because it began to recognize the Batwa as a collective legal subject in their own right. And this is important for the remedies that the African Commission then issued. So how did it do it? It first started by recognizing and accepting that the Batwa people actually occupied and used that specific territory from time immemorial. It recognized that they've got a distinctive culture and that they self-identify as the Batwa and that they are recognized as well by other people as the Batwa and the original inhabitants of that area. And that they've got a history of marginalization, discrimination, and dispossession of that particular land. How did it do it? It traced the legislative development from 1937 up to 1975. So this is where the African Commission comes and say, this is a marginalized group that has been dispossessed, that has been discriminated and driven out of their area. So having recognized that, what did the African Commission do? It came to the conclusion that you cannot decide the fate of the Batwa people without actually engaging the rights that you see in the African Charter, and that you cannot effectively do it by treating those rights as separate silos. You need to read them together. So what we see there is that the right to property, which you see in Article 14 of the African Charter, cannot be read separate from the right to an environment that should be protected. And this is important for the broader jurisprudence that this case actually engages. But the African Commission comes to a very important conclusion. It says that the Kahuzi Biga forest was more than territory in the DRC. It actually served 4 distinct roles for the Batwa people. First, it was their home. It was their land. It was their livelihood. Secondly, it was a pharmacy for them, in the sense that it provided them with the medicinal plants on which they used to treat themselves and also for their healthcare practices. Secondly, it was a school where they could engage in initiation and knowledge transmission. And then lastly, it was a sanctuary for them. They could perform their rituals there. It was their ancestral land. So it was not just a people refusing to be evicted from a forest. It was a people reasserting their sovereignty and ownership of that land. Now, then the question is, does this decision stand alone? Is it a landmark because it is the first decision? I want to argue that it is not the first decision and that it should not be treated as a first decision. Why? Because it stands on the shoulders of other jurisprudential giants. The first one being what Michael spoke about, the Serac judgment. And then we see the Endorse judgment as well. And then Anthony, I think, spoke about the Okiek judgment. Now, then on top, we have the new one, the Batwa decision. Its inflection point is that it frames exclusion, conservation itself, as a rights problem. You cannot conserve the environment by excluding the people of that particular area. So what remedies then did the African Commission make? I see I'm running out of time, so I'm just going to skim through them. You see them on your screen there that there are 4 specific categories of remedies that the African Commission had handed out in this particular judgment. Actually, if you read the decision, the remedies aspects is actually expansive. It's very long. It spans several paragraphs with very detailed orders on what needs to be done. Of course, we may debate that it was a request to the DRC government. Well, that is part of how the Commission's decisions are framed, but this is what it did. So you also see that in as much as this was a seminal judgment, a landmark judgment, there are several risks to it. And one of those is that it will be harder to implement it for obvious reasons. It will rely on state action for it to be actually implemented. Now I'm just flying over, but I would have wanted to speak more about custodianship as environmental reason in this particular decision. But thank you so much, everybody, for listening to my presentation. I hope you bring me comments on that paper that I've submitted. Thank you.
All right, thank you so much, Felix. And in that same line, with regards to environmental protection and environmental accountability, our next speaker, Felicia Bosor, will then come up. Thank you.
Okay, great. Good evening, everyone. So hopefully in the next 15 minutes, I'll attempt to walk you through the case of Lido versus Cote d'Ivoire, also known as the Trafigura case. And this is my topic: corporate environmental accountability and the right to a healthy environment. The African Court's Trafigura judgment as a milestone for justice. So this Trafigura case sits at the meeting points of three areas of law. That is the human rights, the environmental law, and the law of business. So basically, this is a roadmap. So we'll start with why this case is a first for Africa. Then we talk about the facts of the case. We delve into the law that the court used in resolving the case. We'll make mention of Articles 4, 16, and 24 of the African Charter. They will make mention of the MOU that was signed between Cote d'Ivoire and Trafigura Group. Then we talk about the 2 new rules on access of justice, the 6 reparations that the courts gave, and any other implications that other African countries can learn from this case. So why does this case matter? So it matters because it's the first time the African court ruled on the state's duty over corporate harm to the environment. It's also the first time the court used the UN guiding principles, building upon the case of CIRAG versus Nigeria, as was spoken about in the morning. However, this case extends its declaratory findings to a binding judgment where real remedies were ordered. So let's attempt to summarize the facts of the case. So in August 2006, the Probo Kuala, that is a vessel chartered by the Trafigura Group, arrived in Abidjan carrying coca naphtha washings, and these washings were considered or classified as hazardous substances under the Global Basel Convention and the Bamako Convention. So Trafigura Group contacted a local company called the Tommy Limited, and they instructed Tommy Limited to dispose of these waste. However, what happened cannot be classified as disposal. It was basically dumping because roughly 528 meter cubes of these toxic waste were discharged at 18 separate points across Abidjan. And the result was immediate. 17 people died, over 100,000 people suffered medical conditions. So in 2007, February, the Trafigura Group entered into an MOU with the Ivorian state, where the Trafigura Group paid the state 198 million US. And though from the face of this MOU, it looks like it was an accountability, when we look inside the MOU, we get to see that there was an immunity clause which prevented or shielded this Trafigura company from further or civil criminal proceedings. So it went to court, obviously, and in as much as domestic proceedings didn't do much, the Tommy Limited and some port officials were arrested. So in 2016, the Lido Group and others filed an application before the African Court, and in 2023, the African Court delivered its judgment on the state's obligation. But here's the heart of the problem. So the state took money for its people. It took 198 million US dollars. However, it also signed away the rights of these people to sue. And that's what the whole tension of this case is about. So let's turn and look at the legal architecture, what the courts use in resolving the matter. So the court didn't just rely on a single instrument. It's constructed what I call legal architecture. So it used 5 articles from the African Charter, that's Article 4, 7, 9, 16, and 24, and also relied on 3 other tools, that's the Bamako Convention, the Maputo Convention, and the United Nations Guiding Principle. First pillar, which states that states has a duty to protect its people from corporate-related human rights abuse. So we can tell that states have a duty or a positive duty to protect its people from harm caused by others, including private corporations, especially when this harm is foreseeable and preventable. So on Article 4, the court found that Cote d'Ivoire failed to regulate its hazardous waste import, as well as it failed to monitor its operations, its port operations. So it fails to monitor the Tommy Limited operations. So the state sought to argue that the harm or the severity of the harm caused was unforeseeable, but the court rejected this argument on the basis that the port authorities were well aware of the waste and they knew the extent of the damage. However, there were just no adequate legal framework which existed to manage this known risk. On Article 16, the court accepted the medical evidence of these harms suffered by the communities, and it indicated that the state has a positive duty to put measures in place to protect health, and which includes the obligation to maintain a framework consistent with its own treaty commitments under the Bamako Import Prohibition. So on Article 24, the right to a healthy development. So in this matter, we come to realize that Article 24 of the Africa Charter, that's something that not every environmental provision does, because it sought to frame this healthy environment not only as an individual right, but as a people's right, as a collective right. So basically, it just means that the harm is not only measured by individual medical bills, but also as a disruption of a whole community's economic life and their capacity to develop as a collective. And the court made it clear or concrete in 2 moves. First, it used Article 24's language, that is general satisfactory environment favorable to their development. And it linked this to Article 22 on the right to development. So basically, in plain terms, the dumping did just not make people sick. It damaged the whole developmental trajectory of the entire community, their livelihood and the long-term capacity to live. And also, it also linked the Article 24 to the UN 2022 UN resolution on the right to clean environment. So in doing so, it treated this 40 years old provision, putting it in the global context. So the court also went further and specified what positive obligation Article 24 requires. So the first one is to build proper rules for these hazardous waste, to monitor and enforce these rules, carry out environmental checks and act on them, and to clean up harm when it happens. So let's turn to picture this. So we lose someone in these dumping that happen, and you go and look for justice, only to find out that your own government has signed out your rights to the company. So you can't find justice anywhere. And that's what the immunity clause in the MOU did. So the court's holding was very clear. It stated that a state cannot extinguish a victim's right to remedy by entering into a private agreement or settlement with a corporation. And the state characterized this action as a state-facilitated denial of the right to remedy as enshrined in Article 7 of the African Charter. Also, they found that the state's failure to communicate or promptly disclose the harm and environmental risk data, and the non-disclosure of this immunity clause to its people was a clear violation of Article 9 of the African Charter. So the two new rules that came into place that opened the door for people to be able to bring their matter before the court. And the first is, historically, NGOs normally have to take individual power of attorneys from victims before they can present their matter before the human rights bodies or before the court. However, this court reasoned that Article 24 placed it in a collective character such that it's incompatible with individual mandates. So from this case on, for like going forward, there was no need to collect an individual power of attorney from each affected victim. So any NGO with African Commission observer status can bring an environmental claim directly. Also, under 56(5) of the Charter, normally it requires the exhaustion of domestic remedies before applying to the court. However, this case made it clear that where the domestic court is maybe characterized by bias, delay, or evidentiary constraints, then victims can come straight to the African courts. So then the courts went ahead to answer the question every victim was looking for and ordered 6 categories of reliefs. The first is the Victim Compensation Fund, where it was financed by the original MOU of $198 million, as mentioned earlier. The second was independent investigation. So there was an investigation into all the parties involved, including the Traffigira and all its affiliates. The second was the legislative reform, where a specific Ivorian law prohibits these hazardous waste imports, the Ports Oversight Reform, capacity building, that training environmental health and port authorities, and annual public reporting. So there was supposed to be an annual public reporting on the fund disbursement and its implementation progress. So we can tell that the courts did not simply compensate these individuals for the harm directly suffered, but it also sought to rebuild the regulatory infrastructure that failed to prevent this harm. So what does it mean for the rest of African states? So for African regulators, we have to be mindful of whatever we sign. We have to be mindful of any MOUs or any agreements we signed with other corporate bodies, and we have to look for any immunity clause, just like what happened in the case I just mentioned, so we don't find ourselves in their shoes. Also for Kenya, for example, they have Article 42, which contains the right to clean and healthy environment. So it's my suggestion that in as much as they have such a law, they can extend it to livelihood and community development of pollution harm, and not only medical ones. So in Nigeria, we get to see that Nigeria signs a lot of MOUs with oil companies and multinational companies. And when we look closely, we tend to find out that they have these provisions on immunity clause that they fail to take notice of. Also, for South Africa, they have the Climate Change Act and the National Environmental Management Act. And we can tell that this is like something in the right direction or the right path. So for the AU too, I also recommend that we can rely on this case to build like a binding law on business and human rights, rather than it being a case-to-case basis. So basically, to conclude, this case is a milestone and not an endpoint, because basically it's the first African binding judgment integrating the United Nations guiding principles pillar 1 with Article 24 collective development rights, and also opened the courtroom door wide. And it chose not to just pay the individuals, it chose to fix the system and not just pay the individuals. However, in all my discussions, we can see that the court never mentioned or never dealt with Traffigira as a company on its own. It only dealt with just the state. Thank you.
Thank you so much, Felicia. Thank you for that very insightful presentation. Our next speaker is Joshua Fwamba, who will be speaking to us about children's rights.
In the meantime, as he's working on the PowerPoint presentation, okay, thank you. So, Joshua Kipyogo Fwamba. I'm to present on a Nubian children's case. Coincidentally, I happen to be the youngest in the room, so yeah. So my presentation is focused on the Nubian children's case, which was filed before the African Committee of Experts on the Rights and Welfare of the Child against my government. Am I audible? Yeah. So before we delve into the matters in assessing why this decision is landmark, I think I will have to assess the historical analysis of the case, because normally judgments are not made in a vacuum. For you to understand or to properly synthesize a judgment, you need to look at the historical and the social foundations of a judgment. So my flow of the work it will start with the case brief, the history of the case, as I've stated. I'll then delve into the conceptual framework in outlining from my opinion what I understand by a landmark judgment. Then I'll proceed to the first element, the second element, and provide a conclusion. So who are the Nubians in Kenya? So the Nubians initially or historically, they were citizens of Sudan. They lived in the Nuba Mountains, and they were taken up by the British, the colonial government, who took them as military personnel. At that time, we had the East African Protectorate and the Ghanaian Protectorate. So they went to the Ghanaian Protectorate, and afterwards they were transferred to the Kenyan Protectorate. Upon being transferred to the Kenyan Protectorate, they lived there, and on aging, because if you age, you can no longer now work as a military personnel. On aging, they opted to live in Kenya, and they were allocated land. The allocation of the land was that it was discretionary. The state allocated them land without prima facie giving them title to the land. So when the independent government left over and it took over, it presumed these Nubians as foreigners who were living on government land, because as I've given you the history, they came from Sudan initially. And it is out of that the context of statelessness accrues from. In that, they were considered foreigners living in Kenya. And for you in Kenya, for you to be, and I believe this is a position in most of the states, for you to prove nationality, for Kenya, you have to attain the age of 18 years and you're given a national identity card. So for the case of the Nubians, it was when you're born, first, you'll be given the birth certificate, yes. But on attaining 18 years, when you apply for the national identity card, you'll have to go through an extra vetting process, which is not synonymous to what us other native Kenyans go through. In that the committee will have to vet you, the committee will have to look into your parentage linkage. It will have to identify your ancestral linkage to Kenya. And as I've stated, all these eventually pointed out to the Nubians coming from Sudan. because initially that was where their ancestors came from. So the state will ordinarily come to a conclusion that these are not Kenyans, despite the fact of them living in Kenya, because they lived in Kenya since the pre-independence time. And they were denied the nationality because they were denied the identity cards. So it is out of this that first they went to the High Court, they filed a constitutional petition, but the petition was not determined. It was held by procedural technicalities, was placed before the CJ. The CJ did not empanel a bench, and it took almost 6 years without hearing the decision. Then out of this, the Open Society Justice Initiative and the Institute for Human Rights and Development in Africa now made the communication before the African Committee of Experts. So the complaint was based on the violation of Article 6, 2, 3, and 4 of the African Charter on the Rights and Welfare of the Child, which specifically states that children have a right to be registered upon being born, and Article 6.3, which states that children have a right to acquire nationality. Emphasis on the acquiring nationality, because this will be my next argument. And then they said that as a result of them being denied the nationality, then there arose other consequential violations, like their right to health and right to education. Because as you understand, maybe for the right to education, in Kenya, we have the government loans for students maybe pursuing the higher education. And for you to apply for such loans, you need an identity card. But this identity card is what the Nubians are being denied for. So you cannot apply for such loans. So you're being denied the right to education. Then additionally, on the lands that they were living, it was analyzed from the facts of the case, that place did not have sufficient schools and sufficient hospitals. Then the argument that the complainant stated, it's that this was not, it was not coincidental. It was an intentional act of the government, in that the government was not providing, intentionally providing for the schools, funding the schools in areas like Kibra and hospitals, because it considered these people as aliens. It did not consider them as native Kenyans. So it is out of that that they claimed the consequential violations on Article 11 on the right to education and Article 14 on the right to health. So I'm going next to why the elements that I should consider in making this decision landmark. But I think before we proceed, during the presentation, pending the day, I got an insight from Mr. Tarisai, who said that what, from whose perspective, is a judgment a landmark. And I think this kind of changes my whole perspective of what I had prepared, but I'll try to align it into it in that in this decision, if you view it, because it was a compliance judgment. So I'll first pose a question of, from whose perspective should I consider this judgment a landmark? The first person that I should consider is the victims, in this case, the Nubians, whose rights to nationality have been violated. Then the second, it's the Nubians who will be born after that judgment, because now a judgment should be forward-looking. It should make sure that no other Nubians will be born after this, should be stateless. Then for the second people that I should consider, it is what he said to us scholars. Okay, I don't know if I can be regarded as a scholar right now, but in future, or to you scholars. So those are the people whom we should consider, in that when making a presentation or when making a case before an adjudicator, it is you scholars who will look at how it was interpreted and whether that interpretation now fully suits your case. So my first, in this case, the doctrinal significance and impact will now answer the question for you scholars and the litigators. Then for the second element, which now will be more critical in looking at the effect and the systemic or wider symbolic, it will be on the victims, the Nubians themselves, and other children who are stateless in other countries. So I will start with you scholars. So on the doctrine, significance and impact, the first move that the committee did, the committee interpreted Article 6. As I stated, if you remember, I told you to mark the word acquire. Article 6.3 of the Charter states that children have a right to acquire nationality. So the committee stated that a plain reading of this provision does not specifically state when this child acquires nationality. it leaves it's subjective, it leaves this to the discretion of the adjudicative body to decide. But in this case, the committee chose a purposive interpretation of Article 6.3, in that it looked at the provisions of Article 4 on the best interest of the child. It also looked at other provisions, such as the International Covenant on the rights of the child, and stated that the purpose of Article 6, or why Article 6 is there, it was to prevent statelessness. And when you say preventing statelessness, we cannot leave the discretion to grant someone nationality to the state. This discretion comes with a limitation. And it is out of that it interpreted the right to acquire nationality under 6.3 to mean right to acquire nationality from birth. In that children being born in Kenya of Nubian descent, upon them being born, then they acquire Kenyan nationality. It should not wait until they turn the age of 18 to acquire nationality. So that is where the purposive interpretation comes in. The second element for the transformative judgment, again for scholars, it is how it incorporated the best interest principle. It looked at the best interest principle as a tripartite transformation. Even though a caveat in this, it's that it didn't explicitly or expressly mention this. This had to be carved out from its paragraph and now look at behind the meaning, reading between the lines and at what it meant. In relation to this, I looked at the UN Committee on the Rights of the Child, General Comment number 14. It provides that there is a tripartite threshold of the best interest of the child. In the first one, it's that it's a substantive right, a right on its own, a right that can be implemented by itself, in that it's capable of being violated and you can go to court. It is justiciable. Yeah, maybe that's the word that is used by you scholars. The second, or if you're not a scholar, just consider yourself as one. Thank you. The second one is the interpretative principle, in that it used the best interest of the child to consider it interpreting the principles. As I stated, Article 6.3 had a discretion of being interpreted maybe as leaving discretion of granting nationality to the state, or then limiting the powers of the state to grant nationality to people being born in that country. So it took the position that mostly limits the discretion of the state and widens the rights of the child, in that they acquire the nationality from birth. Then the third one is as the procedural rule. As I stated initially, they had started this case before the High Court in Kenya. And there is this principle of complementarity that I think Mr. Tele raised, of whether decisions can be enforced locally and whether they should be taken to these regional adjudicative bodies. So in this, Nubians had first tried to exhaust the local remedies in Kenya, but then the decision had not been heard for 6 years. Like, it was just in court. So the court stated, even though we understand we should exhaust local remedies, but surely it has taken 6 years for remedies to be granted, for this case to be heard. So when you look at this, and it used a word there that a year is 6% of a child's time, or in a child's time, and give it a right injury, in that if these children's rights have been violated all along, so what about in the 6 years that this case has been pending in court? So it used that as a procedure to state that the delay in the exhaustion, the delay is an exception in the exhaustion of local remedies. And then it declared the communication as admissible. The third move, again, for you scholars, the child as a being and not a becoming. So this one, it's stated, which is again interlinked to Article 6.3. Kenya did not participate in this decision, but Kenya's position on giving people nationality upon attaining the age of 18, it's that it looks at the process of being a child as a step of becoming an adult, in that there are certain rights, such as rights to nationality, which are not enjoyed by children, but they'll be enjoyed by that child when they attain adulthood. So it's like this right has not yet matured. So if you're a child, you're in the process of attaining this right. So it's stated that the child is a being. The child is a human being and not a becoming. So that right is to be realized immediately, not for the future, but not like future Africa, not. Okay, then there's the nationality as the right to have rights. This one I removed it from the Hannah Arendt's framework on the right to have rights, how it interlinks the nationality to the right to health and right to education, and also right to movement. And this is a whole context in the indivisibility of rights, in that human rights are interlinked. So if you violate one right, it creates the violation of another right. So let me move to the victims. So don't be jealous when I address the victims who are not here. So for this, there's this question that has been posed in the earlier discussion about implementation. One thing I realized about the decisions by the African Committee of Experts of Children is that it follows up on its decision. So I think the African Commission can borrow from this, because of the decisions that have been made by the committee. Most of them, they have a rule of procedure to make sure that there's a follow-up mechanism on implementation. And that's another element that makes this decision landmark, because most of the decisions, they don't have the implementation. And it comes to my question, the point that I had made, what makes a compliance judgment landmark? In that, in making its remedies, it said that the committee adopted a follow-up mechanism by way of a structural remedy and required the state to report within 6 weeks. And it appointed one of the members to follow up on that decision. And true to its word, in 2013, 3 committee members were appointed. They were told, go to Kenya, talk to the relevant stakeholders, ask them, has our decision been implemented? What is the position? So when I was reading this, I was like, in Kenya, there's this phrasing of mambo kwa ground different, meaning things, okay, not at the flow. Things that, I'm finding it difficult to translate it to English. It means that, okay, law in paper is not law in practice. So a decision can be made at the committee, like by the committee, but that's not what it's felt by the people at the ground. So this is what the committee addressed. It sent these 3 committee members to the ground to see whether the decision has been implemented. And in 2013, there was a follow-up report presented at 21st ordinary session of the committee. Then in 2014, the complainants again did another report. And in May 2017, Kenya, despite not participating in the proceedings before the committee, it filed an implementation report stating that despite you making this decision and we did not participate, but we know it, and there are certain measures which you have done to meet your decision. And it made reference to Kenya's constitutional article 14 of the constitution, which provided for citizenship. It made also reference to the Children's Act, which had been amended, but that was in 2022. In 2018, again, Kenya made another periodic report, the second and third periodic report on the implementation of the African Charter on the rights and welfare of the child. On the effects, whether the Nubians really felt that there's a committee protecting their rights. Kenya in 2019 made an administrative move in that it established a national task force for stateless persons mandated to identify, vet, and propose legal reforms. In 2021, there's a policy change affected by that decision, in that the Nubians did a petition to the parliament stating that this decision was made and told the government to do this, and this, but it hasn't done it. So what should we do? Parliament again made a recommendation based on this to the state. And it also furthered the recommendation by now recommending the Kenya to recognize the Nubians as a minority group. When now they're recognized as a minority group, it brings up other rights that even they weren't entitled, because Kenya's constitution prioritizes minorities. It goes back to the point on substantive equality. So when they'll be recognized as minorities, then it opens up other rights. In 2022, there was the legislative change that I mentioned. The Children Act was amended to now grant nationality from birth expressly. And again, I didn't mention Article 53 that came with the Constitution of 2010, now has or is worded expressly that nationality is granted from birth. Okay. I'm concluding. So there's another policy change. There was the introduction of the digital registration systems by Kenya in 2023. The Nubians again went to court. They told the court the state is implementing a digital registration system that will exclude us, because initially when we had the normal registration system, we already excluded, and it was decided by the committee, we excluded. It told the state to do this and this and this. But now the state is proceeding to introduce a digital registration system that will further exclude us if the earlier violations are not remedied. And the court sided with them and told the government to halt its process of digital registration until it first addresses the recommendations made by the committee. So maybe referencing the Prof's words, as he said, in this case, transformative is looked at as a voyage in that continuum of the journey from the decision being made by the committee to right now, we can see it is bearing fruits from the ground. However, there are regressive measures that the state has also taken. Currently, Kenya still, birth certificate is not an indicative proof of nationality, even despite the government, the constitution stating that nationality should be given at birth, but the state still insists that nationality, but birth certificate is just, we know you are there, but it's not an indicative proof of nationality. You must apply it at attaining the age of 18. And the vetting and the extra vetting and everything, it still persists. This was documented in the decision made in 2023 in the petition. So I think that concludes my presentation. Thank you.
Well done, scholar. Just by the way, the fact that you were the youngest participant here at this panel is in its own landmark. So well done to you. All right, our final presentation is going to be online. It will be done by Ize Chikwere. Oh, here you are. Thank you.
Hi, good morning and good afternoon, everyone. My name is Ezihe Chikwere, but I go by Ezi. And I'm just going to share my screen. Give me one moment. Can everyone see my screen?
Yes, we can see.
Okay. Okay, wonderful, wonderful. Okay. So I mean, I'm mindful that I am the very last presentation of the day, so I will definitely be mindful of time. Today, I will be presenting on the African Court on Human and People's Rights advisory opinion on the compatibility of vagrancy laws with the African Charter and other human rights instruments in Africa. More specifically, the title of the article that I drafted is Vagrancy Laws in the African Union, the African Court on Human and People's Rights Landmark Opinion Exposing the Legacy of Colonialism Embedded in African Legal Systems. So throughout this presentation, I'll start by giving just a brief background on vagrancy laws and the derivation of the advisory opinion, what led to the advisory opinion. So that leads me to my next slide. So this advisory opinion was requested by the Pan-African Lawyers Union in 2018, and they posed 4 questions to the African Court and requested the African Court to draft an advisory opinion regarding these questions. These 4 questions are vagrancy laws compatible with Articles 2, 3, 5, 6, 7, and 12, and 18 of the African Charter? Are vagrancy laws compatible with Articles 2, 4, and 17 of the African Charter on the Rights and Welfare of the Child? Are vagrancy laws compatible with Article 24 of the Protocol to the African Charter and the Women's Rights Protocol? And do states have a positive obligation to repeal and/or amend their vagrancy laws to conform with the African Charter, the Children's Rights Charter, and the Women's Rights Protocol? Okay, so a brief background on vagrancy laws. So vagrancy laws and bylaws are essentially laws that criminalize homelessness, poverty, those who are determined by these laws that have no fixed home, employment, means of subsistence, trade or profession, or being suspected as being a reputed thief, and ultimately orders a person's deportation to another area and allows for arrest without warrant. The issue of vagrancy in Africa that Palu noted is that in 2018, there were 22 states that contained laws such as these. And these laws are overly broad and rooted in colonial ways, and as such, disproportionately affect vulnerable populations. These laws also criminalize a state of being or a social status as opposed to a criminal act. And I just wanted to note that there were, prior to this advisory opinion, there were pronouncements on vagrancy laws, which include the African Commission's principles on decriminalization of petty offenses in Africa, the Model Police Act of the Pan-African Parliament, and ECOWAS Court in the case of Dorothy Injemanze and others versus the Federal Republic of Nigeria. There are other pronouncements, but I just wanted to note these three in particular. Okay, and so as the advisory opinion determined that the codification and implementation of vagrancy laws has perpetuated systemic discrimination across the African Union. This advisory opinion thus constitutes a landmark opinion as it substantially changes the interpretation of existing laws and requires vagrancy laws to be repealed and amended in each of the 18 or more states that criminalize poverty and homelessness. Okay, and just briefly, the court answered the questions that Palu presented. The first question, of course, being, are vagrancy laws compatible with these articles of the African Charter? And ultimately, the court determined that vagrancy laws and bylaws are not compatible with these articles in the African Charter, ultimately stating that criminalizing the status of an individual and enabling the discriminatory treatment of the underprivileged and marginalized is not compatible. Also, the enforcement of vagrancy laws is incompatible to the African Charter because it limits the right to freedom of movement and forced relocation and arbitrary arrests. The court also states that arresting persons under vagrancy laws and soliciting statements about the possibility of them committing a crime does not align with the presumption of innocence and thus is incompatible with Article 7 of the African Charter. And then ultimately, the application of vagrancy laws deprives underprivileged and marginalized individuals of their dignity and unlawfully interferes with their lifestyle choices. The court also answered Palu's question regarding the African Charter on the rights and welfare of the child, ultimately determining that the enforcement of vagrancy laws leading to the arrest and forcible relocation of children violates the Children's Rights Charter. Similarly, that the arrest and detention and forced relocation is not in the best interest of children and thus is incompatible with Article 4 as well. And the court also ruled that arrest, detention, and forcible relocation of children is also incompatible with Article 17 of the Charter. The court also answered the question regarding the Women's Rights Protocol, determining that vagrancy laws permitting the arrest and detention without a warrant of women where they are deemed to have no means of subsistence and cannot give satisfactory account of themselves is incompatible with the Women's Rights Protocol, as the Women's Rights Protocol states that states are to work towards eliminating the discrimination against women, and that women have a right to a healthy environment and sustainable environment, and that states should take the proper measures to ensure greater participation of women in society. And the final question, do states have a positive obligation to repeal and or amend their vagrancy laws? The court determined that states are obligated to, inter alia, amend or repeal their vagrancy laws and bylaws and bring these laws into conformity with the African Charter, the Children's Rights Charter, and the Women's Rights Protocol. Additionally, that states should take necessary legislative and other measures to give full effect to these instruments. Okay, so in this section, I will be discussing what makes this advisory opinion specifically landmark. Within this section, my own analysis that I provided in my paper will be embedded into my presentation along with the determinations of the court. And so in this section, I will be discussing how this advisory opinion is landmark through the fact that it was able to advance legal understanding, has an influence on sociopolitical context, and has an influence on historical context. So let's discuss its advancement of legal understanding. Okay, so the first way in which this advisory opinion is landmark is because it calls attention to the fact that vagrancy laws are overly broad and vague. The court determined that laws must be clear, precise, and understandable. Because vagrancy laws are broad, they undermine ultimately the nature of what laws are intended to do. These vagrancy laws do not provide clear indication of what laws prohibit because of the criminalization of a social status. If laws are to be properly applied, then there must be a clear understanding of the law and how they are to be applied and why they are being applied. Because the court determined that vagrancy laws do not meet the clarity of this criteria, then the advisory opinion calls for them to be repealed and amended. By calling for their appeal and amendment, legal understanding is ultimately advanced because the standard of laws and lawmaking is reinforced to be one that is understood and not up to discretion and interpretation. It also reinforces the need for a presumption of innocence and not the presumption of guilt as given by law enforcement. I state that the advisory opinion also compels states to codify laws that are precise in themselves, and that laws should be rendered to the wills of those who enforce them. But instead, as aforementioned, they should be clear and have a clear legal basis for laws and be commonly understood to all African citizens. By challenging the overall legality of vagrancy laws, this advisory opinion not only reshapes laws, their makers, and their enforcers, but the entire criminal justice systems within Africa, and the way in which everyday citizens understand the purpose of justice systems and the outcomes of these justice systems. Furthermore, as previously mentioned, there have been key African Union bodies that have made pronouncements similar to this advisory opinion of the African Court, determining the discriminatory nature of vagrancy laws. With this advisory opinion, however, the positive obligation of state responsibility to repeal and amend vagrancy laws is strengthened as the court provides a certain level of authority to oversee that states understand that vagrancy laws should not hold legal weight because of their discriminatory nature. Next slide. Okay, so this advisory opinion is also landmark because of its influence on socio-political context. This advisory opinion has an overwhelming moral authority and influence on the entire African society. The court in this advisory opinion pronounced that vagrancy laws target the social and economic status of an individual as opposed to criminalizing an act. Further, it calls into question the way in which societies view criminality and the challenges of the association of criminality and poverty. My article discusses how the advisory opinion brings light to the fact that if vagrancy laws impacted the wealthy and the powerful, then these laws simply would cease to exist. The advisory opinion also determined that vagrancy laws violate Article 18 of the Maputo Protocol, stating that women have the right to a healthy environment, and Articles 3, 4, and 17 of the Children's Rights Charter. As such, the advisory opinion ultimately challenges society's propensity to criminalize second-class citizens, that being women and children. In my article, I also discuss how vagrancies perpetuate intersectionality, as young Black women and girls are disproportionately affected by vagrancy laws. When they are arbitrarily targeted and detained, in turn, the advisory opinion brings to light that homelessness, poverty, and street children, so to speak, is more of a reflection of the condition of the state and the country and the systems within the country, as opposed to the individual. That homelessness and poverty is a responsibility of the state to implement systems to care for these populations as opposed to criminalize these populations. Similarly, within the opinion, AU member state Burkina Faso submitted to the court stating that vagrancy offenses require social responses as opposed to penal responses. This ultimately also shows the overlap in legal understanding, but then also the socio-political context. In my article, I also discuss how this advisory opinion changes societal perceptions of arrests and encourages citizens to even know their rights and note the signs of arbitrary arrest and violations of due process. In doing so, law enforcement is now held to a higher standard that is according to law as opposed to according to their own personal discretion. Lastly, I discussed that the landmarkness of this advisory opinion, it also challenges the words in which vagrancy laws use to define homelessness and the impoverished. For example, having no visible means of support, rogue, vagabond, disorderly. The court determined that language such as this is outdated, discriminatory, dehumanizing, and holds colonial perceptions of individuals. As such, the court determined that words like these deny citizens of their dignity. This advisory opinion challenges the words in which societies associate with poverty and homelessness. And by changing and challenging the language, our perceptions inevitably change as well. Okay. My last point regarding landmarkness is that this advisory opinion has an influence on historical context. In my article, I discuss that if Africa is to rid itself of the remnants of colonialism, then repealing and amending vagrancy laws is a good place to start. The advisory opinion in itself notes that European colonists used vagrancy laws to control Africans. These laws were purposefully broad and vague to criminalize those who did not appear to adhere to colonial rule. For example, the UK Vagrancy Act of 1824 states, every person wandering abroad or placing himself or herself in any public place would be subject to arrest. Such language is actually similarly reflected in Zimbabwe's Vagrancy Act of 1960, which still exists today. This advisory opinion also determined that there are three primary reasons that led to the adoption of vagrancy laws in Africa. The first one being to curtail the mobility of persons and criminalize begging. 2, to reduce the cost of local government care for the poor. And 3, prevent property crimes and provide a wider discretion to law enforcement. By the court making these determinations and reflecting on these reasons, I further discussed in my article that this advisory opinion influences historical context because it reveals the true purpose of vagrancy laws and brings to light the embedded colonialism with them. And by bringing this to light, it should prompt state action to repeal and amend. Okay. So here's the overwhelming impact. Since this advisory opinion, 10 states have repealed and amended their vagrancy laws, one of them including Uganda, and 2 of them including Uganda and Rwanda. As part of my research, I actually interviewed a member of the Pan-Africa Lawyers Union who informed me of this fact. Okay, while I thoroughly enjoyed learning more and conducting research regarding this advisory opinion, it is not lost on me that there are still opportunities for impact. While it is remarkable that 10 states have repealed these laws, it further proves the landmarkness of this advisory opinion, it still remains unclear what other laws create similar restrictions of vagrancy laws and bylaws. As I previously stated, by the advisory opinion calling for states to repeal and amend these laws, it also should be brought to light the fact that there may be other laws that also have remnants of colonialism within them. In addition to this, I do believe that there's an opportunity for model law implementation, specifically as vagrancy laws should have more of a social response as opposed to a penal or criminal response. Systems should be put in place to address issues of homelessness and poverty and discrimination, as opposed to simply repealing and amending laws. Repealing and amending these vagrancy laws is the first step, but it is not the final step. And I do believe that it would have been great for the court to delve more into the specifications of what states should do after they repeal and amend these laws. And that is the end of my presentation. I hope I am within time. Once again, my name is Ezi Hechikwere, and you can call me Ezi, and I look forward to questions and comments.
Wonderful. Thank you, Izzy. Another round of applause to our panelists. As we move on to the Q&A session. So we're going to take a couple of questions. Okay.
I thank the panelists for the wonderful presentations. This question cuts across all the presentations, and it goes to somehow see how we can reinforce the landmarkness of these cases. Concerning the remedies imposed by these human rights bodies on states, how feasible can the African human rights bodies ensure that these remedies are executed at the domestic level? Because that's a major concern. Yes, we have beautiful the decisions by these African human rights bodies, but it becomes a bit tricky when at the end of it all, at the domestic level, nothing concrete is done. So how do we proceed from here? Thank you very much.
Thank you. My name is Giscard Bilingi. I'm from the DRC. I have a question about the Batwa decision. The 2022 African Commission decision require restitution and redress of historical violation about the Batwa people, but in the same years, the DRC adopted the 2022 Indigenous People Act, which in the preamble acknowledge the historical injustice, but don't provide any mechanism for restitution or redress of this past violation. And when you read also the Conservation Act, the 2014 Conservation Act, provide that the right within protected area are generally void and subject only to statutory derogation. And when you read the derogation, there is nothing about indigenous people. Do you think that this legal framework can make the implementation of this landmark impossible? This is my question.
Thank you. Thank you very much. Ezi, I hope you can hear me. Yeah, enjoyed your presentation, and I think I will need to engage with that opinion after. But I'm curious to know, in as far as moving towards, Afrocentric understanding of, all these terminologies. I'm particularly interested in the notion of intersectionality. Whether you think there's room for us to actually use coloniality, the colonial nature of laws as one of the parameters, just as we look at, gender, race, and in the particular context of Africa, where most of the laws, quite a significant number of laws that, are challenged, for example, before the African Commission, the African Court. For example, I'm particularly interested in the ones that affect women, for example, the colonial era definitions of crimes such as rape,
crimes such as adultery, do you think there's room for us to develop an Afrocentric understanding of intersectionality and using the colonial nature of the laws as one of the markers in addition to the other identities?
All right, so it seems like all the panelists have questions to answer. I think we're only going to do one round of questions because of time. So let's start with answering some of the questions. I don't know who wants to go first. Felix, please lead us.
Okay, thank you. So there were two questions that I can directly address. The first question, it dealt with how do we make sure that the decisions and judgments are implemented? And the honest answer is, I also don't know. The reason being there is a convergence of factors that affect the implementation of the judgments and decisions of African human rights bodies. And one of those is the political will in the particular state. And when it comes to the African Commission, we know that it's not a court of law, it's a quasi-judicial body. Its work is mostly to investigate and listen and recommend to the state. That's why if you read the order in the border decision, it's not really an order, it's a request to the DRC government. The African Commission is merely making a request. But I'm glad from hearing the previous speakers that actually the Commission is following up on the implementation of its decision. So I think there is a lot of work that civil society can do. There is a lot that political parties and governments can do to ensure that they implement the decisions of the African Commission. But we know that the issue of sovereignty always remains one of the thorny issues when it comes to these specific decisions. And then the second question that I can address, this one actually, I have no option. It was directly addressed to me at the back. It deals with the various laws being implemented in the DRC and that those laws exclude indigenous peoples, including the Conservation Law of 2022, and also that the other law of 2022 actually does not state out how compensation and remedies must be provided to the Batwa peoples. As I read the order, it's a very expansive order. It contains a very detailed framework in terms of which the DRC government must provide redress, compensation, and in indirect terms, it actually says there should be guarantees of non-repetition of the violence that the Batwa people have faced. So I think there is a long road to go if there is will in the DRC. But what I'm happy with is that we already see the state moving, albeit slowly, but implementing legislation that is actually requested rather, by the African Commission, because they are not implementing those laws in a vacuum. They are actually responding to that request by the African Commission. But we know how states will do. They will always find a way to partially comply, to create any impression that they are complying. But I also want to be honest with you. I have read part of the judgment, the decision and the order that might make implementation impossible. If you read paragraph 233 of the decision, it actually says something very interesting in one of the items there. It says that within 6 months of the communication of the decision, the DRC government must remove a non-Batwa people from the Batwa Central lands. And my question is, how are you going to do it? How are you going to do it? People are not going to move voluntarily. Are you going to drive them out? And of course, we don't want a violent situation that is staged in the name of redressing for the Batwa people, because you cannot provide redress for one by violating another. And also, I ask myself, what does it mean for integrated nationhood? That you can remove a specific people from a specific area in order to provide redress for other peoples? That's another question that I have. So at the end of the day, implementation is difficult, but I think the border decision also makes it difficult. But maybe lastly, we can say the decision is landmark. in that it provides a rather very robust and perhaps aggressive way to restore a central lands to the rightful owners by saying that non-importer people must be removed from that land. Thank you.
So I think I align with Felix's first answer because I'm also of the view that the African courts can't basically force anyone to obey because this same African Union is made up of the governments that are the same rule breakers. So what are they really going to do themselves? However, I also think that maybe they can be like public hearings to question these countries that have failed to implement, and probably that will cause a form of maybe embarrassment that will make them tend to comply. Who knows? Thank you.
Thank you. So for the question of implementation, first for the decision that was presenting on, it was implemented, and it is actually in implementation for the other aspects that have not been implemented. So I'd first use it, and I'll use that now landmark element now to answer first your question, that future decisions by maybe the committee or the commission can end up maybe by appointing one of the members of the committee to follow up on that decision. And that follow-up procedure can also include country visits. Like for the instant decision, it included a country visit where the 3 committee members actually visited Kenya, and they went and consulted the actual stakeholders. They went and talked to the Kenya National Human Rights Commission. They went to the AG's office, to the relevant stakeholders to see the status of that implementation. So I think if that procedure is also adopted in other measures, that can be a step in the right direction. And that is actually coded in the rules of procedure of the African Committee. So every of its decision is always rendered with a recommendation for the state to report within 6 months, and also there is an appointment of the relevant committee members to follow up on that decision. That is law according to the committee. Then there is, from a paper I had read when preparing for this presentation, they were talking about how such decisions can be implemented. And there are a couple of them. First, the implementation hearing, which had been discussed by, I think, Mr. Terisai and earlier presenters, that I need not to repeat. So there can be implementation hearings. 2, there is a point again that I suggested to the earlier presenter on reporting to AU political organs. It has been argued initially by, again, scholars that implementation of such decisions, especially the decisions made by regional adjudicative bodies, require political goodwill for them to be implemented, which is actually true because these decisions touch maybe on sovereignty of other countries and everything. So sovereignty is more of a political question because you cannot just wake up and start to bulldoze a country to implement your decision. So there has been a mechanism which has been adopted by the committee, again, for Committee of Experts on the Rights and Welfare of the Child, in that it tables its report before the AU Executive Council. The AU Executive Council, as you know it, is a political wing of the African Union. What the AU Executive Council does, it approaches now the state. It tells the state, in this report from the committee, which is an adjudicative body, you are required to do this, this, and this, but you haven't done it. What are you planning to do? So, as I said, this provides a link between the adjudicative body, whose powers are limited to deciding the decision, not to the politicization of that decision, because now a political wing is being given that report to now check on its implementation. And what I'm telling you is not moot. It has been decided before, because in this paper, there was, during the 27th ordinary session, the AU Executive Council made reference to the Taliban decision and actually advised Senegal to implement the Taliban decision in line with the African Committee decision that had been stated before. It also went ahead to advise the Peace and Security Council to take into account the rights of the child and also cooperate with the decision that had been presented before the Northern Uganda decision that was decided by the African Committee of Experts. So I think this can be also a step in the right direction, even though there may arise questions about the politicization of such decisions, which again is subject to research by you scholars. Maybe my last recommendation, again, it is stepping away from the traditional rhetoric that decisions made before the court and on the court making a decision. As Mr. Terisai said, domestically we believe that court's jurisdiction ends upon the final determination of a case. We can move from that rhetoric and from that traditional relic that we had to now have these follow-up mechanisms and implementation mechanisms in that now states report back and so that they can, it's like a continuum in seeing how the decision has been implemented. Thank you.
Izzy, you can answer your question.
Okay. Did you want me to answer both questions or the question that was directed towards me? I know we're on a time limit.
I think the one that was given towards you.
Okay, sounds good. Yeah, so to answer your question, and thank you so much, because that is a very good and critical question, and even one that, you know, I considered when throughout my research. I do believe that there's absolutely room for Africanness and an Afrocentric perspective, especially when considering intersectionality. The premise of the African Union and these mechanisms that followed was to rid the continent of colonial remnants of colonialism. And so in doing so, in order for these mechanisms to continue to exist, they must continue to rid themselves of the colonialism that is embedded in things and in aspects and laws and society that we don't even fully see or understand because it has been so normalized. In regard to specifically intersectionality, when I was discussing how vagrancy laws disproportionately affect second-class citizens, and that being women and children, if I don't discuss race, class, gender, then inevitably they fall through the cracks as well. So intersectionality must be included when we view these mechanisms with a critical lens of colonialism. In addressing those colonial roots. If we fail to address how gender, race overlap in one of the most diverse continents, then we fail as well. There was another point that you made that I wanted to address. So essentially, in order to properly engage with these mechanisms and properly engage with that African charter, we must also look at it through a critical lens of what is missing and who is missing in our society from even these mechanisms, which is where intersectionality comes into play. Because I didn't even get the chance to discuss LGBTQ populations who are disproportionately arrested due to vagrancy laws, because of law enforcement perception of criminality, but even societal perception of criminality. Yes, and I'll leave it there.
Thank you so much. Another round of applause to our panelists. Thank you so much. This does bring us to the end of today's session, and thank you to all of you for sticking with us till almost 6 o'clock. I'm going to hand over to Prof. France, who's going to give us a few extra details. Thank you.
Thank you very much, panel. Ezie, nice to see you online, and thank you very much for your presentation. We will chat.
Likewise, thank you.
Thank you everyone online in particular for your presence up to this point. We are unfortunately going to depart for our dinner now, and we regret your absence in our midst. But for those of us here, unfortunately, as indicated, we only have a limited capacity to support some of us. So those of you, the presenters and the chairs who will be going to the dinner, this is now just 10 to 6. We are expected there at 6:30. If you go by your own transport, you'll find us at Cream Restaurant. But for those who are here, maybe you have a few minutes just to go and drop your bags and do whatever you need to do. But it's not a fancy event, right? You can come as you are. And then we meet here, just where the gate is, just on this side here, as you enter to Future Africa at 6:15. So that gives you 25 minutes to do whatever needs to be done. Is that in order? Is that good? Thank you very much. See you just now. And for the others who unfortunately will not join us, we really look forward to seeing you again tomorrow. And I think this day was very exciting, very stimulating, we'd all agree. And I remind also that after our last session on landmarks, we will go into the rewriting tomorrow, and then we'll have a concluding round table to try to wrap it all up. So good night to everyone, and look forward to seeing